would have know that there's money on the head of whoever did that, it interweaves into the retaliatory nature of what's going on at that place and time between the two groups. So the state feels that this topic, because Zachary's right there when the phone call's made, it's not as much about what the individual who made the call, if they, what they meant, if they actually had $10,000 on someone's head, but the fact that that's made gives credence to the retaliatory nature, and also their knowledge that obviously putting money on someone's head is a thinly veiled threat of violence to action that. So that's why the state feels Zachary hearing that call is relevant.
Okay. Any argument? Mr. Short.
It seems to me that first, good morning, Judge.
Good morning.
This all seems to tie in with what we previously discussed. My issue isn't so much about the call and the contents of the call and Woody having money put on his head. My issue comes in when my client is somehow, this is attributed to my client.
All
So I don't believe it can be attributed to my client. In and of itself, I don't have a problem with it. It's
Okay.
when they try to link it. So I guess that's my answer.
Okay. And, I think that just as I put parameters on the last item that we took up yesterday evening, I think the same parameters are on this one, unless you can establish that Mr. Stillwell is there when they return and hears this, then this would go only to Mr. Copeland's knowledge.
Yes, Your Honor.
Okay.
When you say, did you mean, Your Honor, Mr. Zachary's knowledge? Or I didn't quite understand.
Mr. Zachary and Mr. Copeland. I mean,
Okay.
they're both present for it, but the point being not Mr. Stillwell.
Okay.
So yes.
Your Honor, number 23 is also on the same topic.
Okay.
And so Mr. Shard had objected to hearsay about who shot up Mr. Bennett's mother's home. This portion, the question that Detective Dennis, from listening to the time hack, says is, what kind of gun do you think Shannon had on him? And then Zachary says, I don't know. They had an AK and another 223.
Okay.
223s and an AK. There's not much more other than kind of the portions we have discussed.
Uh-huh.
It's not like Mr. Zachary goes into much additional detail about that night at the home of Big Boo when Mr. Copeland and then leave and come back and here's the phone call. My reading of it or listening to Detective Dennis and Zachary's conversation is Zachary stating, he's saying this by my listening and reading, that he's like, they had an AK and 223s. He's saying, because he's not in the car, he doesn't know, because he makes a comment shortly thereafter where he's like, I don't know how many guns they had in the car. But to me,
When they got in the car, yeah.
yes, Your Honor.
So yes, to me as well, that sounds like at the point in time when they all leave out, which seems to include Mr. Stillwell, here's what they had on them in the way of guns.
And Your Honor, here's my concern, and I get that this session, this interview, the police are just trying to get Mr. Zachary to dump knowledge or dump information on them and just get as much information as possible. I get that. Obviously, the detective's job is a little different than an attorney's job. I don't know, as I sit here right now, what Mr. Zachary is basing any of this on. Does he know, for instance, is he saying he saw my client go into a car holding a 223? Or is he saying, well, I just know Shannon to carry a 223? See, and those are the type of things, if I was prepping a witness, I would clarify. I think we need to clarify exactly what he means, because if he just knows my client to carry a 223, if that's what he's saying, then that is something very different than seeing my client get
Yeah.
into a car with Woody with a 223.
Agreed. So on page 113, lines 11 and 12, there's some unintelligible. Do we know what that
I don't
actually
have,
said, or can we listen to that? Because that may shed some light on it.
I believe my review of this, it was unintelligible to me. I don't know if it, other
Okay.
people may find it intelligible. But
Okay.
I don't have anything written there.
Well, maybe if we just listen to this part of it.
Yes, Your Honor. Your Honor, I will pull up, we will pull up that video to play it.
Okay,
It may take.
sure. So we can move on and come back when it's queued up.
Yes, Your Honor.
All right, so the next item is on page 122.
And Your Honor, this portion is regarding, they're asking Zachary about what Birdman knew about the shooting of the Little Wayne tour bus, and they also asking questions about the murder of Donovan Thomas.
Uh-huh.
And so this kind of falls in the category of the state. If we discuss this topic or ask Mr. Zachary questions while he's on the stand, we would lay out an either meet foundation or not meet foundation for, how does he know Birdman? Has he been around him? Like the foundation for this, because it's not clear from just this interview how he's forming this opinion about Birdman's beliefs on or feelings towards these events. And so this is one that I still think it's fruitful to do what we're doing and going ahead of time, but some of it is contingent on Mr. Zachary's
Okay.
on the stand questions.
Your Honor, for instance, just to let you know what the unintelligible is, on 122 line 12, Mr. Zachary says, nah, Birdman, they asked, did he order that murder? Talking about Birdman, Mr. Brian Williams. Nah, Birdman, like he mad at, when he thought Thug had something to do with the tour bus, he mad at him. Like, I don't know how Mr. Zachary can convey Mr. Williams, not Jeffrey Williams, Brian Williams' thoughts
Knowledge.
about, well, not even knowledge, is speculation, what his feelings are about an event that neither of them were present for. That just strikes me as a whole lot of speculation on Zachary is speculating about what Brian Williams is speculating about. And I just can't see a world where that would be coming in.
Okay, well, I think that Mr. Atkins is essentially conceding that unless the state is able to establish a foundation for how Zachary can testify to what Birdman is feeling, that they wouldn't be able to use this. Right?
Correct, Your Honor.
Okay.
Your Honor,
Yes, sir.
the state of Georgia had Mr. Brian Williams on their short list. They did not call him. Same with Rich Homie Kwan or Mr. Lamar. I specifically asked the very first witness in the case. He testified several times. I can't remember his name. Belknap, Belknap. He's with City of Atlanta Police Department. Whether he is alleging that Mr. Brian Williams was part of any type of conspiracy, any type of gang. And he said, no, it's entertainment for show. He has no information. He was not making that claim. So it's total hearsay. There's no co-conspirator link. This would be just, I heard him say something or I didn't hear him say something. So I would object on that basis.
Okay.
Besides, reading someone's mind and what your court said.
Okay, well.
I'd like to cross-examine Mr. Brian Williams.
What he's saying is, no, I don't think he had anything to do with it anyway, but.
Your Honor, if I thought Detective Belknap had discussed some of that Mr. Birdman was a blood, but we're not saying this is a co-conspirator statement
Right.
for one, and who the state calls or doesn't call is irrelevant to the evidentiary considerations for today. Is
Sure.
the state's position.
I mean, I agree.
I disagree because being a blood, quote unquote, I'm not saying that the gentleman is, I'm not trying to tarnish him or maybe say something accurately, but that's come out in this trial. That's not illegal.
Agreed.
Okay.
Agreed. Just think as to this issue, if and when it potentially arises at trial, we take it up then. But at this point, the state understands that they don't have a foundation to be able to use this.
Correct.
Okay. All right. 123.
Good morning, everyone. Good morning. I'm sorry I'm late.
We addressed part of this yesterday in terms
Good
of
morning.
Detective Gaither asked, do you think that Thug ordered that against Nutt, talking
Right.
about the murder? And Zachary says, nah, they're just trying to get a name. This had came up yesterday. It kind of falls in a similar category where the state would have to lay more foundation for how Zachary knows that their motive, knows someone motive. Is it because they told him? Is it because he interacts with them daily? So we would not just ask Mr. Zachary cold, why did they do X, Y, Z? There would have to be adequate questions for that foundation.
All right.
We would object to an order now to eliminate the first word of no. I don't believe that Jeffrey Williams ordered that. If you're saying it's a co-conspirator and he would know about it, then that is relevant. And I don't want it axed from the question.
I'm not sure if I follow you.
Okay, so I think that the answer by Mr. Zachary, the direct question is, do you have any evidence that Mr. Williams, Jeffrey Williams, knew about or ordered the
Right.
killing? The answer is no. Then he
Right.
goes on, and that part, I agree, should come out. But the no or the nah, N-A-H, I assume, should not be struck if you're striking things.
Okay. Well, I'm not striking or not striking this right now. All of it could only come in if there's some sort of an inconsistency and they're presenting it as, to impeach or something like that. So
In Your Honor.
I mean, I guess there are two separate, do you think that Thug ordered the murder? And the answer to that, and then
The next part.
the
I
people that he thinks did do it and why.
Understood. And I just don't, the first part to be part of the equation of that potentially is not going to be played.
Okay, so yeah, I mean, they would be two separate items.
Yes, Your Honor. And the way I could potentially see some of this coming out is if Mr. Zachary was asked questions about, because in this interview, he describes, and he tells Detective Dennis YSL is a gang, and he talks about who he interacts with. And so if we asked him questions about, how does that work? People making a name for themselves or going up in rank, some of these could become relevant if he says, I don't know what you're talking about, things like that.
The same ruling that I made with regard to there are a couple of other comments. Yes, you would be able to use that part of it. They're just trying to make a name to show, okay, yeah, this is how it works. And you have told us this before.
Correct, Your Honor.
Yeah. So that's kind of separate as well. And you could use it for that. And then there's, if you are using it to show what he knew or didn't know about who ordered it, then you need a foundation for his knowledge of that.
Yes, Your Honor.
Okay.
Um,
That clear for everybody?
yes, Your Honor.
All right.
Your Honor, could I just add one, a 24B to my list? And
Yeah,
it doesn't
sure.
even show up.
Okay.
It doesn't show up in the transcript, but I think it affects Mr. Williams, frankly. Off the transcript where, well, you see it, but the transcript's not accurate. On 123 line 12, the woman who's investigator Gaither is asking about the rank of who's the leader. And she's suggesting that Mr. Jeffrey Williams may be the leader of YSL. And Quindarius says, who said Thug's the higher up? essentially. I think that's pretty accurate quote. And,
Okay.
and Investigator Gaither, and it shows up at the end where after it says unintelligible, she's actually interrupted by Quindarius.
Okay.
And she says, that's just what I heard. I do believe that it would be improper to play Investigator Gaither basically an out-of-court statement suggesting that she's heard from other people that Mr. Jeffrey Williams is the higher up of YSL. It's confrontation clause and hearsay.
So, Your Honor, Detective Gaither she's testified previously in this trial, but this portion,
Mm-hmm.
when she says, who said Thug is hired? Detective Dennis is like, who's the boss? Who runs YSL? Zachary says, he was not right there when they started YSL. And they're like, who started it? And he says, my brother and Slug, who was Trontavious Stevens, also known as Tick. And so the state's not going to ask Zachary, did Detective Gaither tell you that she believes Thug was hired? That is not a question that the state would ask. But however, this portion could become relevant in terms of he's acknowledging YSL as a gang. When she says, when she says, isn't Thug the highest, or however she phrases it, he's like, who said Thug was higher, which acknowledges there's a gang with some kind of hierarchy, or because he would have been like, what do you mean higher over what? So
Okay.
so the state, if Mr. Shart's objection is to Detective Gaither's, words saying, I heard Thug was higher, the state does not intend to be asking Zachary about Detective Gaither's opinion on Defendant Williams or the YSL gang. But this portions of it in relation to Zachary saying who he believes started YSL and his own brother, that kind of stuff, he has adequate foundation. We'd have to ask him on the stand to explain that. That's kind of the state's.
And I don't have a problem with anything that Mr. Atkins just said. All I'm saying is, and they could ask about that. And quite honestly, I think the defense likes Mr. Zachary's answers. All we're objecting to is if it's played, there's a prior inconsistent played to the part that Investigator Gaither says, that's just what I heard, referencing that Mr. Williams is the leader.
Okay, so you're saying if for whatever reason it does end up getting played, strike that's just what I heard part.
Correct.
Any problem with that?
No, I agree with Mr. Shart on that.
All
Or
right,
the state does.
sounds good.
Your Honor, the next one, to make it easier on everyone. So I think there was a bond hearing or something that Detective Dennis or Gaither, they're referencing a court hearing and arguments that Mr. Zachary's attorney made. They were like, those are good arguments. We all know that. Anyways, the state is not going to be asking. We're conceding this in regards to it's a really brief back and forth where they're laughing about a court hearing, about the argument on bond, about the gang. And so the state's not going to be asking Mr. Zachary anything related to number 26.
Okay. So redacted by agreement.
Your Honor, and also on number 27,
Yes.
there is and he says that earlier. And so when Detective Thorpe, who's the lead detective on the Donovan Thomas murder, comes into the room, there's some greetings, and then Detective Gaither kind of tells Mr. Zachary, Thorpe's been working really hard on the case. We've been talking to a lot of people. We appreciate your honesty. The state's not going to be, I don't think this will come up. So the state's conceding this portion in terms of, I'm not going to be asking Mr. Zachary about if Detective Dennis and Gaither thought he was truthful or doing a good job.
Okay. Thank you. Was that all that one needed to cover?
Correct. It's just them bolstering
All right.
basically.
Yeah.
On the tape.
Okay. All right. 135.
So, Your Honor, this one, Mr. Zachary says, I think Nard was driving them, and then Thorpe just kind of repeats, okay, Nard was driving. This is when they're speaking about, because Zachary at the beginning of this interview talks to Detective Gaither and Dennis some about Donovan Thomas's murder, and then they get Detective Thorpe to come over because he's the lead homicide detective. And so he goes into more detail at that part. So the state, this part of the interview, Mr. Zachary, as like all of these interviews, he's not saying directly where this is coming from, but the state's position, kind of similar to yesterday, is that the primary source of Mr. Zachary's knowledge is from when he says defendant Stillwell, defendant Kendricks told him that night. He also has a brief mention when he goes down to Miami with them that he had some kind of conversation with with Demise McMullen, Nard. And so he does say, I think Nard was driving them. The state's position, and again, this may depend on the foundation of the questions he's asked, but the pool of information that the state's aware of from Zachary's statements is other co-conspirators telling him about either their own involvement in the murder.
Okay.
And Your Honor, my stance, as previously stated, is that if Mr. Zachary is claiming the source is anyone other than my client, Mr. Stillwell, I would object. However, if the source, I understand the court's prior rulings, and if the source falls under the court's prior rulings, I understand what your ruling is.
Okay.
But I don't, as I sit here now, I have no idea what his source is with some of these statements that he's making.
Okay. Well, I think we have to take the entirety of the statement into consideration, but that would fall under my prior rulings with regard to the co-conspirator exception. So that'll be permitted.
Your Honor, I believe next is number 29, which is 136, line 18 to 137, line 11.
Okay.
In this portion, Detective Thorpe says, after the shooting, do you know what happened to the cars and the guns? And Zachary says, yeah, they dropped it off at OG Bentley's spot, who's Mr. Treadwell. And he asked them, do you know if the guns are still around? Did they get rid of them? And Zachary says, most likely got rid of them. He's supposed to have gotten rid of them. And then they have a conversation about Detective Gaither's like, how do they usually get rid of guns? And Zachary's like, well, this is the first time. Usually we keep the guns. And
Okay.
Detective Thorpe asked if anyone got a word to shoot nut, which is one we kind of just addressed. And he says they just wanted a name. So it's speculation and hearsay. I think the speculation objection is coming from where he says, do you know if the gun's around? He's like, they most likely got rid of them. The state's position here is that, again, his source of them going to Kevin Treadwell's house is, again, the same co-conspirator statements. And he is not definitively at the house or see them bury the guns in a backyard or throw them in a river. But I think it's reasonable to think that from his conversations with them that they went there to get the car and the guns so that they couldn't be caught. So the speculation is Zachary's not physically present at Mr. I have no information that he's physically saw these guns being hidden. But I think because he spoke with co-conspirators about it, it is not as speculative as that question
Right.
seems.
He has a basis for knowing from his other co-conspirators that they were dropped off.
Yes, Your Honor.
What happened to them after that? That is what he's speculating. He knows the purpose was to get rid of them, but whether they were actually gotten rid of past OG Bentley's place, he doesn't know.
Correct, Your Honor.
But that they were dropped off, he does know.
Correct. And because he kind of answers, like, it's clear that he doesn't exactly know if this particular portion through impeachment came in, it's, he's kind of telling her, like, I don't know exactly, I think they did, but it makes sense in the context of the conversation he has a couple hours after the murder.
Right.
That
All
they
right. Well,
wouldn't, so.
with those parameters.
And it just goes, I've stated my objection. I understand the court's ruling. However, I do believe that 9 and 11, lines 9 and 11 on 137 are a little different because, again, that is just, from my understanding, just pure speculation about motive.
And this is kind of similar, Your Honor, in terms of the state would have to ask him foundation about how does he know they wanted a name?
Sure. All right.
That boy Atkins love using that left hand, don't he? Everybody put left hand in the chat. That's my boy left hand. Isn't it better that he's doing this instead of Ms. Love? To be honest with you, I think this is
on
what
this one, Your
I think this
Honor.
is way
Hang
better.
on just a second. I need to actually figure out where we are, because so that actually, even though 1, 3.
I wrote it.
So that went past what is notated on your number.
It was supposed to say 136.18 to 137,
Okay.
line 11.
All right. That's, I looked down and I'm like, well, we're talking about 137. Okay. All right, now I'm back with y'all. Okay, 138.
So number 30, number 30 on my list. This transcript is really rough here, so I'm just gonna, if the court allows me, just
Sure.
on 138, line 6, Mr. Zachary is talking about Shannon. So Shannon's the topic.
Okay.
Gaither says, right. Zachary says, like, Thug really wasn't messing with him. He was around Thug as Woody's friend.
Okay.
Okay. So they're still talking about Shannon. Line 13, right. So once he did that, it was kind of like, we can trust him. Zachary says, yeah. And then line 17, she says, we know he a shooter.
Okay.
That's my objection. The law enforcement saying, we know Shannon's a shooter.
Okay.
And so, Your Honor, this portion, which I agree with what Mr. Shard's saying, that this time hack states. And so they're talking about, it starts with Zachary has a comment where he's like, usually Woody and Moontunk are doing all the shooting. And then Gaither's like, well, did Mr. Copeland slow down with his BS? And he kind of says, when he's around a lot of folks, he gets pumped up. And they're kind of asking, how did Shannon Finnett Stillwell get into the picture? And so he's like, well, he was friends with Copeland, comes around. And Zachary says, no one really knew Mr. Stillwell that well. And then, the way that what they're talking about is after the murder of Donovan Thomas.
Mm-hmm.
Gaither's like, well, once he did that, and that is the murder of Donovan Thomas, that we could trust him, know he's a shooter. And Zachary's response is, he started messing with Shannon hard. I take the he being defendant Williams. And so the state feels that Detective Gaither's question to get Zachary's response, if the right questions are asked on the stand, could be relevant because, for one, Zachary on some level confirms what she's saying, because he's like, after she says, now they can trust him, they know he's a shooter, Zachary says he started messing with Shannon hard, kind of confirming that, yeah, he started messing with him or hanging out with him or being closer with him because he was a shooter in the context of what Zachary's saying happened on January 10th, 2015. So the state feels that it's not just Gaither in a vacuum saying, we know Shannon's a shooter. I'm not going to ask Zachary what's Detective Gaither's opinion, but yes, my apologies, Madam Court Reporter. But it could become relevant because of asking Zachary in the context of his relationship with Mr. Copeland, how defendant Stillwell came into the picture, that this exact clip, if the right questions are asked, could become relevant to get Mr. Zachary's response.
Okay.
But if this clip is played, line 13 says, right. So once he did that, it was kind of like, we can trust him. And Zachary says, yeah. And then we could easily go to line 19. He started messing with Shannon and then they go into Woody becoming a new Slug and Shannon becoming a new Woody. But none of that requires line 17, law enforcement saying, we know he's a shooter. That's my objection, specifically that line. I understand. Right.
So up above on line 6, what gets said then? They already knew Shannon liked something.
I just have it say that until. Like that until. It doesn't make a lot of sense, but that's what they're kind of interrupting each other.
Yeah.
My note, Your Honor, is Zachary says, nah, so lines like 2 or 3, Detective Gaither says, did Woody slow down with his BS? And Zachary says, nah, when he's seen that there's a lot of folks around Woody, they pumped him back up. No one knew Shannon like that until Thug, not really messing with him. He was around Thug because he's Woody's friend.
I agree.
Yeah, that's on the prior page, right?
That's 138, line 10. Right, Mr. Atkins? That's where you're at?
I believe so. The transcript lines I'm looking at, I went back through and added, from listening to it. So my line and page is a little off, but
Well, I see did Woody slow down with all his BS once Nut got killed? Or was he still?
Right. That was on 137.
Right.
And
then
then
this is the no, he'd get the answers, no, he'd get pumped back up, or what?
yes, Your Honor, it's Zachary says, nah, when he's seen that there's a lot of folks around Woody, then he pumps back up. And then he says, no one knew Shannon like that until Thug, not really messing with him. He was around Thug because he was Woody's friend.
and then Gaither says, right. So once he did that, it was kind of like we can trust him. Quindarius Zachary says, yeah. And then Gaither says, we know he's a shooter, or we know he a shooter.
Right.
And I don't know why the Gaither would be allowed to make a declaratory statement, whether she's talking generally that law enforcement has
generally his
determined that he's a
role.
shooter,
Right.
or if he's a shooter in this case,
Right.
that's a question for the jury.
Right. But I mean, assuming that he started messing with him hard after that is actually in response to the statement, we know he's a shooter.
Well,
And maybe I just need to listen to this part.
I view it more of a response to line 13, where she says, so once
Once
he did that, it was kind of like, we can trust him. And he's like, yeah. And then you could easily go, he started messing with Shannon he started messing with Shannon. He repeats himself. I don't know why. And then they don't really, there's no real meat to what Zachary says, because then they move on to Woody. But my concern is specifically with, we know he a shooter.
I understand. I'm going to listen to it. It may not elucidate anything, but where is this timestamp?
So, Your Honor, I have a little bit before this is at 3:25:44.
Okay, I'll just start there. And you did send this video or no? I can't remember.
I will double check, Your Honor.
Okay, just make sure y'all do so that I can
That's
listen
right,
to
we
it.
did give a thumb drive, so it should be.
Oh, so it was on the same thumb drive that the other one was? Okay, I know there were like 4 items on there.
Yes, Your Honor.
Okay, all right, well, I'll listen. Y'all can remind me to circle back on it. Do we have that other thing queued up?
Yes, no, and I wanted to make certain that I got the exact time, because I just pulled it over to this time right when you want to listen to it.
Yeah, we're going over.
And I mean, maybe we can just listen to them both while it's up. I don't know.
Keith, forward that to, can you forward it to Garrett?
Your Honor, for the record purposes, we're pulling up. We're going to start at 3:08:50.
All right, and this is, we're going back to item number which?
We are going back to this actually kind of tackles a couple items because this is all about who shot Lucci's mother's home. But I believe what prompted us to go back was,
Item number 23, was that the one we were?
yes, Your Honor, I think it was 23
Yeah.
because we weren't sure if Zachary physically saw these guns or.
Right, okay. Right.
What's so interesting, a lot of this stuff doesn't have any foundation at all. Yet some of this is getting still admitted. And some things are being I noticed what the judge is doing as well. Is like some of the things she's doing is like she's holding it and she's saying, well, you could come, if you come across the door in trial, then we'll attack it then.
I don't know if that's true.
But
I'd have to get
but
on
she's
Zoom
still
first. Are you playing
giving
it
it some
through Zoom
type
or are you
of,
playing it off
allowance.
your
So
computer? All
kind
right,
of
let me
strange to me.
then join Zoom.
Maybe it's me. I don't know. Maybe it's me. What you all think about that?
And figure out where this might plug in.
Yeah, I don't think it's gonna be a mistrial either. But she still has more time to respond to those motions.
So 30850 is when they first start, literally Detective Dennis asked him who shot up Lucci's mother's home. And then I'm happy to start there for the court if the court would like. There's about 3 minutes of conversation, but when he specifically starts talking about what kind of gun did Shannon have on it, which is more tethered to number 23, I can jump just to that part. I want to just ask the court if you wanted me to play a little bit before or go right to when he's discussing the part about who had what firearms.
If you think the context will help, that's fine.
Okay. We'll start at 30850, Your Honor.
All right.
Officially 30841.
So let's get to this. Who shot up Lucci mama? Shot up Lucci mama? I'm telling y'all, I just got work with me. We bro, like you're doing great. Rudy, Shannon, and Lil Pokey. From Boulevard? Nah, those are nephew. Lil Pokey is in jail right now. Quentin Pittman. So, how did, cause that was one gun that you had, that you got caught with. No, I had two guns. So, how did Woody end up with that gun that day? We was at Boot Mama House, Big Boot Mama House. And we was like, hey, folks, that's right. Okay. Then when they came back, they ain't even tell us what they did. What kind of car were they? They were in what? It was in that white Charger. Woody Charger? Okay. And then the boy, Mushu, who he be with Lucci, Mushu, yeah. He called Boo, like, when Woody got back, he called Boo, like, Boo, they got in. Boo, like, what? Like, somebody just shot up Lucci mama house, and mama got shot. And Boo, like, don't tell me how they did that. Cause they come back and they say that. Don't tell me how they did that. Then that when Woody got scared again, cause Mushu, like, got 10,000 and who else did that? Who had the Monto gun? Woody. So they actually came back and said they did it, or y'all just assumed it? No, they said they did it. He finally said it when Woody, like I told you, Woody got scared when they said he got 10,000. Man, we just shot up Lucci mama house. So because Lucci was close with Nut, they just Lucci was hanging with Kel. Right. That's what he's all about. Lucci and Kel. Like, let them boys get killed. I don't know what made them do that. Did you know Nut? Yeah. He gave me $20 and stuff. You know, I put up on get some gas money, phone bill, doing stuff like that. So he's like a big homie. Yeah, he cool with the whole city. That's what everybody said. So everybody speaks highly of him, but he still was a street nigga. So yeah, he should be trying, but he like every time I see him, so I feel like I'm gas in the car, so he do 20 or 40. So they look at you like the little like, yeah, I ain't no harm. Basically. So, what gun did Shannon, you think Shannon had on that? I don't know, they had an AK. Another 223. And the AK. I know they had that big AK. That was poking on. The AK was? Yeah. And what's that? He had one of the 223. Oh, yeah, the AK. I don't know how they got in the car. I didn't know guns. So answer this question. So when we were in court and you found out that gun.
All right. I mean, it sounds like, to me, like he's saying, essentially, this is what they had with them when they left out.
That's the state's, we're in agreement, Your Honor.
So I'm going to permit that.
Overrule the objection and permit it? Your Honor?
Yes.
Yes, sure.
Okay, so can we move to the other one that I was going to listen to? But we know he a shooter.
Yes, Your Honor.
That pretty easy.
Yes, Your Honor, it is.
Okay.
So we're going to 325-44 for the record.
All right.
Yeah, I'm pretty sure the defense is going to dispute that once it gets towards the trial and they start cross-examining and stuff like that. So that's nothing. Yeah, because they can easily talk exactly. He said also said I don't know, so they can easily say the
325-29.
speculation as well.
You know her last name? No. You know where she rented from? So, after the shooting, do you know what happened to the car and the guns? Yeah, they dropped off at OG Village Park. Do you know the guns still around or they got rid of? More likely they got rid of them. I think when they dropped off at Village Park, they got rid of them. How do they normally get rid of guns? I don't know. That's the first time they ever usually keep them. Yeah. Okay. So, did anybody get word to shooting up, or this was just an opportunity? They just wanted the name. They just wanted the name. Correct. It used to be one and more to going out shooting. They just wanted the name. So did Woody slow down with all his bullshit? Or once Duck got killed, did Woody slow down with his stuff, or was he still? Nah, when he seen that he had a lot of folk that ran with him, then he popped back up. Moody. Yeah. But see, they don't really know Shannon like that until then you do. Right. Like those don't really mess with him. He was around for with Woody from him. Right. So once he did that, it was kind of like we can trust him. We know he's a shooter. He started mixing with Shannon for it. He started mixing with Shannon. So he put Woody to the side and Shannon back to the Woody spot. Yeah. So like Woody took Slug's spot. So Shannon and
It is really, I don't know that it can be determined that he started messing hard with him is in response to him being a shooter, to him doing that, to him coming around with Woody and it being okay because he's Woody's friend. I mean, I just think that I don't think you can base that Thug started messing hard with Shannon on him having been a shooter. I'm going to exclude that.
There you go, Judge. There you go, Judge. Good job on that. I was about to say, because none of that was good. None of that was good for the state. Good job, Judge, on that one.
Moving to 144.
Now, remember, these are evidentiary statements. So all of these things can be objected,
Can we just-
refuted during trial. So, and a lot of this don't have a lot of foundation anyway. So they have to build foundation with these witnesses as they testify and stuff like that anyway. So we're going to see if this trial continues, we're going to see a lot of that. Trust me, it's going to be a lot of objections. It's going to be a lot of objections for sure. Welcome to Biz Nation. For you all that's coming in, go ahead, hit the like button, share this video, share this live, like the channel, like this live, and also subscribe to the channel, man. Become a part of Biz Nation, man. We're a big family over here. We are a huge family over here. We got nothing but love, baby. Nothing but love over here. Right, Sheely? Lots of objections. Lots of them.
All right.
Lots of them.
Your Honor, with this next one, I'm in agreement. This is probably this section where Zachary is stating that his older brother used to hang out with defendant Stillwell. And then Zachary says something along the lines of, until Shannon got locked up,
Okay.
the state would omit or ensure that the jury never hears about Shannon getting locked up, but may ask him about him knowing his brother.
Okay. That takes care of that objection.
Yes, Your Honor.
All right.
Yep, that's good. My boy left hand is all right. Even though I don't like prosecutors at all, to be honest with you.
Now this next one, Your Honor, 32, I'm pretty certain she's not referring to Shannon. I think she's referring to Terry Rivers,
Okay.
who I don't know if his name has come up in this. He's certainly not in this case. He's certainly not indicted. My understanding is he's alleged to be associated with some of these gentlemen in some way, but then Gaither adds, yeah, I know Terry Rivers used to steal ATM machines. And I just think that that's just
Okay.
throwing another.
Your Honor, the state agrees and concedes this.
All right.
this
If
portion
y'all are
of it.
going to agree, tell me before we
Yes, Your
listen
Honor.
to the argument. We can save Mr. Short and my voices.
Yes, Your Honor.
All right.
There is some agreement with this next number 33.
Okay.
So they're talking about the Dexter Montgomery shooting, which was in Act 36. We've already introduced at trial. Mr. Zachary was not present. He admits in this interview he doesn't have any personal knowledge
Right.
about it. The part of this that the state may get into is the photographs used in that case. For example, there's gas station surveillance stills.
Okay.
He recognizes, for example, Demise McMullen, who was one of the defendants in that case.
Okay.
The same photographs that Detective Gaither and Dennis are showing him during this portion are already in evidence. And so depending on, there may be some questions with those exhibits,
Okay.
but we're not going to be asking Mr. Zachary anything about what happened to Dexter Montgomery because he doesn't know.
All right. You'll just be using it.
That's fair. I mean, I don't, Mr. Murphy, DK, took the stand and he's acknowledged that it was him in Nard. So I don't think that's really in dispute. I would add though, and this doesn't show up in the transcript, Investigator Dennis has a habit of doing this with a lot of these gentlemen he interviews. He takes out a picture of Dexter Montgomery's head, which is actually in evidence. And he just goes into this big thing about, oh, he's got half a head. What do you think of that? And I just don't think that's appropriate.
Okay.
But if for some reason there's an issue about who was there, I do concede that Quindarius Zachary, after Investigator Dennis does the half a head thing, does show him pictures from the scene, and he says, oh, that looks like Nard, that looks like DK, or
Okay.
so I concede that he
Alright.
does do that.
So to the extent that this is him identifying, yeah, that's that person. I know that person. That's this person. We don't need commentary about, oh my God, look at this guy's head. You know.
Agreed, Your Honor.
Okay, great.
Number 34 also is in agreement.
Okay.
This is in relation to something that's been suppressed under
Yeah, I
grade of
think
a
y'all
house.
told me
So
that already.
that's right, Your Honor.
Okay.
35, this is a portion where Mr. Zachary they're asking his girlfriend, Summer Good, says that basically she doesn't like him hanging out with them. And then he mentions defendant Stillwell because like Zachary gets in trouble with them. And so the state feels that, in the context of when, and Detective Dennis is going to be also, he's testified before, but he's going to testify again. He's on the witness list and he's in this interview. This could become partially relevant in regards to this. in what's going on in Mr. Zachary's life at this time, he's
Mhm.
trying to pull back, in his words, and kind of get a
Right.
fresh start, spend more time with his girlfriend, things like that. And so this is kind of wrapped into why at this moment in time he's in jail. He's speaking with the police. And so the fact that his girlfriend, who he's kind of self-admits is very close with, interacting a lot, she doesn't like him hanging out with them. And so the state does feel like this could become relevant with the right questions of Mr. Zachary.
Okay. And it could. So I think at the point in time when y'all think it does, that's maybe something we'll just have to wait on.
Okay.
Okay.
Your Honor, the next one, number 36. So Zachary is discussing when his brother died. And what he says is he died when Haiti Gang robbed him.
Okay.
Haiti Gang is kind of a subset and affiliated with If Gang. And so the
Uh-huh.
state feels like this is very relevant because Zachary's older brother, who in an earlier part of the interview, he says was one of the, Zachary says,
Founders.
correct,
Yeah.
that the fact that Haiti Gang robbed and killed his brother, that is relevant to how he kind of got involved in a gang. So it's not as much about what happened. We're not going to be asking him details of his brother's murder, but
Mhm.
this portion could become relevant when we ask him questions about his brother. So that's why the state wants this to come in, at least in relation to, because the objection was discussion about the murder of the witness's brother. So it'd be a brief discussion of that, if at all, depending on how he answered.
Okay. Well, I mean, 159 looks to be like the details of it. So even based on what you're talking about, this part may not come in.
Yes, Your Honor, like we won't be asking him like what street his brother that happened on, or
Okay.
we would just be asking him, or we may never get to a part where we have to play this to discuss this part, but it's just about the fact that Haiti Gang robbed and killed his brother.
Okay.
That's the part the state wants, is relevant.
All right. All right, number 37 is on, starts at the bottom of 163.
Your Honor, this portion is when he's discussing the shooting of Dwayne Carter's tour bus.
Mm-hmm.
So Zachary, Detective Dennis personally sees Zachary when he arrives. They're at a nightclub outside. And then there's a lot of things that happen, some of which Zachary's present for, some of which he's not. And so he is not in any vehicles. He never says he's in a car that did the shooting, things of that nature, but he mentions being with different members that are there, like co-conspirators, defendants, other witnesses. You know, they go different spots in the city before they arrive at the nightclub. They go to places afterwards. The events of this shooting become something that gets discussed amongst each other. And so the objection was, well, the investigator testified about his theory, hearsay and speculation. The state's more concerned with what Zachary, what he states happened. Like, for example, he's discussing what cars people went in, like Detective Dennis asked, did they put Thug's sisters out? Like, because some people got in different cars. And Zachary says, he's saying, I don't know where she lives, but he confirms like Max is who he calls his sister was there. And so, and Mr. Shard, correct me if I'm wrong, if there's a specific portion, but Zachary's knowledge of what happened that night will be something we'll be asking him about. And so this may be one that we have to, it really depends on the questions he asks, because it would only be impeaching him if he kind of backs off the details of that night. And so I will not be asking him about Dennis's theory of what happened, but depending on what he testifies to, certain of these portions, you may need the question asked in his response, but this is kind of very much wrapped into how he testifies because he goes through a lot of different facts of that night.
All right, and it seems like, Mr. Shart, you're objecting to man one, who's one of the investigators, saying, here's what I know, or here's what I saw. Is
I
that
am
right?
objecting to that. I mean, my understanding is that's Investigator Dennis, and he's already testified to what he saw on the stand.
Okay.
And
So they wouldn't be offering that for it to get in anything about what he actually saw. This would be if it becomes relevant to, if the answer becomes relevant.
this is the dilemma, Your Honor, as I see it. I concede that it seems pretty clear that Quindarius Zachary was at the compound that night. The compound, I don't know if Your Honor is familiar. I've been to the scene. It's
Gigantic.
It's very large.
Yeah.
It's unclear to me. I know that he was not on 285. That's pretty clear. Or he's saying he wasn't on 285 or when buses were shot.
Mm-hmm.
What's unclear to me is where he was when he's claiming people were leaving out and switching cars.
Right.
He's definitely giving that information. It's unclear to me if it's based on, and this was a widely reported event. There was hip hop gossip, internet sites almost immediately that are reporting what happened, different theories. So it's unclear to me whether he's there when he's saying people were leaving in certain cars.
Yeah.
And I concede if he was there, if it's established that he was there and he's saying he saw things with his eyes, I mean, it is what it is for me, and I'll have to deal with that in cross-examination. But what I don't want is the state for him to say, well, I wasn't there for that part, and then the state to start impeaching him. Well, didn't you say this and this and this? And then it was just all based on speculation or internet gossip or other things. So I don't know what his source of information is for some of this stuff. And that's what I'm struggling with. I understand in a certain circumstance, he would be able to testify about what he saw. Well, in any circumstance, he'd be able to testify to what he saw. But I'm not sure he saw these things. I'm not saying he didn't. I don't know.
Well, I think we already made rulings, and by we, I guess I mean me,
Well,
about that.
you made rulings, my recollection is you made rulings about what Demekion Garlington allegedly told him about the Donovan Thomas situation. I don't.
Okay, I thought we had talked about him. Maybe we haven't, but I mean, to the extent he gets on the stand and says, yeah, I wasn't there, I don't know any of this, the state can cross-examine him about what he said before, and it may be that it's established through, not cross-examine, but examine, and then y'all can cross-examine him about whatever the inconsistencies are. Even if he says, you know what, I don't know who got into any car. I wasn't there. I was in Alaska at the time. They can cross him. I mean, they can examine him, impeach him with this.
Because that would be clearly inconsistent with his prior statements. But my concern is if he says, you know, as the crowd was dispersing, Investigator Dennis saw me and said my name and I ran.
Yeah.
And I ran from the scene and got into a car and left and went home. And then they're like, well, didn't you say that Shannon got into this car? And it turns out that his testimony is actually that he wasn't there for that part. And what his prior statements were based on something else.
But who knows whether it's true that
I understand.
what his testimony is, you know, whatever, next Wednesday, that he says, oh my gosh, the cops saw me and I ran and I went home and got in my bed. We don't know whether that's true or not. So he's still going to be able to impeach him. And then y'all are going to have to ask, hey, how are we supposed to believe that this is true? And he can say, well, you can see it on my ring camera. I walked in the house, and y'all will just have to explore that. I mean, we don't have any way to know. They're telling the truth. They're supposed to swear to tell the truth and then tell the truth, but we don't know that. So I can't do what it is that you're asking me to do here. Okay.
I understand the court's ruling.
All right.
Your Honor, number 39 and number 40, they all are in relation to the same topic regarding the shooting of Dwayne Carter's tour bus.
Okay, hang on. Did that cover 38 and 37?
It definitely covered 37.
Okay, because I thought we were on 37. So,
My apologies, Your Honor. So
Okay.
for 38, really 38 through 40, and we can take them one at a
Okay.
time. They all talk about this same event.
I would agree with 38 that what your ruling was just covered.
okay. All right. So moving to 39 and 40, is this also still the same incident?
I'm catching up.
Me too.
Okay, so on 39, excuse me, 30, we're on 39. He is saying that someone said we shot up the tour bus, but there's a pronoun we, and it's unclear who the declarant is or where that's coming from. He's saying that people showed up at the studio later that night and someone said we shot up the tour bus.
Okay. Okay. So does he ever say who showed up at the studio later?
He does mention where various people come, but I don't have memory of him ever clarifying exactly. Well, I will say this. Give me 1 minute, Your Honor. I'm trying to find this part in my more detailed notes.
Mhm. I mean, it says after they shot up the bus, what happened? We met up at the studio. What were they saying? They're basically saying we shot up the bus. But we don't know who the we is from here, but we may know who the we is from if he somewhere else says, here are the people that showed up at the studio.
And Your Honor, there is a portion where he's discussing who switched cars.
Okay.
And Zachary, so Detective Dennis says, so Max, referring to one of Defendant Williams' sisters, and Shannon switched spots. And Zachary says, told everyone they were going to watch him, call him, meet at the studio, say we're going to go shoot up the tour bus. And Detective Dennis is like, they said this? And Zachary says, I don't know what the hell made him shoot up the tour bus anyways. Oh, my apologies. Yes. They were at the studio. Say, we're going to go shoot up the tour bus. Detective Dennis says, they said this. And Zachary says, yeah, I don't know what the hell made him shoot up the tour bus anyways. Detective Dennis, who said it? And Zachary says, Pee-wee, referring to Jimmy Winfrey, who was the individual. It's a Cobb County case, but relation to this incident. And then Shannon said it. And Detective Gaither's like, well, who was more hype about it? And he says Shannon. Now, I believe this context is before the shooting, whereas what we're talking about is afterwards, but this is kind of very much wrapped into how, when we get to this part of the interview, we'll be asking him questions about that night. And so depending on how that questioning goes and what his answers are, he will have to have, the foundation for who he was speaking with or interacted with. And I actually say a little bit further, Your Honor, and I can actually play this if we need to. I have 3:45:49. Detective Dennis says, after they shot up the bus, what happened? Zachary says, we met up at the studio. Detective Dennis says, they came back to Metropolitan. What did they say? And Zachary says, they say they just shot up Wayne's tour bus. It was Max's truck with them in there and Pee Wee's car, referring to Mr. Winfrey.
Mhm.
Don't know who Pee Wee was with. And Gaither's like, so both cars up there, other cars following them? And he says, probably follow them to Expressway, not sure if they followed them to the shooting.
Mhm.
And then he just goes into a diatribe about how Mr. Winfrey came into their friend circle. So I don't see where he definitively says who it was at the studio told him. But this event happening, there's a lot of communication about it because it becomes a big incident that happened. And so I don't know definitively who at the studio told Mr. Zachary, but
I mean, I know that this is alleged to be a gang act, and I would assume part of your RICO.
correct, Your Honor.
Okay. That, and the complication is with our potential limiting instruction about, who, well, I mean, it would only be charged against the people that it's charged against.
And it's Act 39. It's only in relation to the RICO count because this incident happened in Cobb County. So this is.
That makes it easier.
Yes,
Okay.
yes, Your Honor. So.
All right, so then it is, yes.
Your ruling, only Mr. Winfrey is alleging that overt act. He's not on trial.
Okay, but it is alleged to be an overt act in furtherance of the RICO conspiracy, right?
It is an act in relation to count one, which every defendant's charged with count one.
Right, okay.
It's true. But also the overt acts have a statute of limitations of 5 years from the time that the indictment's returned. This is in 2015. There's a series of overt acts that Judge Glanville said, I understand your argument. We'll get to that. He just passed on it, basically, that those could not be considered by the jury in reaching a verdict. I asked for a special verdict form. So all of this, I just want to raise your
Okay,
attention.
now I appreciate that if that's yet another pending determination for me to make, but I would think that they can still be, I mean, nobody's being, even if it were in Fulton County, nobody's even potentially being convicted of this act, but I would think that statute of limitations or no, it can be considered by the jury in determining whether the people charged are guilty of a RICO violation.
Oh,
So if you've got case law that says differently, and if you already filed it, just let me know where to find it. But if,
And Your Honor,
and is that the argument that you're making, that they cannot even consider when they're considering whether anybody is guilty of a RICO violation, acts that there is a statute of limitations for, and that statute has run?
I mean, what's the
So I
point of having
think,
statute of limitations? We can't use
they-
them.
My position.
They, the jury.
Okay, so the jury can only, they're going to have to find the overt act because it's a conspiracy.
Uh-huh.
That overt act must be, in my opinion, and the case law that I'll again show the court or show this court would be within 5 years.
Okay, well,
But-
if there's case law that says that, then certainly I'll take a look at it. And it sounds like that issue is still on the table to be determined, right?
Yes.
Look at Miss Love, dog.
being a newer addition to this team, I wasn't present when I'm being told that this issue has been addressed before. And so if there's going to be further, I don't have the case law right now, but in terms of Act 39, the fact you can charge overt acts in furtherance of a conspiracy to happen outside of Fulton County. That part is clear.
Oh, yeah, no, he's not talking
And-
about where it happened. He's talking about statute of limitations having run.
And there is, to my knowledge, and we can, I don't have a case to cite right now, but we can, if this needs to be briefed, we will brief it. But that is not the state's understanding with,
It's not the court's understanding of it either, but I mean, been wrong before. I could be wrong right now. It is not my opinion that matters. It's what the case law says that matters. And if it has already been briefed by both sides, super, just point me to which brief and which response I should be looking at. And it very well may have been addressed before, but not decided. Ms. Lev, do you think it's already been decided?
Judge, that's what I was just saying. I
Okay.
believe that this issue was raised by Mr. Steele very early on, and I believe that it was decided in the state's favor against his position.
Okay.
But I was saying that we can check the transcript for that because my firm belief, because I remember the argument, is that it was actually argued and decided. We will also look for an order
Okay.
to that effect. But I specifically remember Mr. Steele's assertion regarding a statute of limitations. I believe that it may have been Mr. Floyd that argued that,
All right.
but we'll check and see.
All right. Well, thank you. And whatever you find, send to me or point me to it at least. Now, this is not really an evidentiary ruling that's been, assuming it has been decided. This isn't really an evidentiary ruling. This is a ruling that's going to impact how I tell the jury to deliberate on issues and what kind of verdict form we need. And so it really is something that I don't find myself bound by whatever the prior ruling was, even if it was made. I want to take a look at it myself and make my own determination based on the case law. So y'all just, again, point me to what I ought to be looking at, and I'll look at that and then make a ruling.
And Your Honor, so that I'm making certain that we are speaking apples to apples, Mr. Steele's assertion is that because the statute of limitations on the overt acts have run, that the jury is not allowed to consider the overt acts?
That's what I think he's saying. No.
I'm just saying to deliberate for the actual verdict. Let's say that we're asking for a special verdict form. There's 191 overt acts in count one. Let's say the Honorable Court grants a special verdict form, and every one of any overt act within the statute of limitations within 5 years of the return of the indictment says not proven. But then there's one or more overt acts before 5 years of the return of the indictment that says proven. Our position would be the overt act is not satisfied because the statute of limitations bars the conviction because the overt act was previous. I'm not talking about evidence because that shows the history of the quote
Right,
organization.
it could just be intrinsic or whatever. So
Right.
I mean, okay, so I mean, but I do understand they can consider it for whatever, the history and how it all fits together. But you are saying that case law bars the jury from returning a RICO conviction if the only overt acts that they find to exist are overt acts the statute for which has run.
Exactly.
All right, well,
And the state opposed at our previous argument a special verdict form. That was the Honorable John Floyd. And what Judge Glanville said was, we'll address that later.
okay, well,
That's what
we
happened.
need to address that.
We'll do it to you, obviously, because you're.
What? I think you just lost the battery in your,
I did. I'll put it in writing because I think it's a fascinating issue, but we'll put it in writing.
Okay, and if it already has been put in writing, you don't have to do it again. You can just point me to, this was, motion number 50,000 filed on May 1st or whatever. If you haven't put it in writing yet, great, do that. And same for the state with regard to a response. And if there is a ruling, I want to look at that too. I mean, I don't want to reinvent the wheel either, but I will make my own determination about it.
Yes.
Okay.
So I just found, hold on, I'm sorry, y'all. I just found this real quick. It says, yes, the statute of limitations for a federal conspiracy charge begins on the date of the last overt act committed in furtherance of the conspiracy. So yeah, overt acts does have a statute of limitation. And in Georgia, I believe that the statute of limitations, you cannot, what I just looked up, you cannot
So where were we?
use that to deliberate with a jury. So there is a
John,
case
we
law. I'm
were,
pretty sure Brian still has it.
176 line 6 is
Yeah,
what we were
and
just
like-
discussing.
Okay.
And just to be clear, if the foundation is laid that Mr. Zachary is falsely asserting that my
Right.
client stated that, then I understand that that's just going to be a subject for cross-examination. However, if it comes from a source, allegedly comes from a source other than my client, our stance would be that would be either rank hearsay, something he read off the internet or something, or if it was said to him by someone else.
Okay.
I'm just using an example.
Sure.
Pee-wee, that would be spilling the beans. And that's,
Okay. Well, and I'm rejecting your spilling the beans argument with regard to all of these things as they're going down and immediately after they go down. Now, if his source is off the internet, then that's a different story. But you have reason, you have a basis for, I mean, they all get, whomever they get together at the studio afterwards and talk about it. So,
Yes, Your Honor. And Zachary says we met up at the studio, and then Detective Dennis says they came back to
Yeah.
Metropolitan, and he says they say they just shot up the bus. So he's kind of responding to like a person he's around.
mhm.
So, but understand, and we will ask him the right foundation for that before just asking an out of the blue question of, they
All right.
told you they shot up
That's
Little
true.
Wayne's tour bus.
Okay.
And certainly the next two, Your Honor, the state
Mhm.
is in agreement in regarding Mr. Shard's number 41, page 178, line 1 through 2. It's a comment that Gaither makes. So the state,
I'm going to withdraw. Can we deal with 140 first? 40 first.
my apologies, I skipped over that.
40 is just him saying what he feels that there were cars following on the expressway. He wasn't there for that. And he actually says they probably followed them to the expressway, but I don't know if they followed to no shooting.
Yeah.
So he's just speculating there.
He's basically saying beats me. So,
Yeah, yes, Your Honor. We will
Okay.
not be asking about
all right.
those cars on the highway.
40 is out by agreement.
41, I'm going to withdraw,
Okay.
and I just think it's needed to add context.
All right.
I think it would be improper in some ways, but quite honestly, it involves Mr. Steele's client and Mr. Adams' client, and Mr. Zachary says no. So I think it's needed to provide context to the no that Mr. Zachary gives.
All right. Thanks.
Can see it. And Your Honor, number 42, the state's in agreement of.
Okay. All right. And then 43 is our last item on this statement.
Your Honor, we're also conceding number 43.
All right.
We'll not be talking about this
Okay.
topic
Thank you.
with Mr. Zachary.
All right. Then we've gotten through this statement. All right, we'll take a break in just a second. Housekeeping wise, did Ms. Love, were you able to email over to everyone last night what you have so far?
I sent some, and then I have the broader folder containing Mr. Sledge's exhibits that numbered, and so I will share that. I haven't shared it because I was actually still typing in it just now, but I will share that with counsel for the defense. And Your Honor, as I look towards next week, it would be Mr. Sledge before Mr. Zachary.
Okay,
So,
so we did this in the wrong order, but. All right, that means we need to get to all of what might be used with Mr. Sledge today.
that's the folder that
Okay.
they're about to,
All right, well,
and it's not,
not voluminous.
I don't consider it voluminous,
Okay.
but, it's not.
Okay.
So I'm gonna drop that.
All right, so go ahead and send that now. And then we've got to sort out potential jury instructions for when they come back today. We're not going to have court on Friday. Okay. So let's take a 10-minute restroom break and come back and get to work. No.
All right. We are on break from this. This is very, very interesting. Again, this is one of the reasons why it's good to look at these things, even though I know a lot of people may think this kind of stuff is boring. But to be honest with you, you get to learn a lot of stuff. Overt acts have statutes of limitations on them. So the thing about it is that trying to use an overt act that has a statute of limitation, using that trying to deliberate with the jury, I don't think you can actually do that. You know what I'm saying? And so that's very, very interesting that they're trying to implement something that has that kind of connotation. It's very, very interesting to me. A lot of the, as you can see, even with Zachary, some things he knew, some things he didn't know. You know, some things he knew that someone else told him, and some things he knew offhand. But you can't utilize anything that doesn't have a lot of foundation in it, and you can't use it as evidentiary statement unless you do build the foundation first. So even if the judge is saying, hey, well, we're going to defer to this, later on in the trial, and we'll deal with things as they come along, the first thing you have to remember, especially with Ms. Love, is that you have to lay foundation first. And what the state has done in this case for sure is they have made some cumulative foundation, especially towards the early stages of this trial, like with the constant like Instagram photos and all that kind of stuff. And like, especially even with asking Woody, like, do you know who this person is? Who's this person in this Instagram? Is that you? And is this person? And then like having like 20 pictures of the same person, trying to lay a foundation that he knew that Woody knew him or knew whoever. It's just like, it's just too much, man. It's just too much. But while we're gonna break, I want to shout out first to the chat. I see everybody is in the building today. That's what's up. Again, want to say good morning to everybody. I want to see, well, who was this? Teresa. Is it Teresa Do it? Yeah. Appreciate you stopping by, saying what's up to us. Says keep little Woody a free thug. A lot of people have mixed emotions about Woody, because basically, I mean, everything is he's the nucleus of this entire thing. He's the nexus of this entire thing. So I understand why people do have the different, opinions of him, but yeah, but so it's a mixed crowd when it comes to Woody. Mixed crowd when it comes to Rudy. Drea says whole thing is based on gossip. Hey everyone, it's definitely based on gossip, and I totally agree with that. You know, trying to utilize hearsay and trying to flip it to make it look like it has some type of evidentiary um, value to it is very, very, very telling of the system here. Obviously, apparently, you don't even have to have evidence in order to get somebody charged or convicted, huh? You know what I'm saying? Or you could trump a charge on somebody. No pun intended with the Trump statement, but you could trump a charge on somebody, and nothing happens. You know, is either or. So either you don't have any evidence, you can still get charged and convicted, and even if you do have some evidence of something, but it has no mendacity at all, it's just directly what it is, then that also can be, you know, used against you as well, even though it proves that you didn't do anything, you know. So it's this whole thing is just crazy right now. The fact that we even going through this is absolutely insane to me. Let's see who else is in the building. Let's see, overcharged, absolutely. I bet Mr. Harvey cringes every time she says, "Point me to it." She will never be able to catch up. That's exactly what he was saying to her. That you're not going to be able to catch up with what's going on. And I don't think this judge really understands, or the prosecution understands statute of limitation when it comes to overt acts. Like I said, I just looked it up here, and in the state of Georgia, it says that the overt acts that doesn't have any limitations is murder. Um, most misdemeanors and this is in the state of Georgia. Most misdemeanors have 2 years. Most felonies are 4 years. So it's actually a year under what Steele said. And murder is no limit. Voluntary manslaughter of a victim over 18 is 4 years. Voluntary manslaughter of a victim under 18 is 7 years. Uh, Forcible SA without DNA, victim over 16 is 15 years. Armed robbery without DNA is 7 years. I mean, it's so many different list of things here that I'm looking at where these things have statute of limitations. Okay. So trying to utilize something depending on what it is, and if it's going to be something like a felony in the state of Georgia, the statute of limitation is 4 years. So how can you use that act of that is very much outstanding on the statute of limitation? How can you use that and say, hey, we're going to use that and we're going to present that to the jury so that can help them deliberate this case? It just doesn't work that way. You know what I'm saying? It doesn't work that way. It sounds like the state has run out of time. And again, that's what they always do. Again, what we're looking at is this is what they can do whatever they want to do. This is what I be saying a lot, is that they can do whatever they want to do, and they can make it look like they want to make it look like. I mean, look at what was happening to Boosie. Boosie was indicted. He was charged, indicted. He got out on bond for $100,000, and his case got dismissed. Then within 2 weeks of his case being dismissed, now he gets re-indicted of the same thing, but this time they amended something, added something to the fact that, oh, he was utilizing or carrying a weapon while he was under an addiction, which is what and the addiction is marijuana. And we went live about this, and shout out to Drea because she gave us the legal term of addiction when it comes to legally. And you have to be like out of control. You can't, self-control has to be all messed up. You know what I'm saying? And nowhere in the video, in the Instagram video that they're using against Boosie, where he was out of control, under the influence so bad, where he was making bad decisions, he was harmful to the community or himself. None of that happened. None of that happened. So you have to dot your I's and cross your T's all the time when it comes to this stuff here. So the best way to dot your I, the best way to cross your T is don't get in trouble. Don't get in trouble. Leave that life alone. Young people need to learn this. Leave those streets alone. Nothing about those streets are good. It leads you to two places, jail or the grave. That's it. You don't get it in between in the streets. I'm from Detroit, man. I'm from the 313. All right. I'm talking about I'm 82. So I've been through the, I mean, I remember when you could have your port, you know, your screen though was the only thing, you know what I'm saying, that was good. You know what I'm saying? You didn't have to close your door or lock it. I grew up in that little era, and it was only for a short period of time. But then it was another era where you had to lock all your doors. Lock all your doors. Okay. Because those streets was mean. We was under the crack era, all that kind of stuff. I mean, I've been in drug infested neighborhoods growing up and stuff like that. I'm telling you, I've seen some stuff that's crazy. All right. And the streets have one or two destinations, and they're final: grave or jail, prison. That's it. You know, and either way, somebody's gonna make money off of you. Either way, somebody's gonna make money off of you. Because I'm telling you, that is prison is a business. We already know that. We're gonna talk about that one day soon. And so the streets have no love. So in this matter, you know, like you said, being in the gang is not illegal, just like they just said in the court. He's a blood. They use the word blood, the term blood. Okay, what did and the blood said that's not legal, that's not illegal. And the judge said, right, it's not illegal to be a blood. It's not illegal to be a crip, all that kind of stuff. What is the illegal part? The activities that you do. So you got to be careful with what you do. You know what I'm saying? And so my message is just don't get in trouble at all. Just don't do it. If you want to do something to impact your community in a positive way, do that. And if you want to do that in a gang, then do that. But your activity is what's going to determine your destination, period. So seeing this in real time is very, very interesting. How they're going to be able to dissect what the interrogations are saying, how to dissect what can be used as evidentiary statement and what can't be. The most impactful witness in any type of case or trial is an eyewitness. Like, I was there, I saw it. Okay. And if you get about good 2 or 3 eyewitnesses, you got some evidence that, and you have some evidence that correlates with the eyewitnesses. Okay, now you have a case. Now you have a case, and now you can present that. This is the problem with this case. Is that the state don't have a case. They're trying to establish a case while the trial is going forward. And again, they better be very careful, because in your opening statements, you said that the evidence is going to show certain things. So far, you have not done that. You have not done that. So it's going to be very, very interesting. Very, very interesting, because it's getting close to it being the defense's turn to be case in chief. And if their evidence, excuse me, if their evidence goes against your evidence, and it shows that you didn't have the evidence that you said you had, this case is over. Excuse me. This case is over. And we all know it should have been over. We all know that. But if it gets to that point, it's going to be over. So the state needs to be very careful, excuse me, with what they're doing. You're trying to use statements, gossip as factual evidence. That's not going to work. Because again, it's going to be so many objections, especially during the cross-examination with the examination of the prosecution. And there's going to be a lot of objections. And with the cross-examinations, it's probably going to be the same. And so, because you're talking about hearsay, isn't it crazy that the state has to lay foundation on some hearsay? I've never seen nothing like this, man. I've never seen nothing like this. This is, I'm gonna be honest with you. This case is way more educational than the OJ case to me. Seriously. With the OJ case, you didn't get a lot of this stuff. There wasn't no ex parte meetings. There wasn't none of that with OJ. All right. So this generation right here, this is their OJ. Okay, this is their OJ case. And the information in this case is absolutely insane. So I'm pretty sure when Brian Still come back, this is what I'm thinking. When Brian Still comes back from break, he's going to have a case law that states that you cannot use overt acts as a means to refer the jury to deliberate with. And I'm pretty sure, since we know that Miss Love has not turned over the stuff she needed to turn over yet, she's very ill prepared. And so, and I understand, and Sheely, I want to shout out Sheely because she's made a good point about the fact that Miss Love had Miss Hilton doing a lot of the stuff that's going on right now. So that's why it seems like she's not prepared, which I understand. But and I have to push back just a little bit. I can't rock with that. You are the chief. Not only are you the chief deputy assistant district attorney, but you're also the lead attorney on this case. And so one thing I know about, there's a difference between there's a difference between delegating and trying to control everything. If Miss Love, if I would give you that. What statement was? Let me go to the statement. I would give you this right here. I have to defend Miss Love. Miss Hilton was handling. I would give you that if she wasn't so controlling, but she don't know how to delegate properly, and I think that's the problem. Because if you're delegating, that means you know what everyone else is doing before they're doing it, because you know what you want them to do. So you're doing that. And if you're not delegating that way, it's not a good look. But of course I could be wrong, but I'm just saying, to me, that's not a
All
good look
right.
to do that.
If y'all have just now gotten the evidence that is gonna go with witness Sledge, I don't know if y'all are ready to tackle that right now or.
It can't be, because I'm
Yeah, that's
still,
true.
it's still sitting and uploading. So I'm on Dropbox trying to.
All right, well, what all is it? Because, I mean, presumably they've gotten it all before in discovery anyway, right?
Definitely have, and I can do that.
Yes.
I can address, Mr. Sledge gave a prior statement that's can be played on evidence reviewer, following his arrest for the 2015 alleged shooting of houses. He was arrested, as well as Mr. Zachary.
Okay.
I can address that. And there was one, on what Mr. Atkins said, there was one jail call that was identified, and I can address that as well. I don't know if there's more, but his statement I can address, the jail call I can address.
So those two, they have, he's correct, identified those and given them to those. The statement is the statement we mentioned earlier. And the jail call is that Mr. Shard is correct in those. And if we are ready to respond to whatever it is that they bring up while we're sending the rest of it.
Okay. The prior statement he made in 2015, he's brought in regarding the ag assaults, and he is questioned. He's Mirandized. He gives a statement. He denies any involvement. He later pleads guilty.
Okay.
Or offered, I'm not sure. He pleads somehow. He resolves it short of trial. He's just denying being there. So I don't know under what circumstances that statement would be used to impeach any testimony. I suppose he acknowledges that he knows Mr. Zachary. So I guess if he said he doesn't know Mr. Zachary, I guess that could be used to impeach him, but it doesn't seem to be a statement that would be used to impeach him or would necessarily be played. His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's his significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be. And he basically says, it sounds like witnesses 1, 2, or 3, and, or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's commenting, he's speculating, he's commenting about testimony he heard from a detective about what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
And Judge, the phone call would only be necessary if Mr. Sledge said something contrary to what he's indicating in the phone call. And I think a broader context, a broader sort of description of that phone call and what he says is necessary.
No, Ms. Love. No.
A few things are going on. Mr. Shard is correct. He's there is a prelim. He's talking about stuff that has happened. What is most important in terms of the preliminary hearings are that Mr. Sledge is he's privy to information that is given in other preliminary hearings of other YSL members. And he's aware that during his own, they are talking in terms of witness 1, witness 2, witness 3, rather than giving names.
Right.
What he says is, Lil D told, and Lil D is the witness that we've just finished listening to, Mr. Zachary. And he said, I can tell Lil D told because of, and he gives the information that was given by witness 1 or Lil D. He said, I can tell witness 1 is Lil D because he says this. So the fact that as he's discussing with his significant other, the information that he has learned while he's been in jail with other YSL members and in court, and he is not asserting that so-and-so lied or on Shannon. He is saying he threw Shannon under the bus, or they told on this particular person. That in conjunction with his factual acknowledgments in his plea agreement that he made when he entered a guilty plea in this case, we believe it establishes, 1, the nature of you do not tell. 2, he has knowledge that people did tell, and he is not saying this didn't happen. He's not saying this person just flat out lied. There's no way. And it also explains.
So how can you prove his information?
Why certain things may have happened. By certain things, this part is just an argument that would be made later. But if I were to make a statement in closing arguments that, of course, Mr. Zachary changed his story, everybody learned that he told, and he knew that everybody learned that he told, and now he's being looked at as a rat. So the call that Mr. Sledge makes and the content of that call are necessary for a number of reasons, and they become very relevant when put in the context of other evidence that we will be introducing at trial.
Okay.
So we can play the call for the court. We have it. It's a single 15-minute call.
This is terrible, man. He has information. Now, how can you prove his information that he has is true or not? You see, this is how we go down a rabbit hole when you start talking about evidentiary statements, when you don't have forensic evidence, when you don't have actual evidence. Now we got to go down a rabbit hole. Now we got to go down a rabbit hole to see if the information that this person said and that person said is true. This is what gossip look like. This is a rumor. This is what rumors look like. Jeez, oh Pete. Anybody ever been involved in a rumor? You got to fact check every last statement in a rumor to get to the truth. And then sometimes you never get to the truth, you know? So this is very sloppy work, man. This is very sloppy. This state case is very, very sloppy. Yeah, let's play this call. Let's see what this call says, because the way she explained it is like, what? What? So I guess they're getting the audio together to play this call.
Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement. Tablet.com. This during special moments as .net to learn more.
What you be telling Quanah for her to be doing all she be doing that?
Man, I ain't even talked to Kwame. I seen Kwame in the courtroom with Tip today. I swear to God, I ain't even talked to Kwame. I seen in the courtroom today with Tip. I was shocked when I looked back. Only thing what made me look back, cause when they first started calling the charge out, that nigga Peanut them dad punched the damn thing and got up and walked out. The folks did miss you today, man.
You know, Derek called me and told me everything.
What did he say about the bond, though?
He said,
Yeah, I'm
we
sorry,
gonna turn it around at the mall,
that is
so they
entirely
like that.
too muffled for me to understand what they're saying. I'm happy to listen to it at lunch if I need to, but until I can figure out how to hear it through Zoom, or, you know, if y'all want to, sometimes attorneys will bring another speaker, but if I need to hear what's being said, I can't from there. Sorry.
So I do have figures, but I'd rather test it and then, well, I can try and test it, but I can send it to the court.
I mean, if there's an interview we need to get through anyway, why don't we just do whatever the small, I guess, more discrete objections are to that interview.
So Mr. Sharp's characterization of the interview is correct. What he does during the interview is essentially he's telling the police, you know, you don't have to do your job. So there is there is no particular reason at this point that I see that we will be playing it.
Okay.
It is not, it's a statement that a witness has previously given, and if a reason arises, I just don't see a reason beyond, you didn't want to tell him until you,
Okay.
I don't see a reason that I'll be playing it, but it's his statement that he gave, and he's denying it. He's saying to them, do your work.
All right, well, Mr. Shark, do you know what the discrete portion of that is? And then maybe we can just see whether, even if she does maybe want to use it for some reason, she can say, oh, I'm definitely not going to use that.
I didn't identify any.
Okay.
Speaking for Mr. Still, Mr. Still was not mentioned in it.
Okay. All right, okay, so anybody else have issues with Mr. Sledge's 2015 statement that the state's probably not going to use anyway?
Mr. Williams,
All right.
if it comes up though, obviously
Well, okay.
there's nothing in that statement that is harmful to Mr. Williams,
Okay.
but, depending on the circumstances, we'll find out.
All right, well, anybody else? Silence from everybody else. Okay. All right, so as to the telephone call, is there anything in particular y'all want to direct my attention to? Y'all know what it says, even though I haven't been able to distinguish it yet. Or you just want me to listen for the whole?
I just object. I mean, it's Mr. Sledge reporting to his significant other what happened in his hearing that day. And I don't know this for a fact. I believe that he had the prelim. I believe it was him and Mr. Stillwell together.
Okay.
I don't know that for a fact. I could be wrong about that, but he's just commenting. The investigator Dennis, I believe, is the person. It may have been Thorpe, and I wasn't at the prelim. I didn't represent Mr. Stillwell back in 2015. And he's just commenting on witness 1, witness 2, and witness 3, and who he thinks they are, and his significant others commenting back. I don't know why the state would think, because Mr. Sledge, who they're saying wasn't even at the shooting of Donovan Thomas. Okay, they haven't charged him with that.
Right.
I don't know why they think that the fact that Mr. Sledge isn't saying that's a lie about something he wasn't even at is somehow a tacit admission against Mr. Stillwell. It makes no sense to me. And
Okay, no, I mean, that I can see the logic of it. It may be that on that issue, it is inadmissible and not relevant, but in terms of him being able to tell from what witness 1 says and doesn't say versus witness 2 or witness 3, that he knows who that is, it may be relevant to their whole concept of everything that goes on within this YSL gang. Everybody shares the information for, and, I'm tight with him and I know what's going on. So, which is one of the issues that they thought it might potentially be relevant for. Now, they'd have to have a reason to play it. And I think we're going to have to wait and see on that. But if that becomes actually why they're playing it, then I think I would overrule a relevancy objection to that if it's, legitimate.
I don't foresee any situation where Mr. Sledge, I'm fairly confident, is going to say that he knows all these individuals. He knows Mr. Zachary very well.
Yeah.
He was charged in a separate crime and pled guilty to that crime with Mr. Zachary. But even then, I would, even if it became relevant for that, which I can't foresee any circumstance, I would strenuously object to him commenting on other people's testimony about a case that
I
against my
understand.
client that he
Yeah.
wasn't even present.
I mean,
for,
I
according to the
understand.
state.
And it may be that, and I think even the state saying, I don't know that there are circumstances under which I would be able to get this in, this would become relevant. If there are such circumstances, then I would think that much less than the entirety of the phone call needs to be played and we can limit it then. So maybe Miss Love, if you are thinking, or it starts to look like you're going to need it, then if you can, get with the defense beforehand and y'all come to an agreement, understanding what my ruling then would probably be on what part would be relevant to that and what part wouldn't, instead of just, hey, I'm getting this whole 15 minutes in now. Okay.
Yes, I can do that. That makes perfect sense.
All right. Okay. So then anything else on Mr. Sledge's, the evidence that might be used with him at all that we ought to be looking at beforehand?
So the other items that we, and I've shared, if I don't know if anyone has been able to, if it has shown up, but I've shared the link with everyone except Mr. Howell, whose name just. Right. I see Mr. Howell.
All right, so what other evidence is there? There's the phone call, there's this interview, what else?
So there are also,
The fact that this is even labeled evidence is crazy.
the plea agreement, the video of the plea agreement of Mr. Sledge.
All right,
I don't, we have had the need to play other witnesses' plea agreements.
all right. Well,
What does that have to do with anything?
at this point, if he's testifying truthfully, then we don't have any need to play that.
right,
If it begins to intimate that I didn't know what was going on, it wasn't really freely given or
Right.
anything like that, then we would want to show him entering that plea.
okay,
We also have, and we may have already admitted this, we're checking the exhibits, but there is the video where Mr. Sledge is with Mr. Zachary, and they are threatening Kelvin Watts. We've labeled that, if we haven't already admitted it, as State's Exhibit 398 Yankee. There is Mr. Sledge's cell phone records, which we would be using or asking Mr. Sledge, is this your number? Was this your number at that time?
all right. And would that be the only purpose of the cell phone records?
Well,
Or you plan to be using the cell phone records to show some things?
to ask him about numbers within them. to the
Okay.
extent That he remembers.
Okay,
He doesn't, to ask him about specific
sure,
persons and numbers.
all right,
And of course, we have, Agent Bernie later on, who
is going to be able to say whose number is whose, I guess, right?
he'll be able to apply it. Now,
Okay,
we have Detective Dennis, who would be able to say, and ADA Sprinkle, who would be able to say what we determined was the owner of the
okay,
accounts for each numbers that are
all
relevant.
right. Do y'all anticipate, did the defense anticipate objection to that? No,
The defense is like, what is going on right now?
If he remembers his phone number? No, I don't.
okay. And how about the 398Y video being used with, I mean, are there, if it's already in, then the evidentiary objection's been dealt with anyway, but we haven't, I don't know where that list is right now. And he's in the video?
He is.
Okay. I mean,
We're talking about the video with Mr. Zachary and Mr. Sledge. I don't think that's in there.
Okay. If it's not, that will be 398Y.
uh-huh,
And Mr. Sledge, I believe during his interview, he talks about that.
okay. Is this like a music video?
No, it's a video, like a selfie video.
Okay.
Or someone filming.
All right.
Mr. Zachary, threatening Kelvin Watts.
Okay. All right.
If there's, we can play that, it's not too long, it's about less than 5 minutes long, probably about 2 minutes long. If there's a specific objection to that.
Y'all all seen it? Is there a specific objection that you know of now? Or that you know you might have?
Just want the instructions, I think that you talked about that when you did the 105, Mr. Williams is not in that video at all, and it's up to the jury to determine whether that should be.
All right, well, I mean, I keep asking for an instruction or a proposed instruction, and so far nobody has been forthcoming with one. So, and I've told y'all until you get me something to consider, there's not much that I'm going, the burden, the onus is on y'all at this point, okay?
I think we,
So, and considering this is our last day of court before we bring the jury back on
Brian,
Monday,
Harvey is frustrated,
now
dog.
would be the time to do it.
Your Honor, you should be receiving that shortly.
Thank you.
And Your
Harvey is so
with
frustrated,
respect to
dog.
the Video,
Oh, I
I'll just
feel
wait
him.
to see what limiting tricks, because it goes to count 1
Uh-huh,
against each of the defendants.
right.
So I'll just wait to see what the requested instruction.
Okay. So a potential limiting instruction, but with regard to anything else about the contents of the video, y'all don't anticipate an issue.
A video of
All right,
some
any other
threats.
evidence for him?
There's 2 social media posts made by Mr. Sledge on the night that Donovan Thomas was killed.
Okay,
And they are, one is Mr. Sledge is that night around the time of the murder, he's watching the Patriots, and he captions it that he's watching the game, Let's Go Patriots. And there's another one where he is shown watching the game
okay,
with his small child.
all right,
There is what we label Stacy Exhibit 399 Yankee. It's a video of Mr. Sledge. He is saying, if you go in the courtroom and tell, if you testify, it's not great. Basically, it's how do I say this? So you lie to your significant others, you lie to your family, and then you get in the courtroom and you tell the God's honest truth. Essentially,
mhm,
that's bad. I can play it. It's 13 seconds. I can play it for the court.
well, does the defense know the video she's referencing? Yes, it's already in evidence.
Actually, Mr. Williams's video saying that is in evidence, not Mr. Sledge's.
Okay. Maybe not in evidence. 399Y Yankee.
Lord have mercy.
And I'll just
All right.
share it so we can.
Okay, share it via Zoom. All right, a sec to get Zoom opened. All right,
The nigga lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people The God honest motherfucking truth. Pussy ass.
That's it. There's a word he uses at the end, but yes, that's the extent of that video. And this could be argued, it shows the sentiment that
You gotta be
YSL
kidding me.
members have towards, frankly, towards, people telling them.
Okay,
Object to that.
all right,
That may
and
be, that, I think this video, it could be argued, shows Mr. Sledge's sentiments. Mr. Stillwell's not in that video. He's not speaking for Mr. Stillwell. I don't know. There was no vote to make Mr. Sledge the spokesperson for this group of gentlemen, and I would object. Mr. Sledge is not sitting here with us,
okay,
so I
'cause
don't know how that's a comment.
He already pled guilty, right?
He did.
Did he plead guilty to the RICO count?
He
Okay. Y'all can cross him on that topic. What about the 2 social media posts with him watching the Pats game? Any contemplated objection to those? Okay, what else?
There's also a video.
Even actors looking at her like, what?
Not a video, but a social media posting that he makes on June 24th, 2015. Free little D, like right now. And that is, let me share it.
Is he saying it or is it just like a written post?
It's just a written post.
Okay,
It's just,
okay. Anybody anticipate objection to that we need to deal with now?
I don't know specifically what she's oh, is that it?
on the screen is the post. Oh.
On the screen is who?
I just don't know what the relevance is of some of these things. Like,
So 6/24/15, what's just happened? Why is he in? Why is the little D in?
This is.
Which little D is it?
Demetrius Garlington. And, he has been
Microphones.
arrested.
Jeez, oh Pete.
I can tell you the reason that we're wanting the relevance. of it.
Okay, what's that?
It's the urging of each member. We don't have just him. We have him saying free little D, free the other little D, free various members of YSL, as we have with other defendants that are currently on trial, where, for instance, when Mr. Winfrey was arrested, Mr. Williams had free Roscoe shirts, they're wearing it. So they're advocating for the release of their fellow gang members. And it shows their solidarity, their support for, and the existence of the organization.
All right,
I would more accurately, in my mind, say that he's posting free his friend, and to the extent that Mr. Sledge says he doesn't know Lil D from Mechanicsville, that's Demetrius that picture is of the Demetrius Garlington, Your Honor.
Okay.
To the extent he says he doesn't know him, or he's not friendly with him, or I mean that maybe that would become relevant, but
yeah, I'm going to permit it over a relevance objection to show or potentially show the issues that Ms. Love has said she would offer it for. And of course, y'all can argue that all this shows is he's concerned about his friend, but that's a topic for argument. I
Look at
think
Harvey.
it is relevant though.
Your Honor, there's one issue that I failed to bring up earlier.
Okay.
Regarding a video of a plea, and we dealt with this earlier in the trial, and I know that we did some redactions. I would object if they're bringing it in to show that if it becomes an issue and that a plea was freely and voluntarily entered, going through the Boykin rights and things of that nature, I would understand. Going through the state's factual rendition and their of the plea and just their testimony
All right.
and their story, we
Yeah,
would
the
object.
factual rendition, unless you have him then affirm, yep, that's what happened.
So
And unless he's now saying, nope, that's not what happened.
that part is.
It all just
exactly what-
depends on,
That's exactly,
okay.
yes.
So yes, I mean, depending upon the reason that the plea might end up being potentially used, yes, I agree with you. If it's to show voluntariness, then the factual rendition is not relevant, and I would not expect y'all to try to play that. If
So-
it is to say, dude, when you took your plea, you agreed that all of this is what happened, and he has in fact agreed.
That's not
yep,
true,
that's what
Judge.
happened,
When you take a
then
plea,
that's
that's
what I'm
not true.
pleading guilty to, and it's not an
That's
Alfred
not
plea,
true.
then
Nope,
then
that's not how
the
pleas
facts
work.
would be relevant.
Right. And
Nope.
so we've heard creative ways to sort of distance witnesses from prior acknowledgments that
Yeah.
they've made. So some may have expressed a lack of an understanding, or some may have expressed
Yeah.
feeling pressured. And then during their plea colloquy, they actually shut it down and
Yeah.
were.
Okay, so yes, but understood. It's not necessarily all in, it is just going to depend upon the reason it's being offered. And just as with whatever the, reasoning for the phone call, and I'm not going to say this as to every little piece of evidence. This just needs to be how y'all operate going forward. At the point in time when you anticipate, oh, I actually am going to use this. I didn't think so before, but now I am, or whatever. You tell them so that they can, so that all of
This
us
is
don't have to be
crazy, dog.
scrambling, okay?
Okay.
Advance notice to the other side about things that you know are likely to be evidentiary issues so we can deal with them at an appropriate time and not be sending the jury out every 10 minutes.
And so, Judge, we will definitely
This is
abide by that instruction. And I guess we'll ask for more granularity, a little bit more clarification if in the middle of questioning.
Obviously. And I mean, that's why we're kind of going through all of this now, is so that most of it you're already going to know in the middle of questioning. Here's how I can use this. Here's the part that needs to be redacted out, whatever. But, like for one of them, you said, I just really don't anticipate in any way using that. And then you're like, oh, we're in the middle and we take a break at lunch. You tell them at lunch, at the beginning of the lunch, yeah, I'm going to use this after all. It's just as much heads up, as much advance notice as possible. And given that you are supposed to be providing all of the evidence in detail for, the first 30, and I think you're almost to the point where you're supposed to provide it for the next 30, this shouldn't be an issue. But, okay. Mr. Harvey, you wanted to say something?
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
I mean, who is this that's commenting? 70 likes, one comment,
Okay.
come
All right. So I agree with the prior ruling, and I don't know that this is
Free
how
and
you
true.
were gonna
I would-
present it on the stand when you use it. This just may be how you got it now. But make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope,
a
you're not
sticker.
going to share it as you're going
No,
to present
share
it. You're going
with
to
the
share it
defense.
with each tranche of 30 witnesses. Okay. If
Oh,
you
yeah.
know oh, somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay, yes.
Okay.
But the comment that is made by the witness, which is on the left side, that we would do on the screen.
Yeah. Mr. Harvey agrees that, yes, he's talking about the likes and comments and what have you on the other side. Those don't need to be included.
I was
Okay.
in agreement with him.
All right, super. Thank you. Everybody's in agreement.
So the next one, Your Honor, is the post on June 15th, 2015, where Mr. Sledge is saying free Jimmy Winfrey and FUXK12 and KANT, hold the real one down. And he tags Mr. Williams on the left side.
Right.
So this is absent the comments on the right. This is the post that we would.
All right. And if you already have that as an exhibit number, you can tell us now. Otherwise.
It states exhibit 401 Yankee.
Okay.
And the exhibit number, as we have it listed, is up in the upper left corner, almost imperceptibly.
Oh, all right.
Quite see it.
Okay.
Does the court want me to just keep going?
All right.
So
I'm not hearing any objection.
The next one is State's Exhibit 402 Yankee.
All right, we don't, if you've got a series of free XYZ, free ABC, and they're all pretty much the same, then I don't need to see them all right now. They're all going to be the same issue, and you can do that.
Okay. This is not saying free anybody, but it's saying happy birthday. to
Okay.
Mr. Stillwell.
Okay.
Stop putting me on fucking fake pages, cause I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see me to? I'm here. I don't hide, and I do not run for fuck niggas. You did.
Your Honor, this is relevant, and we would seek its submission for you hear the comment, but then at the bottom underneath the photograph, it has FR for real 100 100, and then the two little green snake emojis.
Yeah. Which are alleged to be a YSL gang symbol. Okay.
Yes.
Yep.
We've already admitted the content, the group photo that is now labeled states 405 Yankee, but because of what Mr. Harvey pointed out, that we had taken out comments. I was not certain without looking back at it whether the YSL, FUXK, the rest love had been admitted. And for that reason, I sought to admit the whole post, since this is the witness that made the
Okay.
post.
All right, well, you can go back and look and see. Let me ask y'all, with regard to these things that are electronic as we look at them, are y'all printing out a hard copy and using that?
No, so we are in fact giving to the court reporter and showing to the defense contemporaneously with
Y'all
publishing
just showing
to
it
the
on the
jury
screen.
digitally. Yes.
Okay.
There,
And so I guess the reason I'm asking is, so whenever you used 405Y before, how do you now know whether it contained the comment at the bottom or not?
we have given the court reporter hard copies.
Okay.
That is not the case with all of the exhibits that have been tendered. We have, but that's how we know what.
So y'all can go back, well, you can go ask Ms. Weaver on 405Y, does it contain the comments or not?
Right, we can go back and it won't be labeled 405Y. We have the list of the exhibits and we have the description.
Okay, well, whatever it was labeled at, let me ask you this. If it was labeled 205Z before, and now and we find out that it does in fact contain those comments, you're not gonna re-tender it as 405Y, right?
No.
That's only if it doesn't contain the comments.
Correct.
Okay.
And definitely to the extent my colleague is expressing that the court may not understand me to be saying explicitly that we are printing our exhibits that we have tendered and shown digitally. And we have given to the court reporter the physical printout of any digital exhibits.
Okay, the physical printout as well as the digital exhibit, right? Or by the end of trial, you will.
Right.
Right,
For the
okay,
digital.
that's fine. And I know that Ms. Weaver, and whenever we get probably in a couple of weeks that the jury's gone, we'll take up, let's figure out what evidence is actually in and out. Maybe that's what we'll do that week. Not the whole week. We'll get lots more done than that. But I do know there is an issue with regard to a couple of defense exhibits because they were only shown, I think, on a laptop, and we'll just have to sort that out at some other time. But we do need to think about going forward. If you're walking up to a witness and showing them something on your laptop, you might need to take a screenshot of what's on that laptop so that then the court reporter knows what it is. Okay. All right. What else?
This is a similar
All right.
social media post.
All right, so I'm gonna basically rule generally, unless you think that there is something particularly, oh gosh, I think that there's gonna be some other kind of relevancy or 403 objection to something. The posts that are just seeming to show his posting about gang life or indicating gang insignias or anything like that, those would be relevant. And if you think there's some kind of 403 thing as to something, then pull that up. But I don't need to go through every little bit of evidence. I want to be hitting the evidence that you think the defense is going to have an objection to that we need to hash out beforehand.
I don't, so
Okay.
there are 3 videos
Mhm.
that are also social media postings. I
Okay.
don't see anything that would be 403 there. For instance, 416, Stacy exhibit 416 Yankee has Mr. Sledge. It also has Mr. Williams and other alleged associates or members of YSL in it. And they are sort of just congregating and
Okay.
I can let.
Yes, Ms. Love, we
Since
know
I
that
shared it,
they're,
I can let defense
we know
look
they
at
know
it.
each
It's
other.
labeled in the shared document as well.
All right, well, and ideally, again, after they've
Hmm.
got the big list with the 30 and all of the exhibits, then they can do their homework and they can actually tell me, like Mr. Sharp did for Mr. Zachary's statements, hey, here's what I find objectionable about that. So once y'all got that, y'all can do that with everything and it'll be more smooth. All right, so but you think that pretty much for Mr. Sledge, after what we've discussed, you'd be good to go, and the defense likewise. Okay.
I do. I have shared with the defense just the case that is like the printouts from Mr. Sledge's federal case. I
Okay.
don't foresee, I'm not going to try and tender that as evidence. There may be a portion of it that I reference or need to reference, if depending on how he testifies, to refresh his memory or something, but I'm not going to try and enter his federal case as evidence. And I think that's it.
Okay.
Mr. Sledge. And his certified copies of the conviction, his proffer, his factual acknowledgement, the physical documents, those we have labeled as states 394.
Okay. All right. I've gotten the proposed limiting instruction now. And Mr. Matthews, you are requested in my other courtroom for the trial calendar. You know what that issue is? So can you run up there to the judge handling that case real fast? We'll recess I'm probably just going to stay here, but we'll recess for 10 minutes. It shouldn't take longer than that. And I'll take a look at this proposed limiting instruction. All right. And then we'll come back.
All right. They are in recess for 10 minutes. I'm not too sure if I want to continue to look at this, man. I'm gonna be honest with you. Some of this is just downright ridiculous. I don't understand why she's allowing some of this stuff into evidence. I don't understand why a video of a person saying, "Hey, man, I don't hide. I don't run from nobody," and da 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 da. Why? What is that relevant to when it comes to evidence towards the indictments that you all are accusing these young men of? What does it have to do with Donovan Thomas? You've established already that YSL you have established already that YSL is, or in her case in chief, is a gang, according to her. You have established that for your case, even though if YSL is a gang or not, it doesn't matter. So you've established that they all know each other. Okay, great. How much more evidence do you need to establish that they know each other? You go into social media, you're doing all kind of craziness here, So I don't necessarily get it. Mr. Harvey, man, Brian Harvey, as you can see, is very frustrated with this whole situation. And I understand why. I could tell why. Because a lot of this stuff has already been talked about or been perused with Glanville, where they went through some of these. And now that I'm looking at it again, I remember, I'm like, oh yeah, we already saw those postings and things like that. And she tried to implement the comments and things of that nature to show solidarity. Same excuse as before. The same thing she said to Glanville, she's saying to this judge, trying to show solidarity of YSL being a gang, which is still not illegal to be a gang. However, but she's trying to show solidarity again. We are in what month of this? This is day 108 of this trial. So that's a nice period of time. As far as trial dates are concerned. This case has been going on for the last 20 months or so, and you are still trying to show solidarity between YSL. I just don't understand. Somebody help me in the comments, please. I'm lost right now. I can't get, I don't understand. What are we doing with this? What are we doing with this? These statements don't have a lot of foundation. You're trying to use an overt act that has statute of limitations on it as a way for the jury to deliberate a ruling on a case that, quite frankly, has some statute of limitations in it as well. However, you was able to catch it within a nice period of time. But I mean, especially Marquavius Huey, his case, it's like, yo, I don't even know why he's sitting in there. Honestly, I don't even know why he's sitting in there. This young man had a case that he was already convicted of or whatever, did what he had to do. Then the prosecution saying, hey, that charge that he got that had nothing to do with RICO. Now they're saying, oh, it does have something to do with RICO conspiracy. And we're going to indict him and charge him for that. And then arrest him for having a firearm that was unrelated to YSL RICO conspiracy. He's been in jail since what, 2021? Early 2022, 2021? He asked for a bond in 2022. I remember that. The bond got denied, I believe, by Judge Whitaker. Then he asked for a new bond because of circumstantial changes, which is Judge Whitaker again being a new judge, new trial judge, and his bond got denied again. And nothing has been proven that Marquavius Huey did anything. Lil Rod, they don't know him, right? It's like I don't understand. This case is so sloppy, dude. This case is so sloppy, man. It's I don't know what this judge is thinking. I really don't. I don't know. We got did we all has anyone seen Brian Steele's motion to the amended motion to disqualify Love and Hilton? Because we might go over that today too. Because he had some links in his motion. He has some links in his motion that show specifically certain things that the prosecution has been doing that has prosecutorial misconduct in there. And he has the link also to where she showed Brian Steele's name in a slide. And he has the link to that. He put a lot of different YouTube links inside of his motion against the prosecution. So we might go over that too. I mean, it's a 10 page I believe it's a 10 page motion. And I think I'm looking at it right now. It has some links in here. There was another motion that he did where it talks about him working with the prosecution, how it's been a horror. It has been a horror, to say the least. Let me see here. See what else. Oh, you haven't read it, Sheely? Sheely said I haven't read it. Yeah, he made a motion. Yeah, he made the motion here. I'm looking at some stuff now, guys. Just give me a second, please. Yeah, so he said something. He said something that was so like this is what he said, you guys. Hold on, give me 1 second. Let me go ahead. Since they're in since they are in a quick quick recess. Let's look at something real quick. This is the latter part of his motion. Let's see here. So I want to go to number 4 real quick. See if you all can you all see this here? Oh, that might be too big. Y'all see this? So this is Brian Steele's motion, right? That he amended to disqualify lawyers Love and Ms. Hilton. And number 4 talks about the enormity of violations of candor with the court, candor with the counsel, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hilton to continue as lawyers in this litigation. Okay. He said he said the below is just a touch of the constant misconduct by Love and Hilton in this case. And he starts breaking things down. Recently, lawyer Love filed a motion with this honorable court. The undersigned counsel had a duty, quote unquote, to provide work product. Lawyer Love knows that same is untrue, and that the cases that she cited in said motion did not support the propositions of law that she asserted in the motion. So then it says here, this was the 4th time that lawyer Love raised this same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on this exact same issue. And then she gave, now I saw this link here, and this is the link where it goes to, she tried to present it to Glanville. Okay, I'll check it out, Sheely. I'll check it out. Okay, I'll see what get the new motion from Bruce Harvey. Okay. Thank you for letting me know that. The ex parte motion for order to compel testimony necessary to public interest. No defense lawyer on this trial had any connection or involvement with Mr. Copeland on or around June 6, 2024. This is a knowing misstatement by Laura Love, because she did say that. Look at this. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27, 2023, so that objections could be made prior to presentation of the opening statement. On Friday, November 24, 2023, at 4:58 p.m., Lawyer Love shared her supposed demonstrative aid. During opening statements at trial, Lawyer Love showed a completely different demonstrative aid in violation of the prior court's order. There has been no consequences for Lawyer Love's intentional, unethical, and continued misconduct. During the same opening statement, Lawyer Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undersigned counsel had represented another person charged in this case. Specifically, in her PowerPoint, Lawyer Love showed the jury that undersigned counsel represented co-indictee Blaylock. Y'all remember seeing that, right? In the opening statement, where that's the first motion for mistrial that happened, I believe, was that day. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of his arrest on September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence as Mr. Bean never went to Grady Hospital on September 11, 2013. He has the link for that. Lawyer Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally knowingly false. He has a link for that. Mr. Williams, over Mr. Williams' objection, when the state was attempting to introduce January 26, 2015, social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the prior court that only Mr. Williams' voice could be heard on this audio, except for one other voice saying yeah in the background. Undersigned counsel told the prior court that Lawyer Love was incorrect and that several persons' voices were audible on this social media posting. Lawyer Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, Lawyer Love was proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. Okay. This is the footnote. Lawyer Love never introduced the evidence on her table. Never introduced it. This pattern of prosecutorial misconduct. I'm telling you, this is the word. This is the word. Let's highlight this, dog. Can we just prosecutorial misconduct, man, illustrates the enormity of unethical conduct of Lawyer Love and the state of Georgia in this case. He has a link for the prosecutorial misconduct. On Thursday, June 6th, as well as Friday, June 7th, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. Again, this was another knowing, malicious, false allegation by Lawyer Love as she continues her unethical conduct. And on the June 10th, Hilton, Love, and the recused court attempted to hide Brady evidence from Mr. Williams and the other accused that was obtained during the unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that everything he says is a lie, that he committed all of the crimes in the indictment and the like. These statements are impeachment of Mr. Copeland and are squarely within the concept of Brady versus Maryland. Moreover, Hilton and Love, with the assistance of now recused judge, told Mr. Copeland that he would not get in trouble if he lied under oath unless he told a bold-faced whopper of a lie, that he could not be prosecuted based upon some erroneous theory that the statute of limitations has run, and Mr. Copeland would have to remain in custody until all 28 co-inductees cases were resolved. This is all unethical conduct in order to intimidate, coerce Mr. Copeland to testify at trial. Watch this right here. The above does not truly encapsulate the horror of working with Miss Love and Hilton. Oh, it doesn't encapsulate the horror, the disdain. Jeez, oh Pete, man. Not to be able to trust the prosecution to provide the simplest and most basic fundamental fairness, such as honesty to the tribunal and honesty to all in the courtroom, must mandate that both lawyers Love and Hilton be disqualified from this case. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask this honorable court to grant the above requested relief. He said it does not truly encapsulate the horror of working with lawyers Love and Hilton. Respectfully submitted by Brian Steele, YSL Steele. Look at this. I could tell, even when Brian Steele speaks. All right, Dre, I see you got the link to Harvey's motion. Oh my God, I got it. Okay, we got to do this too. We got to This is awesome. This is awesome. Hold on, let me go ahead and see if I can get this real quick. He said that it doesn't even encapsulate the horror, man. It's been horror working with them. Horrible. He doesn't even want to come to the court. Remember he said something about, man, I used to love this. I would die for this. Remember when Brian still said that? I would die for this. I don't even want to come to court. I don't even want to come into court anymore. I got you, Drea. I appreciate you, girl. She said, I'm in between chat. You over there with Cat too? You chatted over there with Cat too as well? I'm pretty sure you are. Lisa said, wow, exactly. Have you ever seen, let's think about this for a minute. Have you ever seen a lawyer, forget if you're a prosecutor or forget if you are defense. Have you ever seen a motion with this type of language in it? With this type of disdain? You know what I'm saying? This is absolutely wild that he has this level of disdainment. It's absolutely crazy, man. It's absolutely crazy. He said, I am so sick of this court. I'm so sick of coming to court. I don't even want to be here. I don't even want to be here. She has violated all kinds of misconduct. All kinds. She has done, listen, remember the time where she tried to input some evidence at the last minute and her and Judge Glanville was going back and forth? And that's the day where Judge Glanville was like, I'm going to exclude this. I'm trying to do Glanville's voice. I'm going to exclude this because I told you this was going to happen. I told you. Your Honor, I just was no, Your Honor, see what you don't understand. And we talked about it this morning, and then that's Glanville in Love's voice. If I did it right, put a 1 in the chat if I did it right. Put a 1 in the chat if I did it some justice. But that day, everybody was like, what is going on in this trial? Because she was going back and forth. And you remember, he rushed her to be quiet because he started bringing in the jury. So the jury was coming in. Y'all silly. Y'all put 1s in the chat. The jury was coming in, and he was like, don't speak anymore because the jury about to come in. It's a wrap, right? So that was the day. That was a day where she tried to implement some evidence in the last minute in a very untimely manner. And that's another issue. That's another issue, is that you are not showing any candor to the court or to the counsel on submitting the evidence properly. That's what I'm saying. This whole thing has been sloppy, and she thought this was going to be a cakewalk because Glanville was the judge. Glanville was, I believe, endorsed by one Fonnie Willis to be the chief judge of Fulton County. So now the chief judge is recused, and now you're trying to play the same game with this judge, but you're doing it in a way that you're trying to do it in more of a nice, innocent. You're trying to show a level of, sincerity, or you're trying to show and act like you're being authentic, but you're not. The judge is seeing right through this lady. And that makes, with this Harvey motion, that makes what, four unanswered motions now that need to be addressed. Since he couldn't, and Brian still is smart. He's like, okay, I made the motion to disqualify lawyers Love and Hilton because there are witnesses to an ex parte meeting. There are witnesses to something that was improper according to the Georgia rule. Now I'm going to amend it and say, oh, by the way, they also don't act right. They also don't act right. And they don't do what they're supposed to do. And here it is, the defense, we're always forthcoming with what it is that we're going to do when they bring us something, but they're always bringing us something last minute. They're trying to ambush us with evidence at the very tail end, so that way we don't have enough time to respond to what we object to or whatever the case may be. And so by the time they come to court and they have this, they present this evidence or they present this question to a witness, the defense haven't had enough time to peruse, to go over what that was so they could object to it. It's total misconduct and it's total abuse to the counsel. So there's no way that there's no way they should be on this case anymore, man. They have lied and lied and lied. They have done some last minute stuff. They have coerced with a judge, man, with the chief judge. They have coerced. They're trying to put things in evidence right now. They're trying to say, hey, this dude says something that is in relevance to some knowledge that he has. So we want to be able to utilize the knowledge that he has in this case as evidentiary statement. But then you have to prove the knowledge that he has is true or not, which means you got to go down a rabbit hole. You have to go down this rabbit hole in order to find out the truth. If you would have actually built a case against them, against the defendants, with some forensic ballistics, okay, with some actual evidence that can bypass what somebody said. You're not doing that. So, with that being said, since you don't have the ballistics and the things of that nature, like the real evidence that ties them to anything, they got rid of guns. My man said, I don't know where they get rid of the guns at, but most of the time they keep them. But I don't know how they get rid of guns. I mean, we went to OG Bentley spot. Ain't that what he said? We dropped them up. We dropped off the ones I know about was at OG Bentley spot. So how do they normally get rid of the guns? I don't know. You tell me, investigator Dennis. I don't know. I'm trying to figure it out too. I mean, I know they keep them most of the time. But I don't know how they do this. So, so it's not you're not adding up to anything that's concrete, man. So you already got a sloppy case. Then on top of that, you're going to act a fool on top of the fact that you don't have a good case. You don't have a case at all. On top of the fact you don't have a case at all. You're going to act a fool too towards me, the defense. You're going to ambush me with last minute evidence so that way I won't respond in the proper time because you didn't give it to me in the proper time. And then by the time we get to court and I say what Miss Love haven't done, and then the judge Glanville said, well, next time be prepared. To me, Brian YSL Steele, you're telling me the next time I need to be prepared, and you said it in front of a jury when he doesn't have to be prepared to do anything but respond to whatever he object to when it comes to evidence being released over to the defense. Judge Glanville owes Brian Steele a huge apology publicly, because you just accuse this man of not being prepared for something when he's not case in chief on top, first of all. And secondly, the state was not ethical and timely in their evidence that they were sending over. Whether the evidence made sense or not, anything that you say is evidence in this case that you're going to use, you got to give it to me. So I can say, you know what, I object to this, I object to this, I object to that. That way, evidentiary statements like this whole procedure don't have to be done one by one, precept by precept. All they should be doing right now, the only things that they should be doing right now is going over the things that they disagreed with. All the stuff they agreed with, that should be already admitted. Already admitted. All right, let me go ahead. I'm talking too much. Let me go ahead to the chat real quick. Okay, Dre, you said, let me go to X real quick. You said something about I follow my man Joseph too. Check this link out. Okay, hold on. Let me go ahead and check this out. Check this link out. Okay. Let's see here. All right. See here. Okay. Proposed majority instructions. All right. Go ahead real quick here. Let me pull it up. I appreciate you, Dre. Everybody put Dre in the chat real quick. Show love to Dre real quick. Show love to Dre real quick. All right. So we do have the motion here. I'm gonna move it over. I'm gonna cut and paste it here real quick. Yeah. I'm gonna open it up. Yeah. All right. Hold on. Let's see here. Okay. Sorry, guys, just getting everything together. Dre just hooked us up with some information that I do appreciate very much. Oh. Let's go ahead and blow this up real quick. Well, let's blow this up real quick. Since they still shucking and jiving. Let's go ahead and blow this up real quick. Kablooski. All right, this is X. This is Joseph Papp. I follow Joseph Papp on X, man. He's a excellent I would say journalist or investigative journalist. I'm not sure if that's the proper term. It says here, attorney Bruce Harvey has filed his proposed limiting jury instructions that he has been mentioning for the past 2 weeks. Okay, here we go. So let's go ahead and look at it. Can everybody see this? Can everybody see this? Put a 1 in chat if you can see this. Let me go ahead and see if I can bring it a little closer. Here we go. How about now? Let's see if we can get it closer. Okay. That should be good, right? Put a 1 in the chat if you can see this. This should be good. So we are here on Joseph Papp's. Again, it says here that attorney Bruce Harvey has found his proposed limiting jury instructions that he has been mentioning for the past 2 weeks. Okay. Says here he filed it at 10:45, about an hour ago, Eastern Standard Time, about an hour ago. And it says here in the Superior Court of Fulton County, State of Georgia versus Quamarvius Nichols. Whew, that's a name. Proposed limiting jury instructions. Let's see what it says. This is our first time seeing this, y'all. Hey, shout out. Yo, short and sweet. Shout out to Dre, man. I appreciate you. Look. All right, let's get into it. It says, I instruct you that some evidence may be admissible as to some of the counts or some of the defendants, but not admissible as to other counts on other defendants. In that regard, evidence related to certain alleged acts specified in count 1 of the indictment may be admissible against those defendants on trial charged in that count. However, I remind you that in order for you to use such evidence against those defendants not alleged to be involved in the counts under your consideration, you must consider whether the alleged acts for which the evidence is being offered have been proven, okay, beyond a reasonable doubt, to be part of the overall scheme alleged in count 1. Exactly. Wow. Wait a minute. Exactly. So basically, listen, if it has nothing to do with the alleged, you can't consider it in that particular count. If it actually does, and it actually does, it is what it is. We can't dispute the fact, but we can dispute the fact that you can use something else that has nothing to do with the alleged and try to use it as evidence against that person. Beyond reasonable doubt to be part of the overall scheme alleged in count 1. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to evaluate the credibility of the witness testifying. Who you think you talking about? Everybody put Woody in the chat. Hey, I love me some Bruce Harvey, man. Put Woody in the chat. Put Woody in the chat. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to evaluate the credibility of witness, but not as proof of the matters asserted or against others not alleged to have been involved in the events being testified about. That is, prior inconsistent statements are offered for the limited purpose of determining the credibility of the testifying witnesses and not to prove the truth to the statements made. Lil Woody, he's talking about Lil Woody, okay? You cannot use, oh man, good job. Put Bruce in the chat. Good job. Good job. Good job. Good job. Good job. Good job. What'd you say, Lisa? Lisa Butterfly says, though I am very biased towards the defense in any case due to the inherent advantages that the state receives, it's not that I want killers to go free, but I want fairness and justice, and this ain't it. That's true. Now, I'm gonna tell you something though about that in a minute. I'm gonna say something about that in a minute because I had to rethink a little bit as well. So I've kind of modified my thought process. Everybody put Bruce Harvey in the chat. Bruce Harvey's laid it down. As a matter of fact, he laid it down right here. Yes, he did. Yes, he did. Yes, he did. Yes, he did. He laid it down. He tore that up. He tore that up. This part right here is very important. It says here, let's go about this real quick. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to evaluate the credibility of the witness testifying. Okay, right here, he's basically saying, look, when you deliberate, you got to remember that if you're going to deliberate, you got to use something that has credibility. If you're going to use a witness's testimony as something of fact, you have to be able to deliberate this in a way to say, okay, has this witness or testimony that this witness given, is it credible? Is it credible? Right? Is it actually credible? Can it actually be used to complement evidence? Because that's basically what a witness testimony does. It's supposed to complement and correlate with evidence. So that means that what happened and what you saying happened, and if I have evidence of what happened, your testimony, if you're the prosecutor and I have you as my witness, your testimony is going to complement the evidence that I have produced. That's the way a witness testimony should go. Not using a witness's testimony to build my evidence around their testimony. That's not how that goes. And that's what Bruce Harvey is saying. It's like the state is doing it backwards. Even though I know this is jury instructions, but he has said this before about this. But he's saying it in this sense that do not try to utilize or deliberate a person's testimony as evidence, especially if they have had what? Prior inconsistent statements. Right? So it's right here, but not as proof of the matters asserted, not as proof. This is not proof. The person's testimony cannot be used as proof that of the matter that's asserted or against any alleged to have been involved in these events being testified about. That is prior inconsistent statements. Prior inconsistent are offered for the limited purpose of determining the credibility of the testifying witness or witnesses, not to prove the truth. So we have to make that distinction with the jury. Because, hey, let's go. Let's just say it. The jury has been off for how long? The jury has been away for how long? Weeks. And so, look, I'm all about fairness too. Now see, this is the thing. You got the prior inconsistent statements going on. It's been a month. Okay, so D. Pill said it's been a month. Okay, so it's been a month. So the jury been off in a month. Do you think for 1 second that this jury has not watched YouTube, Associated Press, Law and Crime, 11 Alive on YouTube, The Lead Attorney, AV to the 7th Power, Class E Beats, Paralegal, Nick Starro or Cat Not Williams? You think the jury hasn't had none of that in their YouTube algorithm for a month, for a whole month? That's what Bruce Harvey said. Hey, Bruce Harvey said, good luck proving that any of the statements is true, dog. Good luck. There you go. There you go. They have seen it all. Absolutely not. You mean to tell me the jury has not been looking at this case? This is the most televised case. This is the most televised case in recent history. The most popular case in recent history. Even though we just had the Karen Reed, we got the Richie case, we got things like we have things. We do have things. Karen Reed case was one case that was like really, 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 I would say popular, talked about. But this Young Thug case has been talked about for the last few years. So the thing about it is, I agree with Lisa Butterfly that said, I'm not trying to free anyone that's unaliving folks. That goes without saying. You know, that goes without saying. But you cannot utilize corruption or be corrupt to invoke to call it fairness in the name of the law. You're trying to do something in the name of the law. Now you're using it in vain. You can't say, oh, well, the reason why I had this ex parte meeting and this, that, and the other is because, well, first of all, why are you having ex parte meetings? That's the first question. So you can't, so you cannot utilize corruption as a tactic to prosecute a defendant, because Here we live in America. And here in America, it says that we are innocent until what? Proven guilty. Okay? We are innocent until proven guilty. This is not how it works. You can't just say I did something and then you be corrupt towards me to prove that I did something. That's not how this works. So it's about being fair. No, who's to say all those counts are accurate? No one knows. No one knows. You can't say that. So that's the thing with me that I don't like or appreciate is the fact that you're trying to be corrupt in order to say that we're doing it for justice. Just like Fonnie Willis said, my first thing that I'm going to do is attack the gangs and attack this and attack that. Okay, that's fine. You can do that. You can do that all you want. But what you cannot do is be corrupt while you try to do that. Again, the law becomes now you upholding the law in vain. Now you're doing it in vain. Since they are on court in lunch, we're gonna go over this. We're gonna go over this. Wait a minute. Hold on, Drea. This motion was filed March 19th, 2024. Hold on. Let me look at something real quick. Here we go, man. Antenna's going up now. Let's see here. Let's see. All right, we're gonna go to Thugger Daily real quick too. See what's going on over there. Oh yeah, we talked about this. Check this out. There was remember the young lady yesterday? She said something. Was it yesterday? Yes. Where she got up and said something about do not serve yet on one of the on one of the pieces of evidence. So there's a portion. Thugger Daily posted a portion of that motion that Brian Steele made back in September. And we're gonna read it real quick here before we get into the other motions here. Hold on, we get that. So Dre, if you're watching real quick, the link you gave me, the link that you gave us, let me see here, because I'm looking at it now. This is a motion that was made back in March. Oh no, it was the can you all hear me? So my mic is breaking up. Can you hear me real quick? Put a one in the chat if you can hear me. Okay, great. Sorry about it. It's probably too close. I have to sometimes push it back a little bit. All right. Thank you all for letting me know. So let's see here. Check something out. Okay, let me see here. So this link, Kendrick motion, that was back in March. Okay. Okay, so the motion with Okay, got okay. I see what happened now. Okay, when I clicked that link, it went to the Kendrick motion back in March. So it directed me to a different place. But we got what we needed. Gotcha. Okay, we got what we need. All right, let me go ahead and drop this then. So they are still on. They're on a lunch break right now. Court will be back at 1:15. Cool. All right, court will be back at 1:15. And I saw a video yesterday. Where it talks about Miss Love and her inability to be prepared. And I want to shout out Paralegal for the video. I'm gonna actually put the link to the full video. See here. Share this link to this video. Yo, man, this is crazy. This is crazy, man. I mean, look, Bruce Harvey is a beast. Bruce Harvey is a beast. I mean, I totally understand. I mean, I feel him. Like ain't nowhere in the world, man. You can ain't nowhere in the world you can utilize Woody's testimony for anything. Woody lies so much it's ridiculous. Lisa Butterfly meaning to say your hat game is on point. Well, I appreciate it. You know, hey, listen, I appreciate it. You know, us boys from Detroit, baby girl. We fedora it up. You feel me? We fedora it up. You feel me? You know, I know I live in Indiana now because of my career in IT and all that kind of stuff. But I'm telling you, in Detroit, they call me, that's my nickname here. They call me Detroit. That's my nickname here. Well, I'm representing the 313 all day. I appreciate the compliment. Thank you so much for the compliment. All right, we're gonna get into this real quick, right? Because when I saw this video, I was like, yo, I want to talk about this while they on lunch because it's been going on for too long. She never know what I'm talking about. Yes, right. That's right. Now look, I want to read this real quick. Okay, so right here, this is the motion. This is the motion that Brian Steele had made back in September of 2023. It says, why did the prosecutor refuse to serve all discovery in June 2022, along with complete statutorily proper witness list as promised? Who made this decision? And who was aware of the decision to instead piecemeal discovery all the way through the end of September 2023? Here's what the young lady said from yesterday. Who made the decision and who was aware of the decision by the prosecution team to intentionally do not serve yet so that the accused would be blind to this mandated discovery until over 14 months after the district attorney's office stated that all discovery was ready, organized, prepared to be shared with the accused? So, like, this has been going on for how long? This is exactly what the young lady was saying. It's like, yo, this has been going on for a minute. And so that was a do not serve yet piece. So Brian Steele actually filed a motion about this, about the fact that they do not turn over discovery or evidence in a timely manner. So I wanted to play this real quick while they are on break real quick here, so we can go ahead and dissect. My bad. There we go. Go ahead and dissect this video real quick while they're on lunch. Lisa said, I hope if I were ever put in a position like Woody that I'd be able to lie my ass off as well as he can. I listen. Look, and told the judge, hey, I testify. It depends on how I feel Monday. I'll let you know. I'll get back with you, judge. I'll let you know what I want to do. I'm gonna let you know the day of. I'm gonna let y'all squirm. I want to shout out hold on before we get started. I want to shout out Paralegal Institute of Washington channel who made this video. The full link to the video is in the chat. If you want to watch the whole thing, we're going to just go through and dissect. It's about a half hour or so. We're going to go through and dissect through a few things here because it's important to understand. Because see, the reason why this stuff is so important is because it can happen to any one of us. Real talk. Any one of us can go through this. Is that better? Is this better? I guess it's better. Any one of us can go through this, right? Any one of us can go through a situation where you can be accused or whatever of something, and you haven't done anything, or they have no evidence that you did anything. And so what they'll do is they'll stockpile evidence on you to make you think that you did something, or they will ambush you with some type of phony evidence to make you think that you did something and you didn't do anything. You see what I'm saying? Hence the plea deal. And that's the one thing about what Judge said about the plea deal. Plea deals doesn't mean that you are just because you take a plea doesn't mean that you actually did something. Okay, because a lot of men or women who are in the system have taken pleas, and the plea that they took it, and the prosecution know they don't have enough evidence to accuse them of anything, but they take the plea because they are coerced to take the plea. Because if you don't take the plea, you're going to be in jail for the allotted amount of time that constitutes or warrants that particular charge. So that means they can put you in jail and charge you without having evidence being presented to the courts or anyone. So, you know what I'm saying? So you're charged with something, but you're not convicted of anything. So now you're in jail, but you're not convicted. So a lot of men in the Fulton County jail, they're charged with crimes, but they don't have any representation. So they got to sit in jail. And these particular crimes may have a certain amount of a bond on it, and they can't afford bond, and they can't afford an attorney. So what do they do? What do they do? They put you in jail, they put you in that system, and they say, okay, you got to sit here until there's an attorney present or a public defender for you ready. And then you like, okay, well, when you gonna get a public defender? And the public defenders are like, yo, I got 650 cases. I'm not even gonna get to that person. How much? Case 651 is this RICO trial case, for instance. This defendant that's a part of this. They can't afford an attorney. When are they going to get one? And the public defender is just the other side of the face of the system, of the court. Like this, the good side is the prosecution and the judge and all that kind of stuff. Then the other side is the public defender, but they all work together. They all work together. They're all in the same thing together. There is no difference. There is no major difference. You know, just like one side of your face may have a mole. Like I got a mole on this side of my face, right? Or this side. This is my mole on this side. So this is the defense, and this is the prosecution. You know what I'm saying? But it's still my face. That's all it is. A public defender is just a government employee. It's just a face. It's just a face of the other side. And they cooperate with each other and they make deals. And that's how they get their money. That's how they get paid through taxes, through the taxpayer. And so they putting people in jail, and they giving people pleas. And these people who take the plea, they're like, man, I ain't got no choice but to take the plea. I can't afford an attorney. I can't retain an attorney that would do private practice, because private practice, he or she gonna give it their all. They don't have any bias. You know what I'm saying? Well, they have a bias, of course, to the client, but they don't have any type of I would say mendacity in a sense. Okay, because they're strictly for the representation of their client. With public defenders, it's a little bit different. Yeah, they represent the defense, but they also have to comply with the state in a lot of instances. Ricky E, what up, though? He said, Tay Biz, I appreciate you, dog. So it's unfair across the board. And this is the reason why I'm enjoying, I don't want to say it that way, but it's fascinating that this case is happening in real time, because we're starting to see all the itty bitty bits and pieces of things. And we're getting a chance to see the language, like sua sponte and all this kind of stuff, and ex parte and all this. Like, you know, we're starting to see things and be like, yo, this has been going on for how long? You know? So it's interesting. Now, this video is awesome, man. And so I want to go ahead and play this video. We're gonna get into it real quick. I'm gonna stop talking so much, but we're gonna get into it real quick, and let's go ahead and see what's up here. All right. See how he break it down.
If they're not really rules. They're just aspirational.
All right, I understand.
Y'all remember this interaction between Lawyer Love and recused Judge Glanville? We'll keep this in mind, because this interaction and others like it that happened during the course of this trial, someone's going to refer back to it today, and you're going to see what happens a little later.
Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning.
That's
this morning. Ms. Love said this morning. You've been having this case for how long? And now you want to Hansel and Gretel the evidence? I think not. This was a big blow up this day.
Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. I'm going to exclude because.
Hey, I'm sorry, y'all, but Glanville got a little sassy, didn't he? Hey, I remember this. The Glanville got a little sassy, didn't he? Glanville said, I'm gonna exclude that. Because I told you. Glanville had a little spice, and it wasn't nothing nice. All right, okay, I'll stop.
Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded.
Look at her face. Look at her face.
Well, this morning.
That's too late. The evidence is excluded.
Why you say that shit? Why did you say that? Dang, you Andrea Love.
Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
There you go.
All right.
No. I'm going because I told you this is going to happen. No, madam. No, I'm going to. I told you. No. He got spicy. The boy Glanville has some spice that day.
Evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention.
All right.
You had no intention to use the evidence. Now you got some intention to use it, and now you want to last minute give it to the defense. Come on, man.
We're not here to introduce the PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not gonna tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take colleagues, I am not gonna tolerate this any further.
This is why Hilton wholesale usage of the evidence. Okay. Now this is why Hilton is going to get away from this chick. This relationship right here. This you see that relationship right there? This too? Skip this dude. He's sassy. But this right here, it's a wrap. Like this is when I knew, like, okay, yeah, there's something going on in the house. Because she keeps messing up. And so you're not going to just last minute throw some evidence in. And he said, while the jury is sitting in a box. What does that mean? Now, this is the only time where I gave Glanville a little bit of okay, good job. Because if we can scold Glanville, we can also praise him at certain times. So I gave him praise on this one because it is disrespectful to the jury to do this. It is disrespectful to the jury. We know it's disrespectful to the defense. We get that. But it is definitely disrespectful to the jury. These people have basically paused their life, their livelihood. They got to come to court every day. They can't go to work. They're getting paid. What is it? Is it like $25 a day or something of that nature? According to the law, if you've been summoned to the court for a trial and you are part of the jury, you're doing jury duty, you can't be fired. But this trial has been going on for months. November 2023 is when the actual trial started, I believe, right? Or the trial started around that time. January, something of that nature. And these days, like when you see days like day 108 of the trial, we're talking about business day. Okay. We're talking about business days here. So it's a total slap in the jury's face for you, the prosecution, who represents the people, to have, and excuse my language, to lack of better words, half-ass do your job. My taxes is paying you to make sure that my community is safe. And this is what you give us. You give us a poor performance, laziness, a lack of accountability, and you give us attitude and you're spicy all the time instead of taking your position more serious. This is unacceptable. This is why he said, I'm glad he said, while the jury is sitting in the box, because in other words, you're wasting their time, not just the court's time, not just the people's time, but you represent you're totally disregarding the jury. That is why that's why I gave Judge Glanville a little bit of a hurrah with this one, because he was right on the money when he said that.
If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them, we'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Watch this video to the end if you want to just sit back and relax and see DA Love squirm. Today was one of probably the most blatant example of not being prepared, of not having done your job properly, of just, I'm not going to say misconduct, but of prosecutorial non-preparedness, unpreparedness, lack of preparedness. And Whitaker held Love's feet to the fire, and Love squirmed all throughout this entire morning into the afternoon. So if you want to see that, watch this entire video. But I will warn you, as you see how this unfolds, you're going to say to yourself, wow, I wonder what the penalty for all of this is going to be. I wonder what Whitaker is going to do to the prosecution for all of this. So I'm going to tell you, you will have to wait as well till closer to the end of the video to see what kind of penalty Whitaker is going to mete out to the prosecution. You may or may not be surprised. So sit back, relax, watch this just incredible turn of events. I've edited it down to just about over 30 minutes. So again, get yourself comfortable and just watch how all of this unfolded in court today.
David's in support of seeking the contents of cell phone, or did you not need that because you had the wiretap stuff already?
We because no one had any contact with the person himself, we never had access to contents of his cell phone, just his cell phone.
Okay, so when we were saying cell records, it's essentially like location information.
Yes.
Okay. All right. So can you get me the affidavit in support of that, please, to review? Yes, sir, Mr. Short.
Your Honor, regarding the state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear.
Okay,
There's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case.
It was.
And I can state in my place as an officer of the court, upon information and belief, that I've listened to pretty much all those calls. I don't recall in any calls in the wiretap where that number's involved, anyone ever saying any government name that would put us on notice and say, oh, that's DeMarco Boyer's number. So we've been pretty diligent.
Okay, so Ms. Love,
Yes.
what do you say about that?
I'm not refuting the person's name. I'm talking about the phone number whose records we turned over being present and the content of his conversations and communication.
Okay, so do you have the affidavit available?
That's what I'm getting.
Potentially by the time of the affidavit, but certainly by the time the cell records were secured in the fall of 2023, you knew that phone number was connected to DeMarco Boyer, true?
That is true.
Okay, so is there a way that the defense was supposed to have also known that that phone number was connected to DeMarco Boyer?
If the court will permit me 1 second.
Go ahead.
So here Love is going to check her cell phone. She's going to look under a rock. She's going to look under a rug. She's going to do everything to try to find the information that the judge is asking her for. So we have a little bit of a break while she tries to find the information that basically everybody feels she should have been prepared with and ready to go with. But she's going to look under a rock and a rug and try to find the information.
Yeah. So, I'm not looking for the wiretap affidavit. I'm looking for the affidavit to get Mr. Boyer's cell records. I don't assume that was served in discovery, was it?
I'll check. The reason that the phone records weren't served was that they were considering arresting him.
This is crazy.
So the answer is no on that one.
Two things, Your Honor. First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly,
now that's a great point. That's a great point. Remember she said that the day before. She literally said that the day before. Let's go back to that. That's a good point. That's a very good point.
First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state.
Yep. Remember, she was like, "Oh shoot, we should have just, oh shoot, oh shucks, we gotta turn this over." No, we never intended to. What?
Hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
And I reached out.
Sorry about that. Sorry about this. Yeah, Lisa, it was court yesterday. I was unable to go live yesterday. I was multitasking yesterday. I was had a busy day, but I was also at Cat Not Williams channel yesterday. So there was court yesterday. A lot of evidentiary statements and stuff like that. And this interaction, this is the way court started yesterday. It literally started like this yesterday. Okay. Where the first thing was trying to get, because the day before about the cell records and the cell location, all this kind of stuff, the day before, she said that she inadvertently didn't give out the evidence. And then she asserted yesterday that she never really intended to do it, to give the evidence. That wasn't her intention. And then she had a realization. Then she tried to say the realization wasn't hers, it belonged to somebody else. It was somebody else's realization, to get her to actually turn over everything, because they didn't get they had this one piece of evidence that they just got Monday. And they're like, and the prosecution been sitting on it since 2023. So that's what that was. So yeah, so my bad. I wasn't live yesterday, but yeah, but I was at Cat Not Williams channel yesterday. But this is pretty much how court started yesterday.
To the investigator who got that last night. That person hasn't provided information to the court in this chart as to what is happening to the lady that on their end.
Is there some reason that can't just be shared right here and now?
They're trying to do a murder.
They're trying to do what?
Work a murder that is underway or being.
Okay, then it seems they should pass off the responsibility for getting the affidavit to someone else. Okay, so I understand that well, let me.
I have a question real quick for you all. If you have an affidavit available, can't you have affidavits available by email? Because they e-file in Georgia. You can e-file an affidavit. As a matter of fact, I know you can, because when Brian Steele had his 253-page motion about the recusal of the judge that was trying to recuse Judge Glanville, he added his affidavit to the motion, and it had an e-file date on it. So yeah, as long as they're notarized, you can have, as long as they get it notarized and they notarize the copy and they make a copy of it, you can literally keep that in the email form. You can send that through email. Why don't you have an email folder for just this? I mean, am I off? I might be off. They'd have to be done in person, I think, but there's no reason they couldn't provide a copy that was e-file. That's what I'm saying. Exactly. Okay. Everything she asked love did not have it. Exactly. That's facts. Might even been able to do a Zoom notary these days. I'm not sure. I know that if you notarize, anything that has to be notarized has to be done in person. I know that for a fact. You can scan a notarized document and email it to somebody. You can actually, not only that, you can actually scan a notarized document and put it in a folder and put that in a shared drive. Okay, again, real quick. I was a municipal tech before. Okay. I've seen these documents. Municipal tech. I did IT for the city. I did IT for the police department. I was doing IT for the fire department, IT for the emergency staff. IT for the judge, IT for the mayor. Okay. Yes. There are plenty of times where they would do things in person, but they would scan whatever they need to notarize or whatever the case may be. They would scan it and put it in a folder. And I know I'm not off here because they would always lose the folder. It's like, oh, I had my folder in this location on my computer. Now it's somewhere else. And it has very important notarized documents in it. And da, 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 da. Then I'm able to find it. Then they're like, oh, thank you so much. You're a lifesaver. Da, 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 da. Right? So I know that if you are handling notarized documents, you can scan them. They have scan to email. I know I'm not too off on this. They have scan to email where I have set it up plenty of times where I would go inside the print server and I would make sure that I add the person's email to the address book in that print server. So that way, when they scan a document, it'll go straight to their email so they can send it to somebody that's on the other side of the damn world. So I know for a fact that you can scan to email and you can send it over to someone. So you didn't do that. You don't. So what were you trying to find? You should know where it's at. And nowadays, even in a lot of courts, they're moving over to shared cloud networking. So one thing like Teams, Microsoft Teams is literally synced with OneDrive. So if you have a folder in OneDrive, it links and syncs to your Microsoft Teams. So that means that your entire team can see whatever you put in your OneDrive, even in your personal drive. As long as that folder is linked to the team, everybody can see it. And if they have access to that folder and access to those files, and they have the access to edit them, read and write, and do all the edits or whatever, then you can everybody that's in that team can see it. So you should have it organized to a place where you can pull your folders, even archive them. You can have an archive folder, pull it from there and say, you know what? I got the affidavit of this search warrant here. Boom, send it over to them real quick. But you didn't do that. And this is the reason why he's talking about prosecutorial unpreparedness is because you didn't do that. Exactly. Okay. That's how it is in my office. I'm telling you, man, I've been doing IT for over a decade, man. I'm telling you, there is no way you can, even if you do need to find it, because I mean, archive folders are, it depends on how far back you go. But we're talking about 2023. That was last year. And it wasn't even it's not even been a whole year, I think, or maybe it has. But last year, 2023 is when we had the affidavit. There should be folders for each year, and there should be breakdowns in that. Like you have one main folder that might say 2022 YSL case. And then inside that folder, there should be subfolders. And those subfolders go to certain things, affidavits, motions, state responses, boom, boom. Like you should have these things prepared. That's why Judge Whitaker is like, well, and there's something you could do right now at this very moment. At this very moment, you should be on your computer just sending it to them right there. You have their email address right there in court, and then they get the email. Okay, now we have it, Your Honor, right in front of the judge. So this is the part that's kind of like trippy. It's a little trippy. It's like, wait a minute. How come you don't have this on command? It's an affidavit.
I understand that I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent. And this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked the court yesterday, so allow me time to speak with team members.
Right.
And
Wait, what? They're both? What? I missed that part. What? So you inadvertently did something and intentionally did something at the same time? What? Wait, what? Hold on, am I off?
Him. So which is it? Whether Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
thank you. They are both. I asked the court yesterday, so allow me time to speak with team members.
Right.
And the information internally that I know is that
Just call me 3J. What up, though, man? Salute to you, my brother. Appreciate you watching. I appreciate you watching. Everybody put just call me in the chat. Just call me 3J in the chat. Or just call me J. Just call me Jay. I'm sorry about that. Everybody put just call me Jay in the chat. Welcome him into the chat, y'all. Say what up to him.
when the phone records were initially secured.
In the fall of 2023?
Yes, yes.
Okay.
When they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial.
Do you know when the decision, if there was one, was made? Okay, we're not going to get a warrant for him after all.
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there's still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. We're chief that person wants a warrant. So there's not the decision to obtain the warrant has not been abandoned. The
Okay.
efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And it wasn't time progressed. It was in our possession.
Mm-hmm.
It occurred to team
Hold on,
members.
ladies, I got a question. Ladies. Because Miss Love was talking, right?
We need to give this over. And it wasn't time progressed. It was.
Okay, what was that? What was she catching in the air right there? What was she catching in the air, yo? Y'all saw that, right? What was she catching in the air? Look at this.
We need to give this over. And it wasn't time progressed. It was.
What was she just snatching? What was that snatch? Hey man, I'm telling you, dog. There is no way Lori Love is. Listen, what was that snatch, ladies? Ladies, only you all can answer this question for me, okay? Only you all can answer. What was she snatching? I need to know. I got another gentleman. I have another gentleman in the chat. Just call me Jay. Ricky E is in the chat. We need to know, what was she grabbing as she was talking? Okay.
We have this. We need to give this over. And it wasn't time progressed. It was.
That snatch is crazy.
Mm-hmm.
It occurred to team members. This is something we can't wait for a warrant or arrest on. All of that is true. And I would have to consult with our team to see when they ask that those records be plotted. Because at that point, I know that would be something that, at least in our minds, we're thinking, we could use this. So I can get that date as well, the date that they were sent over to be plotted.
Okay. Because, I mean, do you think?
Hold on. That was her credibility flying away. She wasn't catching anything. That was her attitude. No, she caught something. She caught something. That was her attitude projecting through her hands and not voice. Exactly. She was snatching something out of the air, man. I don't know what y'all be snatching sometimes, man. I be snatching dreams. What's going on? What y'all be snatching?
Think that it's reasonable that at least by that point, you should have shared that information with the defense?
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier. At least, so initially there was this belief and understanding that there was this investigation that would lead to an imminent additional person charged. That has not occurred. And there was the realization that we have in our possession this data that we need to turn over.
All right. So in the meantime, let's keep.
Put a 1 in the chat if all of that was lies. Put a 1 in the chat if all of that was lies. Hey, Sheely, you be safe over there now. You said the thunder's roaring. You be safe. Please be safe. All right. Was she lying? I mean, listen, when you are, it's one thing to be an habitual liar. It's another thing to be a pathological liar. I mean, it's possible. It's possible. You're like 1 1 1 1 1. It's another 1 1 1 1. Yeah, it's very possible that this is very possible. About 95% of that was lies, and then about 5% truth. But all of this, again, because the waters are so muddy, nothing she says is clean enough. Nothing she says is clean enough. Okay. And so this is the problem, is that she tries to weasel her way through everything, and because of that, it causes the attitude and the spirit of it to be fake and phony. That's what it basically does, in my opinion, in my humble observation, I would say.
Plodding through this set of statements of Mr. Zachary's.
Can I ask a date or a date certain for the court to inquire of a date certain on this issue before you?
On the getting the affidavit and the search warrant?
No, I'm just, I'm sad saying that. I'm really hurt saying this, but this is not new. So a date when Ms. Love just said, oh, shoot, this is not a quote, but something effective. Oh, shoot, we must turn this over. That was before giving it to Agent Bernie. So what happened on that date of the oh shoot to we get it yesterday and we don't get it like, oh, this is new stuff.
Good question.
So we are one team, but we have many members and parts, but I will get the date, but I can tell you that.
Here we go. We're going to start indirectly throwing people under the bus here. We're one team. We have there's many parts. It's one team, but many. You the chief deputy, assistant district attorney. This is your case. It doesn't matter. This is her case, man.
That when I said that there was the realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out because it was not mine. It was not my.
We're gonna find out. Really? What you mean? Really? What you mean? Find out? But
realization occur.
I will find out because it was not mine. It was not my realization.
Okay.
So I'll find out. What I'm saying is,
who's in charge of the team?
I am. And so before it's mine, generally speaking, I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
All right.
No, ain't no collectively. You realize it. See, this is how you know. So you gotta be careful with people like this because they will throw you under the bus, and you had nothing to do with it. It's they would throw you under the bus. You have done your part. You done the part you were supposed to do. Okay, you have done the part you're supposed to do, and then they'll throw you under the bus. How many times have you had a manager, a boss, a supervisor, or whatever, give out and delegate or give out instructions? Not delegate, because delegation is actually taking accountability and responsibility and actually doing something. But a manager or a supervisor gives you an assignment to do something and gives a bunch of people assignments to do stuff, and they just go ahead and do it. Then all of a sudden, when it's time, when the team doesn't look right and it's time to take accountability for the team, the supervisor want to throw you under the bus. They want to throw you up under the bus. And like, yo, I did my part. I submitted what I needed to submit. When the opening, this is how I know it's her. This is how I know it's her. The opening statement, she didn't even turn that over. It was her statements. All the evidential aid in her opening statement was supposed to be given to Brian Steele. She was supposed to leave out the fact that Brian Steele represented a potential person on this case before or whatever, and it had his name up there. So that's misconduct right there. But also, you didn't give over all of the evidential aid. I know it's her, the one that didn't realize it. I can almost guarantee that somebody in that office was telling her, "Hey, we need to we need to turn this over. We need to do this or do that." Instead, what she do is she'll just throw you an assignment and just be like, "Okay, that's it. Now you go ahead and take care of it." And if something go wrong, she start looking at you instead of her actually being a part and delegating. Okay, to delegate, I mean, that means that you are getting involved enough to where it satisfies the project. Okay, I'm gonna put you over this project. I'm gonna work with you until this point, and then I'm gonna let you do your thing, and then I'm just gonna delegate from there. Okay, so you're supposed to have weekly meetings. You're supposed to have something going on. Okay, what we got this week? When one of my IT managers, when I was first getting into the game, we would have weekly meetings. This is a little bit early in my career. We would have weekly meetings and to see what has progressed and things of that nature. And if someone said, "Hey, we need more time or we need more involvement with this or whatever," he wouldn't mind helping out and doing things to make sure that the project went well. So even though he's delegated, he's also getting involved to make sure that the project is going good. That means doing some research. That means also implementing some solutions, some things that we may have overlooked. He has more access to certain things than we do, so maybe he can go into the depths of his access and get some stuff. Those type of things. Those are the type of people you want to work with. Not a person who's just bossy and controlling and say, "Hey, I told you to do this. I told you to do that. I told you to do this. I told you to do that." And then if something doesn't go right, then all of a sudden it's on you. They want to put everything back on you. But that's unfair treatment. Now, she thinks she can give that same unfair treatment to the defense, to the judge, and to the jury. Not today. Not today at all. Yes, her title. Yes. Here it is. Look, Chief Deputy District Attorney. No, Assistant District Attorney. Or Chief Deputy District Attorney. I'm sorry, that's right. And in 2023, her salary was what? 165K? 167K? All right. 15-year veteran in the game. She's been in, actually, I think she was to be she was also a judge, I believe, in the juvenile courts at one point too, something of that nature. Anyway, it's some details about her that I fairly know about. But she's the Chief Deputy District Attorney of Fulton County. She's right up under Fonnie Willis. It's Fonnie Willis, and then it's Adrian Love. And Hilton is the Assistant District Attorney for Adrian Love and for Fonnie Willis. you're the lead on this. This is your case, essentially, Miss Love. So this is the stuff that needs to be going on. You need to be a little bit more present. You need to be present with your case.
And you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Yes, this weekend we were talking about it and we turned it over.
All right. So sometime over the weekend is when the realization occurred. Oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over.
Oh my gosh, it has not been turned over and we need to turn it over.
Okay. And you're getting us the information about when we get the affidavit in for the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense.
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. Right? I mean, obviously not, since you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So we weren't thinking along those lines then.
Okay. Have you at any point provided information that the phone number that y'all all know about from the affidavit and the nickname, which I think that's what it was, you were going to tell me what the nickname was, is actually DeMarco Boyer. Did you ever before Monday share that information?
No.
Okay. All right. What was the nickname? Unk.
You haven't shared this lady. This lady is absolutely insane. This lady is absolutely insane. When did the realization happen that you needed to turn this over to us? Oh, it happened this weekend. We were all talking. And like, oh, well, we had a collective realization. Okay. A collective realization. Oh, we got this very important potential Brady potential Brady evidence. Potential. It has potential. We don't know yet because they ain't seen it. It has potential Brady evidence. Okay. And so, but we haven't turned it over. We've had this evidence since 2023. And we realized over the weekend of August, what is this? This is because this happened yesterday. So of August, the weekend is the third, the second, the third, the fourth weekend. You just now realize that you didn't turn this over. You're full of it, ma'am. Your whole team is, but it's really incumbent upon you because you are the chief deputy. You the lead attorney, right? Like the lead attorney. You the lead. You the one that's supposed to be doing this. You feel me? I ain't supposed to. The defense just get this evidence, and this is crucial evidence because it can determine the location of who was there at this particular time in this particular area, which has potential Brady evidence, which could exculpate the defense. You don't want to. You didn't want to turn that over. You just realized you done had this since almost over a year. Almost. You just realized you just had this. You like, oh man, oh shoot, we need to turn this over. No, this judge ain't playing with you. This judge asked you, do you have anything else? Do you have anything else to give to the defense that you have not given them? Here we go.
Listed on, I think in the wiretap, I think it's
okay.
May I step to the door once more?
Yeah, and before you step to the door, is there at this stage, which is mid-trial, anything else, whether it's Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
Definite silence.
And you may want to huddle with whomever.
That pause was nasty. That was nasty pause, dog. Yo, that's a nasty pause right there, yo. that insinuates a yes. It insinuates, yeah, Judge, I think we got more stuff that we haven't given over. First of all, this is nasty work. Okay. Everybody put nasty work in the chat. Put nasty work in the chat. This is nasty work. She said, is there anything else? Anything else? That whether it's Brady or not, just evidence. Do you have any evidence or information that you intended to give to the defense that you haven't given yet? Anything else? And there was the longest pause between her and that judge. Are you kidding me? Are you kidding me? Nasty work. This is terrible work. Again, prosecutorial misconduct covers more than just behavior in the courtroom or behavior in a sense of well, this is just bad behavior just within the trial or a court or whatever. No, talking to a witness without their attorney is prosecutorial misconduct. Withholding evidence is prosecutorial misconduct. Ambushing evidence is prosecutorial misconduct. Not providing evidence in a timely manner is prosecutorial misconduct. And asserting your emotional gestures and behaviors like Ms. Love have been doing the whole case is prosecutorial misconduct. Behaving that way in the court. You are out. I appreciate you subscribing. Just call me Jay. You have literally single-handedly confirmed why we do not like prosecutors. Flat out. Y'all got absolute immunity and y'all just do whatever you want to do. And this is not the first time that they've had this conversation with this lawyer about this case. This is absolutely insane. Nasty work. Do you have anything else? It doesn't even matter if it's Brady or not. You're not supposed to, whatever evidence a prosecutor is intending to hold or to intending to use in a trial, that prosecutor is supposed to give it to your defense attorney, all of it. Now, if your defense attorney finds out that this prosecutor withheld some evidence that did not get to him and it can exculpate you, then that is Brady violation. Withholding exculpatory evidence. But prosecutorial misconduct is withholding evidence in general, whether it's exculpatory or inculpatory. It doesn't matter. You're not supposed to withhold evidence that you said you're going to give the defense. You have to, because you have to, that evidence has to be approved. So you approved all this evidence stuff for that. It's nasty, though.
Comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch. Okay, can you do that? Okay. Yeah, just we'll recess in place until you come back from whatever you're going to find out at the door now. Thank you.
And in searching through the discovery that has been turned over with respect to the representation that I made to the court about the number being on the wire, within the discovery that was served in 2022, the phone number that we've gotten the records for and the last name of Mr. Boyer is provided within the Sumlin-Dorsey conspiracy. And I said wiretap. There are 2 wiretaps that were gotten. This name and this number appears in both, and the name for the number appears in the Sumlin wiretap.
All right, and you produced that to the defense as a part of the Sumlin-Dorsey conspiracy package of discovery in 2022. Is that what you're saying?
Yes. You distilled that much better than I said it.
And do you have anything more specific than that to point out to show Like exactly when that discovery got served?
I just,
Okay.
the second,
Hold on one second, y'all. This is a good point. This is why Morrissey is the prosecutor that was on the Rush trial, was completely laid out by Judge Summer in the Rush trial, even though she believed it wasn't exculpatory. This is a good point right here. It wasn't up to Morrissey to decide that. That's the whole point. Exactly. Bingo. It is not the job of the prosecution, even though the prosecutors know that a prosecutor will know the difference, but it is not up to the prosecution to decide whether or not evidence is inculpatory or exculpatory. My hand. It is up to the jury, is up to the courts, especially. And when the court find out that this evidence is exculpatory or not, there should be a hearing about it. This is the reason why, if you're going to present a motion of something like Brady material being withheld, there is an immediate hearing that takes place, which took place in the Alec Baldwin trial, and they discovered that it is exculpatory evidence. And Morrissey got on the stand and said, hey, the reason why we put this evidence under a different case number basically is because we didn't think that it had anything to do with anything, when you know it did. It's the same. It was the same type of casing and everything. You put live rounds in blank casings that had similar looks to them. And now you're going to say, well, that evidence, we're going to withhold that. We're going to put it on a different case number. But she sanctioned it. She sanctioned it to do that. She knew that that evidence had something to do with the Russ case. And she purposefully put it under a different case number. And she had prejudice against Alec Baldwin, which was discovered as they asked questions. But that's the whole point, is that it's not up to you to decide whether or not something is exculpatory or not. You're supposed to just give over the evidence, period. Everything. Every single thing that you get, give it to the defense, period. That's how you do that. I mean, it's just ridiculous.
2022.
All right.
And the folder specifically that the number and the name appear in the discovery served August 2022, it's folder 1, counts in indictment by act at 181 through 182, Sumlin, Dorsey. Count 55, 181 through 182, discovery 2, Dorsey conspiracy. And it is the 1, 2, 6 call down.
Okay.
As on it, and I will submit this as states 1 for the purposes of today.
Okay.
It has the phone number 470-957-2893 - Dorsey and Boyer.
All right. Okay, that appears to clear up that issue. I am not going to make a blanket ruling at this point that it can't come in and rebuttal either, because y'all got time. I don't know if it might need to be used or not. I don't know, but I'm going to leave that for another day if and when it does come up. Now, with regard to this second sort of chunk of information that's just been produced, Agent Bernie's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with.
Okay,
It's
as to the, okay, so what do you say as to that, Ms. Love? Because if y'all have already presented your evidence, what's your plan with regard to Agent Bernie's report and analysis?
Your Honor, would the court permit me to address the first part regarding the Boyer records and get tender the evidence and then address?
Yes.
The second
Yes.
part of the motion? Okay. So the state is tendering for the court's consideration states 2A Boyer records, which is the affidavit for the search warrant, and states 2B Boyer records, which is the search warrant itself for the cell phone records. And the court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor, I am marking as State's Exhibit 2C Boyer records.
It is a screenshot of a search of the wiretap data for the number of calls that involve 470-957-2893. And the number of calls within the wiretap that involve this number are 501. So
Okay.
I'm tendering this for
Okay.
court's consideration.
All right, thank you. And 1 as well as 2A through C are admitted. Okay, turning now to the Bernie
set
matter.
of plots regarding the Little Wayne bus shooting. The data, the cell phone records, and their cell site location information was turned over, I believe, in July of 2022, if I'm not mistaken. I'm almost certain that we turned it over in the first set of discovery that we served.
Okay.
So the data that the plots are derived from have been in defendant's possession since July of 2022. The plots that were made at the request of our office were requested after testimony and cross-examination, testimony elicited from through direct and cross-examination of our witnesses in the Little Wayne bus shooting.
Okay.
As a result of some of the questions and answers and the direction that we saw that questioning going, we asked for the plotting of the.
And when did you ask for that?
I'll get an exact date.
Give me a ballpark.
Jeez, oh Pete, man. Here's another example. I know we talked about Ms. Bumpus, right? But here's another example of how you just don't know how to retain information. This is all you're doing every day. You should know when you asked for something, when you requested something, when you said something, or you should know, at least like the judge said, give me a ballpark figure. You should have a guesstimated idea. But you don't, but you're just, because, and this is what it looks like when you just hand over assignments to people and you don't get involved. Delegation and dictatorship is two different things. And this is what a dictator looks like. Even though Hilton is gone, you should not fold this bad this week. This has been a terrible week for the prosecution. I mean, terrible week. Put a 1 in the chat. Come on, chat, help me out with this. Put a 1 if you think it's been terrible for the prosecution this week. Been terrible. So I don't understand the way she operates when it comes to her retaining information. You need to retain dates, and because all those things are important. All those things are important.
Give me a ballpark.
Give me a ballpark. June.
When did these?
In the last 6 months, that's the narrower ballpark because things were delegated and we did.
Okay. When did these people testify to the Lil Wayne shooting? When was that testimony roughly? January, June, April? Okay. So at some point after April.
Yes.
Okay. Let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved. We've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway. Go ahead and plot this too.
Yes, that would be. Yes.
Okay. Why was that not done?
Uh-oh.
So
you saw her walk around that desk.
Bernie did not test.
Hey, Ricky, you saw her walk around that desk. She's still on that runway, dog.
So Bernie did not testify about these. He has.
I know.
Okay.
Why wasn't it done, love? Why?
Your Honor, if I may, I'd like to give the court first the more precise time that we got those records.
Not when you asked for them, not when you got them, when you asked for them.
That, yes. Before I go to that second question with the court's permission.
Okay. Go ahead. How long is it going to take to get that information? Can Mr. Christian work on getting that information?
It's already been worked on. I already
Okay. I mean, will the answer differ based on when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice. And we did not, but I don't have
a good answer. I mean, and the answer could be because, man, there are only 24 hours in the day and this is chaos. And, you know,
Objection leading. Objection leading. Don't tell her what her excuse is. Or it could be the fact that she just didn't do right.
doing the best we can. That could be your answer. I don't know. It's still not a good answer, but let's just maybe nip this in the bud. Because I did ask you also to, at the lunch break, huddle with your team and see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial that it would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use?
Judge, I used the lunch break to get that information I gave to you earlier. We are feverishly getting that.
All right. So all right.
Right now, what I have for the court is that Racy testified on between May 13th and May 16th. So I need to clarify that. Okay. And the defense challenging him and as I said earlier, the questions and answers and the follow-up cross-examination elicited during that time period, May 13th and May 16th, is what caused us to request them.
Okay, that's fine. Okay, and essentially you acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing. Okay. Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it. Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or we are going to use it, here's the result. And that is going to be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of in progress, tell them about it. Okay. And moving forward, as things come up, when you decide I'm going to be doing something about this, tell them about it, okay?
Yes.
So what amount of time do you need to get with your team and figure out, is there anything in process?
Friday at 5 too late? Or you want me to do
Friday at lunch? Okay. Well, okay. I don't know what our Friday is going to look like, but yes, you can share it with them without it being in court. So yes, Friday by lunchtime. And you can just copy Ms. Percival or whatever it is you tell them. Okay. All right. And
how much you want to bet that she ain't going to turn it in until Friday at 5? The judge said Friday by lunch. Watch. It's going to be Friday late. And again, here is another bone being thrown to Ms. Love. All right, here we go. About to get back in court real quick.
Emailed over the lunch break some proposed jury instructions, which I've been able to see on my mobile phone, but because we're having internet issues, hopefully IT can work some magic and let me see on my actual computer. You can move the I think had sent over something. Then there were two things, I guess, like an initial and then a revised suggestion from the state. Has anybody else sent anything?
And Judge,
Oh, wait, no, that's not.
the suggested instructions sent by the state dealt with the.
Right, Mr. Copeland, how to handle Mr. Copeland's thing.
Yes, I have a response with respect to Mr. Harvey's request. but
Okay,
not
if you
a-
want to email that to Ms. Persfield.
It's not a suggested response, suggested instruction. It
Right.
is a response that we should not give an instruction and the reasons why at this point.
Regardless, I haven't seen it, so if you want me to.
I was gonna orally, but I can.
Okay, that's fine. If it's not in writing, that's fine. I thought you were, I maybe misunderstood you. I thought you were saying you had sent something over, but no, if you just want to orally say, here's why I don't like Mr. Harvey's instruction and why we shouldn't give one, that's fine. I think if we do give it, we need to work on it. And I'd also like to maybe sort out from Mr. Harvey. I'm trying to find it. There it is. So there's the kind of limiting concept about RICO versus other counts, but then there's also included in the same instruction, hey, here's how you might consider prior statements. And are you just proposing that I give some general instruction like this at one point and then we move on? Or I'm not sure what you're proposing.
Okay. When, for example, we have Mr. Copeland on the witness stand, we've spent an inordinate amount of time going through his prior statements.
Right.
To weed out those portions that may or may not be admissible. But the point of the prior statements is that he is being impeached.
Right.
From his testimony at trial. And if it is impeachment evidence, then it can be considered with regard to the credibility of Mr. Copeland and for the act in question, but not for any other purpose. That is, I guess, my point. And, we just got a potential witness list with exhibit descriptions, which includes the captions impeachment in some of the categories and some of the exhibits. And I know those are potential depending upon what the witness testifies about, but we're clearly in impeachment territory with Mr. Copeland. So I understood your honor to say, look, this may be admissible against everybody because they're all charged in count one. And that was the first part of my proposed instruction. That's what I understood you to say yesterday. And I don't really have an argument.
You know what? Thanks for bringing that to my attention because you're right. I guess, yes, during this exercise,
yes.
I guess at some points I've been thinking about, okay, substantively speaking, how does this come in? And you're right. If we're thinking about certain of these things as coming in only if they are prior inconsistent statements, then yes, you're absolutely right. So yes, thank you.
Well, that's why it was
okay.
Joined together.
Okay, so I guess, thank you for that clarification. And then also what I'm asking is, are you suggesting that I just give this general instruction to the jury, you know, basically whenever we restart the trial on Monday? Or are you saying before each kind of thing comes in,
Well, I don't necessarily know whether you need to do it beforehand. And that was the old rule prior to the new evidence code. And I think the old cases, and they were old cases from like 1990.
can you try to speak into your mic?
Oh, I'm sorry.
I know it's a lot to do at once.
The
but-
old cases were from like 1998, and they said you got to give it beforehand. And you said that yesterday. Boy, I think you got to give it beforehand. And I don't think that's the rule anymore. And I think if you look at the new proposed jury instructions for the Superior Court jury instructions,
Yeah.
it says, and I'll quote, note, new code section requires the judge to give limiting instructions when applicable on request. Probably better to give if applicable, whether requested or not. Now, if witnesses are not impeached by prior inconsistent statements, then it's unnecessary to give it. If they're impeached after, and there's a prior inconsistent statement that may be admissible, I think after that evidence comes in, not before, because you won't know necessarily.
Sure.
You can say, you know, this is admitted as impeachment, and it goes to the credibility of this particular witness. That's my request.
Okay,
That's why
so,
it's in two phases
well, yeah.
or
it-
two paragraphs.
Yeah, as you proposed it, that's kind of what I'm trying to sort out is they are two different topics. Do you want it as just one big instruction or, and no, I don't think that it's appropriate every time a witness is impeached to say, hey, this might be impeachment, or this is or was impeachment, and here's how you consider it.
Well, it may
And not talking necessarily to kind of impeachment evidence, but sometimes there's other evidence that comes in for a limited purpose.
I agree. And I have asked for instructions when I thought, and the state has objected, and they've said, look, it comes in against everybody, and I understand their argument, and I could probably give the opposite, the same argument that I know Ms. Love is going to stand up and give.
Yeah.
But I have asked for those instructions. And when evidence comes in as impeachment, I'm going to ask for the instruction and have it limited to that particular count and that particular person.
Your Honor, I would.
Yeah.
Just as to Mr. Harvey's words regarding evidence that comes in as impeachment, I'm hearing, and I'm aware that he may not be saying it as I interpret it, but this makes the second time once he previously, before Your Honor began presiding over this case, once he expressly said impeachment evidence cannot be used as or is not substantive evidence. And I wanted to just make clear that under our evidence rules, impeachment evidence is in fact in the form of a prior inconsistent statement. A prior inconsistent statement is substantive evidence, not just impeachment evidence. So to the extent that Mr. Harvey is asking for any kind of limiting instruction because we ask or we admit a prior inconsistent statement that is impeachment evidence, I would object to that because that statement now becomes substantive evidence that is admissible, not just for one person or to, somehow attack the credibility of the witness on the stand. But now it becomes substantive evidence of what is stated, of what is given in that prior inconsistent statement. And because each of the counts in this indictment are alleged as overt acts to in count one, and everyone is charged in count one, a limiting instruction based on Mr. Harvey's interpretation or assertions regarding inconsistent statements and the acts alleged regarding, or who is alleged to have physically committed the acts, would not be proper. The response that I have to the overall requested instruction he has, sort of, it makes it, it goes into it a little bit more, why it would not be proper, but just based on what he has just said, we would object to that primarily because an inconsistent statement is substantive evidence.
All right, well, with regard to the beginning of your paragraph 1 that doesn't concern prior statements, that I think is meant to concern the RICO count, that needs to be much more specific. So maybe if you could endeavor to make it more specific as to, I mean, if I'm going to give the jury an instruction, I want them to actually benefit from it. So, let's talk specifically as to RICO, and then I guess I am asking, prior statements aside, as to the RICO issue and then the substantive counts issue, is your proposal that I say this once, hey, these people are charged all in count 1, which is RICO. Certain people are charged in other counts, other people are charged in different ones, and we can be specific about it. But as you hear all of this evidence, keep in mind that it can all be considered against everybody with regard to your determination of whether the state's made its case on count 1. But it can only be considered as against the defendants who are charged as to everything else.
All right.
And give that once, or give that, I think give that once, because otherwise it's, okay, now I don't know if we're going to very cleanly break each time from, all right, this is counts 2, 3, and 4. Now we're done with that. This is counts 5, 6, and 7, so that I could separately charge each time.
But the jury has to make the determinations as to the predicate counts. Did the state prove that first place?
I know
this predicate count. Did they
Right.
prove this predicate count, and that anybody else may be a participant or should be? That conduct should be imputed to anybody else. That's the issue.
That's the whole concept of a conspiracy in RICO.
I get it. But when you are admitting inconsistent statements.
Now, I don't want to talk about inconsistent statements right now. I'm talking about how to handle the RICO count and what should be limited with regard to that. Okay, we'll get to the inconsistent statements in a minute.
We will try to make it more specific and
Okay.
resubmit it. If that's what I understand.
All right. Yes, and then do you all think that and I know you don't want one at all from the state on how they should consider other charged crimes against everybody as for RICO, but not against everybody as for guilt to that crime itself. But assuming I'm going to give one anyway, is the best way to do it a one-time, let me explain this to you and how you consider it, and not every time we move to a potential different crime. I'm leaning that way. So I'd like for y'all to try to craft something that way. So anything else on that?
Just to say that broadly, to give an instruction at any juncture other than the end as it relates to the RICO count and how it should be considered would be confusing and premature because it would be incomplete. Especially the way that we've seen it in Mr. Harvey's proposed instruction. So just as much as the court is asking, how are we proposing instructions be given on, during or throughout or at one time at the end? Our position is that regarding this topic, at the end, at the very least, one time at the end, and we have more to say that we can put in writing in response to Mr. Harvey's.
Okay, well, I don't think it's particularly helpful to have the jury not have any idea how they are supposed to be considering and evaluating this evidence.
Right, Ms. Love, what are you talking
while
about?
they're listening to it. And I know they're not deliberating on the evidence until they all get together at the end of the case. And I know that they are not making any kind of determinations about it until they're deliberating together at the end of this case. But as they're taking it in, it might be helpful to have them know how to be conceptualizing it. And if this were my trial from the outset, yeah, it would be pretty bizarre for me halfway in to be like, oh, hey, by the way, here's an instruction about it. I would have done it before now. But if I'm going to do it, it's not that weird for the first time they see me while I'm telling them other things anyway to say, and hey, this might be helpful as well. Here's something that
Judge,
you
they
need to
already
think
know
about,
you.
and here's a way to think
They've
about
seen
it.
you on the
So,
internet.
what I mean
They
for
already
that
know you
is,
over the
and
case.
I mean, I think I'm
Over the
making the
trial.
decision anyway. I think the appropriate way to do that is to give that instruction once and then give it again at the end to remind them, but not throughout the entirety of the trial each time we move from one set of crimes to another.
So, Your Honor, I'm going to let Mr. Atkins address part of what the state's response is. And then if the court will permit me, I just have to say a little bit more after he addresses the first part. Go ahead.
Your Honor, I just wanted to highlight that I think an important thing to consider, because there seems to be conflating the concept of relevant evidence and admissibility at trial with every defendant being charged in count one, the RICO. Evidence of, for example, Act 39 we talked about, Mr. Winfrey. If the jury finds that overt act was made by Mr. Winfrey, that is relevant evidence to their overall determination. And so I think any instruction, if the court were to give one, I think, as the court alluded to, it needs to illuminate something in the jurors' minds, not confuse them, but explain something. With every defendant having count one, there's no defendant who's not charged with that. So all of the overt acts which track the indicted counts, if someone is not mentioned in evidence presented in Act 39 and defendant X is never mentioned, the jury never hears any evidence of that specific defendant, that evidence is still relevant when they're deciding count one for that defendant who was never mentioned in said act. And so and of course, RICO trials of this nature, the jury instructions, they take a lot of heavy lifting legally and thought. And the case law makes that clear that what instructions the jury are given, it's very important to be clear and concise because it's naturally with so much evidence it's important to get those instructions right. And so I think that is just an important thing to keep in mind of relevancy versus admissibility. And some of things in regards to relevancy, if they're admitted by this honorable court, any argument can be made at closing of why it is not tethered to their client, or why the state didn't prove count one.
But you ain't,
And I
you're
just
not going
wanted
to
to
be.
share that because I think it's important when thinking through this. And to ensure as well, given the endeavor of jury instructions at the end of trial, that whatever we instruct the jury now, we don't want to instruct them something different later, after a more fleshing out of all of the jury instructions. Because of course, jury instruction as a whole are what's considered from appellate courts in terms of if one specific instruction was proper or improper. And so I just wanted to highlight that for the court while we're thinking through this.
Okay.
And Your Honor, I just wanted to tag on to that, that I heard Mr. Harvey reference predicate acts, and I wanted to just emphasize how overt acts are not necessarily predicate acts, and we don't have to have any predicate acts in this case. And Mr. Harvey's instruction that he's given the court so far is just wrong in that it implies that evidence introduced under count one is not something that can be introduced against every defendant. Just to follow up on the admissibility or relevance distinction Mr. Atkins just made. The other point that I wanted to make is that understanding the court's inquiry and concern about instructing the jury and making it clear for them how they are to consider evidence as we go along. My question regarding the instruction that Mr. Harvey has proposed is, what problem exists right now that we are trying to solve with the instruction? And my answer to my own question is that there is not one at this
She answered her own
time
question
prior
now.
to the close of the evidence that
She answered her own
requires
question.
us to give the type of limiting instruction that Mr. Harvey is requesting. Right now, as it reads, his instruction is misleading and it's confusing.
Well, yeah, it is not particularly helpful at this point in time. It's a start because he at least said something. So, which is what I've been asking everybody to do for the last week and a half. But yeah, no, it's not what we're going to use. It is not particularly elucidating, but it is at least something. So thank you for that, at least.
May I respond? I'm sorry. I didn't know whether you're done or not.
I was just going to point out that his instruction, it sort of implies something, but that proof of a substantive RICO violation is not an element of the conspiracy violation that we've alleged in our indictment.
Well, and I mean, in all honesty, nothing about this even mentions RICO, which is what we're trying to clear up for them. So it needs to be much more specific and targeted also. I mean, this is just general amorphous,
Well,
not helpful.
that, you know,
Sorry.
I understand, and it's very hard to pinpoint. I think it's extremely difficult, and in that sense, please don't quote me. I agree with the state. First time in my life, perhaps.
Yeah, probably so.
But I think what the state is doing is conflating the gang charges, because if these go to the gang charges as well, then I want you to instruct the jury every time gang evidence comes in that the mere participation in illegal activity with a gang member or gang members does not, as a matter of law, constitute gang activity.
Right. It's got to be in furtherance of the gang. And I will give an instruction to that. It will not be every time gang evidence comes in. That'll be an end of the case
But
instruction.
that's what's being conflated here. We're getting RICO evidence, we're getting gang evidence, and it's coming from the same witness. And that makes it very difficult to parse out, given that kind of.
That's why we're going to have really good instructions.
And Your Honor,
I agree.
The gang is the enterprise that is charged.
I understand. I understand. So let's get something much more specific than this. Now, on the prior statements thing, sometimes they're only impeachment and sometimes they're substantive evidence. So it's not true that every time a prior inconsistent statement comes in, its only way that it can be considered is as to the credibility of that witness. It's not true.
I concede a split in authority. The 11th Circuit specifically says that impeachment evidence,
Okay,
prior
so
inconsistent statements are
are they talking about Georgia evidence or are they talking about their own? So then it doesn't matter what federal courts say about it.
but it's the same rule. It's the same rule, and I get it. I conceded that. I'm conceding. I'm arguing. It's the same rule. It is the exact same rule. The Georgia courts have specifically said we're adopting the 11th Circuit. So I think there's some disagreement, but I concede the Georgia rule. But sometimes it's still just impeachment.
Sometimes.
So, and the state has said several times, both in their exhibit description and today when arguing to your honor, that's impeachment evidence. If we may just want to impeach him with that. And that would go to the credibility as to that act. And Mr. Nichols is not charged in that act. So I think, and again, I agree, it's very complex and it's hard to parse it out. And I think it's difficult for us in the court. I know it's difficult for the jurors.
All right. So with regard to prior statements, it's kind of whether we're talking about a witness who's testifying or it coming in some other way. But when you're impeaching a witness who's testifying with prior inconsistent statements, yeah, it's substantive evidence when it comes in. So.
Now, what if Woody say, I'm not going to testify?
Now there's
And they ain't got to worry about none of that.
Issue of the jury instruction I am going to give. Oh, and obviously one jury instruction I'm going to give, we had discussed before, and it's, and I had read it out, but upon further consideration of some of the motions that have been filed since that time, including the kind of new spin on Mr. Stillwell's motion for a constitutional and fair trial with requested relief. And just considering some of the motions that have been filed, I think by Mr. Williams, since I am actually reconsidering and have reconsidered and made a different decision about at one point, I had said I was going to just say disregard any comment about any of the actions of the lawyers. And I'm going back to the proposed instruction with that. And I'm going to say that may have been disparaging of any of the lawyers in this case, because I mean, it is a fact that on the record, some things were said about certain defense counsel that anybody who's an attorney would consider disparaging, unprepared and unprofessional. So I'm going to address that and seek to cure that by just using that actual word. So that has changed with regard to my just general opening instructions about being the new judge on the case. Now we have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he decides at this point, on Monday not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right. All right. So Mr. Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion. And that being, I think like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder, disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that so I at this time, I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so I mean, y'all have had the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah. I mean, I'm not saying I haven't looked at it. I'm looking for and reading.
Yeah. So, I mean, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that?
So
you do? Okay. What's the answer?
I misspoke yesterday, but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors.
Uh-huh.
They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes.
Okay.
And I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So
yeah,
he was getting there.
Okay. But if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background. So what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So Judge, it's, when you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean. And we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
Evidence.
I think it's safe to say that that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion.
All right. Is there anybody that disagrees with that? All right. Thank you.
Specifics of the night.
Adrian Love is out of pocket this week. This week has been a terrible week in the court for her, man. Thank you, Abundance. I appreciate it. Thank you. Evidence, Miss Love. Evidence. That's what we need. We need that evidence. Harvey brought a good point about the prior inconsistent statements not being used as evidence, but more so being used as a way to show the credibility of the witness or not. And so with Woody having prior inconsistent statements and then the state want to impeach him, well, they can't conflate the two and say, okay, well, we're going to call this evidence, we're going to not call it evidence, but you can't just use impeachment and be like, you know, you got to use one or the other. It's going to either going to impeach him or you're going to limit the statements as evidence of what he says. Now, it is a possibility that on Monday, Woody won't testify at all. So, with that being said, the jury can be instructed to disregard his testimony, you know? So, since Woody is not a credible witness, that's what they're trying to do is impeach him. But you're trying to impeach lies with some other lies that he made. You see what I'm saying? So, how are you going to be able to impeach someone who has lied both he lied to the police department interrogation and then just lied, you know, about that and then but he under oath he hasn't, according to what he said, he hasn't lied about anything. So prior inconsistent statements can be used as substantive evidence, but they have to meet certain requirements. The statement has to be given under oath. The statement has to be inconsistent with the declarant's testimony. So it's going to be hard to do anything to that.
Characterizing any evidence in any way, it could imply to the jury that
That is correct.
other evidence does not fall into that category. So in other words, any evidence of the night of the murder, I'm not certain how the court will be instructed.
I'm not either. That's what we're supposed to be tailoring today. That's what I wanted y'all to be giving lots of thought to. But yeah, no, I want to tailor it in such a way that I don't mislead the jury about anything. But y'all all agree that we have to tell them to disregard some of it.
We will be live.
And I mean, yeah, maybe the cleanest thing to do is, you know, XYZ date, but people don't normally think about their lives in, you know, June 3rd. Okay. I know exactly what June 3rd had to do with, you know, unless it happens to be their birthday or something like that. But so, yeah, I mean, I'll consider all of what you want to offer me, but Okay,
Personally, I'm not speaking for, I went by my notes as well as a transcript. But my notes have, more things, I guess, I don't, they were my notes. But I don't have anything specifically talking about the Donovan Thomas murder before Mr. Weinstein filed the, motion to recuse. I do have like a January 11, 2015 interview by Detective Thorpe of Mr. Copeland. and
Yeah.
it is admitted over objection, and it was played from 3:29:46 to 3:30:13. And I have to go back and remember what that was about, but I have little things like that, but I don't have any
that's
specific.
very helpful. And I knew there were a couple of small snippets of videos played. So if you've actually got the timestamp as to what parts were played, then it's easy enough to have somebody look at those snippets and see what it covered.
Can I announce now, or
Yeah,
so everyone can check? I have States Exhibit 378Y, as in Yankee, D as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's the January 28th, 2015 interview.
okay.
And then I have, the January 11, 2015 interview marked at States Exhibit 358A as in Elisa, and it's at the time I just said, which is 3:29:46 to 3:30:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 3:29:46 to,
3:30:13.
okay, thank you.
And that's at 358A as in Elisa.
All right, and I think that's our review had only revealed those two. Anything from those two videos also. All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know.
Who was Little City talking about the young lady
All
that
right.
spoke yesterday?
Silence.
Yeah, she's in court.
All right, turning back to Mr. Steele's proposed instruction. You're saying that as to collecting their notes, they're going to be sealed for the record. Why not just destroyed?
She's in court.
And I don't even know if your mic's working right now. We might need some more batteries, but
I was given more batteries, but this should be working, I hope, anyway. I just, from doing death penalty cases, that we don't destroy anything, but we don't get to look at it. The court can look at the notes, I guess, but it goes under seal. That's how I've always been taught.
I mean, why would there be any relevance whatsoever, even on appeal, to what jurors might have written down about something we then take from them and tell them to disregard?
I understand. This is just how
Okay. I mean, if it were a death penalty case, I would do it that way, but
I'd have to look at the law, though, but.
okay, well,
But I can't answer your question other than, yes, I understand at the end of the case.
all right.
No one gets their
Frankly,
notes.
I don't need to tell them what I'm doing with them anyway. So if I do seal them for the record, I'm not going to tell them that. If I'm going to destroy them, I might tell them that. But so if you want to give me law on that, great. All right, now, one other thing that I propose to do, because we're telling them there's this chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do, in addition to instructing them on that, is to then do some version of, and Ms. Persfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction. So that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial. But better to go ahead and figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Persfield, do you have the site for it? It looked like a pretty good idea to me.
Judge, that is Davis, Davis, the state, and that is at 307 Georgia, 746. Don't have the pinpoint, but I believe it's towards the.
Yeah, it's towards the end. It's either the last or the second to last topic that the appellate court addresses. And it even includes the instruction, and I may look at that and maybe borrow some from that as well. So y'all can take a look at it too.
You all asking the jury not to be human. That's crazy. Disregard what you just heard. Yeah, I can't do that. I'm not willing.
And do y'all all agree that if Mr. Copeland decides on Monday he is not going to testify, that everything he's said so far gets disregarded?
No, Your Honor.
No, you do not?
No, Your Honor.
Okay. All right. I'd love to hear it, but I'm not sure how that's going to work unless everybody agrees to it. Because nobody's going to get to cross-examine him. So if y'all all are like, yeah, every one of us wants everything he said recusal motion, super, stipulate to it, I don't have a problem with it. But otherwise, tell me how that's going to work. Actually, does everybody want every bit of what he said
He didn't say much anything.
Yes.
No. Okay. Then how do I let them consider anything that everybody doesn't agree to recusal motion when nobody's going to get a chance to test him further?
So, Judge, there's the issue of what Mr. Copeland wants to do, what he decides to do.
I know.
He may later on, if change his mind.
Sure.
And so I would just ask the court to allow us to think about what the court did.
Okay, y'all, I have been asking you for the last week and a half to think about it and to get together on it.
Specifically, if he chooses not to testify, because we were earlier, the court had said that regarding his decision not to testify, there were limitations as to what remedies existed.
Yeah.
And
Miss
the
Love.
court said that if we found case law to present it to the court. So
okay.
I have been looking at that issue, and before I present the court a specific case, I want to make sure it's on point. But I'd like the ability to present that.
Here's the thing. It's Thursday. We are not having court Friday or Saturday or Sunday. I'm bringing the jury back Monday. So
understanding that, well, all that I'm saying is that even if the court brings the jury back Monday, and on Monday, Mr. Copeland chooses not to testify, Monday would be premature to tell the jury to disregard what he said, because he may change his mind on Tuesday, and then he comes in on Tuesday and they have to now consider what the court has told them to do.
Undisregard it.
Right.
Yeah, well.
So I would ask that
Well, let me ask you this. Assuming that we have him in before we have the jury in and he says, I'm good to go, put me on the stand, which he will not say in that way, but we still at that point need to say, as to the 13th, 14th, whatever, disregard that, right? I mean,
Right.
that's the time to say that, right? Yeah. Okay. So I hear you. It may be that he says one thing on Monday, which is throw me in jail. And then by Friday, he's like, I don't like jail. I want to come testify. Then, yes, they get to consider what he said on the 7th through the 12th or 10th or whenever it was, 12th, I guess. But I don't think we leave them hanging in the meantime.
In the same way that sometimes we have to break from a witness if the witness gets sick.
Yeah.
They get sick in the middle of state's direct. It would be not yet right to say disregard.
Okay. What does anybody on the defense
This
side
is some
of
bull,
the
guy.
aisle think about that?
Oh, two things, Your Honor. First, I think Your Honor indicated that you want to make sure the jurors are able to follow the instructions. And so I don't know how we're going to be able to, without telling them to disregard, make sure that they're able to disregard the instructions. Secondly, if there's evidence that they're not supposed to be considering, I don't want them to be evaluating other people's testimonies further on in this trial while still considering something they're not supposed to be considering.
I think so too. I mean, it's not ideal, but it may not come to pass, but I think that at the point in time when it appears to us, if it appears to us that he's not going to testify, we need at that point in time to say, disregard everything you heard from this witness. And then if he later says, you know what, get me out of here, I want to testify anyway, then is when we say, okay, I know I told you to disregard it before, but he's available again to testify. So here's what you can consider. The rest of it, we're picking up from wherever. I just think that's the best we can do. So
I'm still looking at that issue. Just
okay, well, I mean, that's fine. If you come up with something, let me know. All right. Okay, so have y'all yet gotten together on if he does not testify, what parts everybody agrees they want? Because there were clearly some parts that everybody wanted. Yeah. Or are you just, because y'all were all like, oh yeah, there's some good stuff in there. So
Yeah, I know Brian still said that.
if y'all all agree to it, fine. If you don't, also fine. Probably none. Sure.
If he doesn't testify, if he decides not to testify, you can't unhear something, but you can disregard something. Like I heard that, but I'm not gonna give it no. Like you can hear something, but you're not gonna give it a lot of attention. You know what I'm saying? So I can understand that. You know what I'm saying? Like, oh yeah, I heard that, man. But I ain't worried about that. I ain't gonna pay that no mind. So it doesn't go into my thought process of what I'm doing. But if you tell me to unhear it, that's not going to happen. I've heard it already. So the thing is if he does not testify, if he decides to hold himself in contempt until the end of this trial, which is somewhat around March-ish, if he decides to do that, he's already made prior inconsistent statements. You've been trying to impeach the man. And on top of that, he's not a credible witness at all. So nothing he says should be held into this case. That's what the judge is saying.
With all parties on the defense side, our position is that if Mr. Copeland elects not to testify, we're going to ask that all of his testimony be struck.
That's
not
fine.
have the opportunity to cross-examine, obviously, and so
Exactly.
that'll be our position.
Exactly. Great point, Adams. Put Adams in the chat. Great point, Adams.
Okay.
Great point. You haven't been able to cross the man. Put Adams in the chat. That's a great point.
Okay, I think Mr. Steele, you were going to get me some case law on, what was it on? Something.
I assume it's the statute of limitations.
Yes, yes.
Statute of limitations,
yes.
right?
I have a whole brief on this, Your Honor, but
Okay,
in the meantime, if the court wouldn't mind looking at State versus Conjo, it's C as in Colette, O, N as in nice, Z, O. It's 293, Georgia Appeal 72. It's a 2008 case. And they talk about,
okay.
it's in,
All right, I'll take
there's
a look at
also
that.
there's also a federal case that's on point, and I have to find it. I know it happened. It was a lawyer charged with money laundering. It's in God, it's in the trial was a district court in Maryland, so it would be, and my mind's gone. What circuit would that be? I can't think of the
If
circuit.
it's in your brief and you can point me to
I
your
can.
brief, that works.
Did we just get that brief?
I'll send it to everybody.
Is this something new that has not yet been filed?
No.
Okay, yeah.
And I don't know if I filed it, but I argued it. So I have all the relevant cases.
Okay, great.
And Your Honor, with respect to just the argument that Mr. Steele makes, as it relates to, as I understood his argument is that broken down, that the jury should look at the dates of the acts that are alleged, and if they only find that the state has, one, proven beyond a reasonable doubt acts that have been alleged further than 5 years before the indictment, that the state has failed to meet its burden. The problem with that is that in a RICO conspiracy, overt acts do not have to be a crime, and they do not have to be racketeering activity. So proving the act beyond a reasonable doubt is not a thing, for lack
Not
of
the
a
right
better.
standard.
Right.
Not a thing. Okay, I'll take a look at the case law.
And second, Your Honor, that's breaking apart the whole of the RICO, and that's not the way that that's not the law.
Okay.
In fact, and I'll get the case, there is a specific case, I'll get it for the court.
All right.
It is the last date, the last overt act. So we have to prove that at least one, the existence of the enterprise, and at least one person committed one overt act. If that overt act, that last overt act.
Is within the RICO statute of limitations.
Yes.
Yes.
That is what we're looking, not.
Which may be what the nuance of the case is that, as you just described it, it would be true that if the only thing the state proved, let's assume that for whatever, I don't know if it was a federal or a state RICO, but let's call it a 5-year statute of limitations. And if they had only proven overt acts, all of which were before 5 years, then none of the overt acts would have fallen within the statute of limitations, and therefore they would not have proven their RICO charge. And that may be what that case stands for. I don't know. I'll read it. I think I followed you. I may not have summarized
Well,
your
it's missing
argument
some
well,
details.
but I think I understand what you were saying, and that may be
With
what
some
that case
details.
is saying. Okay.
Yeah.
What I'm going to propose at this point is that we recess for about an hour, at which time I would like for you to all put your heads into these proposed instructions and then come back with, something to work from that is whatever y'all want me to consider as to each of these things, and let's try to finalize what I'm going to say on Monday. Okay, so we'll break till let's break till 3:30, which is an hour and 10 minutes.
20 seconds.
Yeah. Yeah, sure.
We've raised this a lot of times. It's been overruled.
Okay.
But I just want you to, because it's going to come up, God forbid there's an appeal. I don't want the court to feel like we sandbagged you.
Okay, I don't want to feel like that either.
So I'm giving a copy of the case, if I may approach.
You may. Thank you.
Your Honor, on the copy that I've given, and it's United States versus Vendetti, VANDETTI 63, that's wrong, 623 F second 1144. It is the Sixth Circuit 1980, and the copy I've given this honorable court and the state, it's on pages 3 through 4. And then there's another case that I have copies, I have to find them though. It's State versus Thomas, which is THOMAS. And it's 364.
Come on, Steve.
Georgia Appeal 148. It's in Division 2. It's 874 Southeast 2D 195. That's 2022. And that's citing to a case that we've all cited a lot. State versus Jefferson, JEFFERSON 302 Georgia 435 807 Southeast 2D 387 2017. The Jefferson case and State versus Thomas deal with a guilty plea of a non-testifying co-indictee in a conspiracy gang case. The United States versus Vendetti case deals with a jury verdict on a co-indictee who did not testify. The reason I bring this up to you is it won't have any effect on Mr. Sledge because he's testifying, but the state has successfully over objection brought in, I'm just remembering Mr. Winfrey, but I'm confident they're going to try to get in Mr. Johnson's client, I can't remember, Eppinger, EPPINGER, et cetera. And I just believe that that's a confrontation clause violation.
All right, and where in, you said pages 3 and 4?
Yes, it's in division on page 3 on the right-hand side.
Okay.
And it starts at the very first full paragraph to determine whether the testimony.
All right,
That's in the Vendetti case.
thank you.
No, thank you. And it's a lot of it. They summarize, they've been the Sixth Circuit summarized on page 4, specifically the first full paragraph on the left-hand side.
Okay, thanks.
No, thank you. I just wanted to use the time.
All right.
Thank you.
So, Your Honor, we have three instructions. Would the court mind just laying them out so that everyone's.
So I think the most challenging one is going to be any sort of a 105-ish limiting instruction on how they are supposed to consider evidence as to the RICO count versus as to the substantive count of the indictment that might be an overt act alleged in furtherance of the conspiracy, which I assume, like, for instance, a few of these defendants, but not all of them, are charged with the Donovan Thomas murder. I assume the Donovan Thomas murder is an overt act in the RICO count. An instruction that clarifies for the jury that when they're considering all of the evidence on the Donovan Thomas murder, it is okay to consider that against all of the defendants, because they're all charged with RICO, when considering whether the state has established guilt, their guilt on count one, their each individual defendant's guilt on count one. It is not, however, something that they need to be thinking about when they're deciding, okay, who's guilty of this murder? Mr. Williams is not charged, for instance. So they shouldn't be thinking, is Mr. Williams guilty of this murder that he's not charged with as a murder conviction? And I'm not necessarily explaining it well. That's why I'm asking y'all to come up with it.
So would the court, so within this, and I know that I think this is what the court is asking is, but within the context of that type of instruction, would it not be necessary to have or to give to the jury the elements, like we would need to go through the elements of the charge to say how, when you say consider, you know, how they are to follow that instruction without being given the elements of each charge, how will they know how to?
So I don't know if maybe the way to, or the place to look at it to begin with is where in the pattern jury instructions, there's a pattern instruction about, you know, sometimes things are considered for limited purposes or against limited, some defendants and not others. But I'd like for us to get more specific than that, because if that's all I say, that is really not helpful, because I haven't said, and so here's what you do consider it for as to this person or that person or this count or that count. So work on that. And then, you know, what I'm saying about how we handle Kenneth Copeland stuff. And I'll go ahead and look at these two snippets now that I've got timestamps and see, and y'all can do that as well if you want to make sure that you agree. But that's what I want y'all to be working on. Okay. All right, so we're in recess till 3:30.
All right. Court is in recess. Right. So, okay, so there's a few things that this judge is doing. First of all, how y'all doing? How y'all doing so far with this, man? What y'all feeling right now? What y'all feeling right now? What are y'all feeling right now? This is absolutely interesting stuff going on. Okay. So one of the things that's interesting is about the overt act situation, and the statute of limitations on that. That's very interesting. But also the fact that the judge is trying to come up with a fair presentation for when the jury come back on Monday. And that is a very that's very particular, because again, Harvey's motion and what he said was on point. You know, we can what he said basically is like, yo, if the statements are inconsistent, if the statements are, you know, that have been made by this witness, not credible statements, doesn't have any level of credibility at all, you know, basically, how can you use that? You know what I'm saying? I know Brian Steele also. Can y'all hear me? I know Brian Steele also Brian Steele also had a motion. We can read that too as well. Yeah, sorry, I got too close to the mic. I hope, can you all hear me now? I don't even need the mic that close. Can you all hear me now? Let me know. Put a 1 in the chat if I'm good. All right. I got too close to the mic. I was all up in here like this, you know what I'm saying? No. All right. So this particular motion, this is what Brian Steele did. Now we read Mr. Harvey's motion. We read that. And so I'm going to try to, you know what I'm going to do? I'm going to go ahead and just do something real quick here. I'm going to go ahead and screenshot this motion. All right. Screenshot the motion. I'm going to put it in my Google Docs real quick so we can read this. Copy. Paste. There we go. So it's a little bit, I got this from Thugger Daily. So we're going to take a look at this real quick. Okay. And let's see what it says. All right. So let's try to, here we go. So y'all can see this, right? There we go. That's better. All right. So this is the motion that Brian Steele made today. I think in the early recess lunch break area of the day. This is the joint motion for jury instruction. So this is a joint motion that goes along with what Harvey had wrote. And it says here, comes now Mr. Jeffrey Williams et al. By and through their undersigned counsel and hereby file this joint motion for jury instruction in the above referenced case. In support of this motion, Mr. Williams et al. Shows as follows. Now watch this. Have you all noticed that the state has not done anything? The defense are filing motions. The defense is doing exactly what this judge is asking for. And so one of the things, and the reason why, and I wanted to address this, because I know Lisa had said something earlier about, did she just say something about, I can't figure it out, y'all do it for me? Yes, she is. We have to understand something. And again, I want to address this because I kind of got, I had to get my emotions out of it for a second. She is being a referee. All right. The state is lazy and they know they don't have a case abundance. You are absolutely right. Let me go ahead and put you up here. You are absolutely right. All of this is true. All right. All of this is true. All right. But listen, just hear me out for a second. The judge has to be a referee to this thing. And she has to hear both sides. So this is the reason why. This is another reason why, again, it's another reason why the motion for mistrial has not been made yet, is because the state has not responded to anything. They're not working. Okay. She's trying to do this. I think this judge is trying to do this particular portion of the trial fairly. Again, I had to get my emotions out of it because I'm like, man, when's she gonna file for? When's she gonna file the? When's she gonna give an order? When's she gonna? The state has to respond. The state has not responded. Okay. The state hasn't suggested any type of jury instruction. The state has not filed a motion to keep certain parts of Woody's testimony and the reasons why and all that. The state has not done anything. She's too busy trying to yield over evidence that she wanted to use that she's had since last year. So this is the reason why the defense is crushing the state right now. Crushing them to gravel, because the state is being very lazy, and they don't have a RICO case. They got some gang stuff. Yes, I would say that. Do they have a gang related case? Sure. Yeah, because they have a gun involved. They got a video of a drive-by shooting. They got yeah. So there's some gang related evidence. Okay. Yes. But RICO, where are you coming up with RICO? And so while they're on break and doing their thing and trying to figure out what to tell people, we're going to deep dive into this a little bit. But we're going to read this jury instruction, okay? Because this, first of all, they made a mistake. And like I said this on Lead Attorney's channel again. I said they made a mistake calling it RICO. The state effed up by calling this a RICO case. And so that's the reason why they're having a hard time with things, because there's statute of limitations that need to be considered. There are, and then also there are actual evidence that has to be linked to a RICO conspiracy that's related to organized crime. And once we look at what RICO is, you're going to be like, what? Because again, most of the time RICO cases are involved with stuff like conspiracy would be like the La Cosa Nostra, which is a part of the Italian mafia. And they've had RICO cases they get RICO cases a lot because they are actually organized crime. They have the 5 families and the Gambino family, the Corleone family, the Genovese family, the Franchise family, whatever. Like, they got all these different families, man. You know, the Bonanno family, which is one of the most powerful families out of the Italian mafia. And they operate under the Cosa Nostra. They take the blood oath and they don't snitch on each other. They don't cooperate with the feds. They don't do any of those things. Okay. This is totally not RICO. These Negroes is cooperating. They are trying to figure out a way to save themselves. They taking plea deals. They serving time. They're not really in a RICO conspiracy, because where does the money go to as far as where does the money go to as far as the organized crime part? You know, how are you saying that these crimes were benefiting a YSL music company? You got to prove that. You got to link that. D. Pill says, yes, it's unread motion still pending, not answered. And Weinstein also, exactly. So again, a judge has 30 days to respond to a motion. The state has, if I'm not mistaken, the state has to respond to a motion within like a 20-something day period, I guess, or a 14-day period, something of that nature. So there is still time to respond to those motions. You can still continue a trial without responding to those motions yet. Excuse me. Now, also, it's a possibility that a mistrial could be done after the jury come back, or for whatever reason. Me personally, I'm speaking from a common sense perspective. I'm not speaking from like a legal knowledge perspective at this point. I don't see a reason why we should be having hearings about these motions at this point. The state needs to respond at a timely manner to all the motions that have been done by the defense. If they don't have a response, then we can have a hearing about the reasons of being a mistrial. You can say it. You can say your piece from there, and then I can make a rule on it. The reason why if I'm Judge Whitaker, the reason why I would do it that way is because the defense has a right to a speedy trial. This trial has been going on for 19, 20 months. Or this case, I would say, has been going on for almost 2 years. And these gentlemen have been in jail off of charges that haven't been proven yet. I'm going to consider the motions first before I do anything. Because if I have evidence that can actually prove that this motion is warranted, then I can make a ruling on that motion, and we could just nullify the whole thing. I wouldn't be going through, me personally, I wouldn't be going through evidentiary statements or any of that if I'm the judge. I have these motions in front of me, and also potential Brady evidence that has been that I need to consider seriously. Prosecutorial misconduct has been proven for sure without a shadow of a doubt, but beyond a reasonable doubt. I just think that the order of what's going on is kind of backwards to me. And so this is the reason why, doing the jury instructions and doing all this kind of stuff, for what? You got motions on the table that, let's say for instance, the jury comes back Monday and they start this trial, you know what I'm saying? And again, judge got within the date of the filing until 30 days to file an order for those particular motions. Here it is, the jury comes back for 3-4 days, and I find out more information about the reason why it should be a mistrial. Then I say, you know what, I'm going to order this a mistrial. That's backwards to me. You should address the motions first, even though you have the right as a judge until 30 days to respond or whatever. I would still handle my business a little bit differently, and I would say, okay, I would consider the things that the court, her words were, this court takes Brady very seriously. Those are her words. If you take Brady very seriously, then you should be focusing on what you take seriously first, because all these other things all these other processes that we're doing, it may be unnecessary. Okay. So the judge is I believe the judge is saying, hey, this is y'all case. Talking to the state. This is y'all case. And you had this case for 19 months, going on 20 months. And you haven't turned over all your stuff. And you want me to tell you, you want me to do your job for you. You want me to instruct the jury for you. You want me to do all this. This is your jury. You selected these people. You see what I'm saying? This is the state's case. So the judge has to let the state work their case. The problem is the state is not working their case. I think the fact that the state is not working their case is causing the judge to look like she is being biased towards them to a certain degree. But there's plenty of times where the judge agreed with the defense for sure. So it's not lopsided like Glanville. This is nowhere even near lopsided like Glanville. If anybody were to think that, that's being disingenuous. Because there's no way that this judge is even remotely close to how Glanville handled this, okay? Not even remotely close. She's only been at it for about a week and a half or so, but we can give her more time, more grace on that. But there's no way in the world that she's handling it like him. So I just think that this judge is making the state actually do their job. Like, this is your case, man. You are supposed to prove this to me, or prove this to the jury, or prove this to the people that these guys did a RICO conspiracy. That's the first count. So I think the fairness is especially with judges, fairness is going to look biased to us because we like, man, we sick of the system. We sick of the corruption. We sick of it. But we have to be objective in certain points. Her telling the jury or her telling the state, I'm sorry, and lawyers, hey, y'all give me what y'all want me to instruct the jury with, and then I will make then I have something to work with. That's the reason why she gave Bruce Harvey a little bit of praise and said, at least you gave me something. Thank you. At least you gave me something to work with. So I appreciate that. Thank you, Mr. Steele, for amending your motion so I can have something. Now, Mr. Steele has made a motion to, to disqualify, and he amended it. And he went the prosecutorial misconduct route, which is what I said before, to just do that. Stay on that. Y'all got plenty of evidence on that. Y'all don't have deep-seated Brady evidence yet. Okay? You don't have deep, concrete exculpatory evidence. Like the Baldwin case, the exculpatory evidence was blatant. You know what I'm saying? So you don't have blatant yet. However, you got prosecutorial misconduct, which can still lead to a case dismissal. So so the state is not out the wood. They're not out the woodshed at all yet. Yes, cartels, the mob, these are RICOs. This is not RICO. These are just some gang-ish. Just some N-word stuff. You know what I'm saying? I mean, basically. All right, Lisa Butterfly, I see you. Let me get to you real quick before we get to this motion here. We got plenty of time. I largely agree with you, Tay-Biz TV, but what irritates me about how she's handling it is that she's acting like, oh, I just don't understand, instead of directly calling out the prosecution. Again, she's doing that though, but she is kind of calling out the prosecution because she's showing them that they don't have their case together. She just can't do it in an outright. She's not going to do it like Glanville did the defense. Now Glanville did the defense like that, like, oh, you're not prepared, and you're not this, you're not that, and all that kind of stuff with the defense, and that showed he had clear bias. So yeah, she's acting like I just don't understand how. At the same time, she still want the state to do their job. Because I had to really think about this. Like the state just not working. They're not doing what they're supposed to do. And that is the problem. That is the that's a huge problem. Lisa said, I feel like fairness warrants each side require nothing beyond. Well, I, as new judge, see corrupt activity, if not by both court and prosecution cases. No, she can't do that. She's not gonna be able to do that. No, you can't do that. Again, why was Glanville recused? He was recused because he wasn't recused because he had an ex parte meeting. Remember? I just want immediate justice, but if it's at least fast justice now that she's taking over, I will be satisfied. I got you, but she cannot. She still has an oath to the law. Even her, she's not gonna be able to do what we want her to do. She's not gonna be able to say like this right here, this corruption, and she's not gonna use words like corruption. She's a judge. She's not gonna be able to do that and stay on the stand. She's not gonna be able to do that. So I understand that. I feel you. Trust me. I agree with that. But that's the reason why Brian still said, hey, this is disparaging stuff that he did. But that's the reason why he's recused. But let's go back to the recusal. He's not recused because he had an ex parte meeting. Judge Glanville got recused because he showed the appearance of impropriety. That's what Judge Krause recused him on, is the fact that, because she said, I didn't see nothing improper about the ex parte meeting, but it does show the appearance of impropriety. So therefore, without all things being considered, this court will grant the motion to recuse Judge Glanville. He got recused because he showed the appearance of impropriety. He didn't get recused because she thought he was being improper. You see what I'm saying? This is how they do. This is how they word it, man. this is how they word it. You know what I'm saying? So we just need to breathe a little bit and let this lady work a little bit. Cause I see she kind of doing the Rubik's Cube chess thing here. And she's not doing it. That's why these motions have not been responded on yet. And at a certain point, they will, they're going to get the attention. She has to respond to them. I mean, if she don't respond to those motions, she gets in trouble for sure. She may get recused. So, yeah, she's going to have to respond at some point. But we're not going to get the mistrial or the case dismissal like we want immediately. Okay, I'm fine with that now. Let's be patient. Let's do it. Let's go with it. What's happening right now? What's happening is she's giving out instructions. Okay, y'all. Hey, y'all send me something that y'all want me to say. I don't know. And then we'll figure it out from there. Y'all send me something. Don't make me do your job. You know what I'm saying? Don't make me do your job. So yeah. So y'all gonna have to give me some instructions to tell the jury. Let's go ahead and look at what Brian Steele has in motion for instruction. Is everybody following me on this though? Is everybody getting what I'm saying? You may not, I know we may not agree totally, but is everybody getting what I'm saying? Is the fact that the state has not been working. The state has not been doing what they're supposed to do. The judge is exposing that. And according to the law, she still has to give the state time to do whatever. The state has not responded to any motions. They haven't made any responses at all to that. They haven't done anything. They're still trying to hand over evidence they've been sitting on since 2023. She's putting all that into consideration, I believe. And when Monday come, if Woody decides not to testify, it's a wrap. All that stuff needs to be stricken out of the court, which all his testimony, which I totally agree with. That's why Adams did a great job. So kudos to Adams on that, because he definitely made sure that the whole testimony of Woody gets thrown out. All right, so here we are. This is Brian Steele's motion. Okay, I'm done talked enough on that. This is Brian Steele's motion, and it says number one, Mr. Williams is innocent of all charges in the above referenced indictment. Number two, Mr. Williams respectfully requests this honorable court provide the following instruction upon the return of the jurors to court for trial. Look, Brian Steele, even his wording, and when it comes to this judge, is a little bit more proper. Okay. It says, ladies and gentlemen, you are hereby instructed to separate and give to the court for sealing for the record any and all of your notes that were taken on the afternoon of Wednesday, June 12, 2024 at or around 3:30 p.m. and beyond. Okay, let's go Steele. This is great. Brian Steele is on point. This is absolutely fantastic. This would include when you were last here on Monday, June 17th, 2024. So everything from Wednesday, June 12th to June 17th, Brian Steele is saying, Judge, just instruct them to give you all of their notes from that point on. Why is he saying June 12th? It's because that's the day that Judge Glanville had the first motion of recusal by Weinstein. Now, we all know the first motion for mistrial was the opening statement, the day of the opening statement. All right, we know that. But for the recusal of Glanville, June 12th was the day that Weinstein said have a motion for recusal. And what did Glanville do? He denied the motion right then and there. He's supposed to give it to a different judge. He denied it right then and there. All right. Also, you must erase from your mind any matter that occurred from the afternoon of Wednesday, June 12th, 2024 at or around 3:30 p.m. until you were excused from the last time you were in court on Monday, June 17th, 2024. Now that right there might be a little bit of a problem. Erased from my mind. I don't know about that, Brian. Now, there are some people we have learned in recent history. There are some people that don't recall a lot of anything, even though they were there. I'm not going to name no names right now because I ain't trying to be messy or nothing like that. I'm just saying. We know that there are some people who can be inside of an ex parte meeting that happen to be a lawyer and not know that they're in the ex parte meeting, even if they're not required or was asked for an ex parte meeting. Okay. So this is where it gets interesting. I think that you're trying to ask the jury to do something that they may not have the possibility to do. There are some people, again, that know how to hear something and disregard it. You know, you could be at your place of business, your BMV or your Secretary of State office if you're in Michigan. You know, if you know, wherever you're at, the doctor's office, you be at the doctor's office and you can hear a child running around being silly and laughing and playing, but you might disregard it. You know, you're there chilling. You might disregard it. There's some people that can't handle noise. They get immediately irritated, and they have to respond right then and there because they don't have the tolerance for it. Okay, we get that. That's fine. But he wants them to erase from the mind any matters that occurred from that afternoon until that Monday. All right. It says this includes any motions, testimony, rulings by the former court, statements of the former court, questions and answers by the witness, and the like. Then he cited some case law for this particular jury instruction. And so it says here, wherefore Mr. Williams respectfully requests a hearing on this motion and that was the end of the it was only a one page motion. So that right there is I think that's legit. I think that's a good instruction to give to the judge so that way she can, look at it. Again, these are instructions that they want the judge to say. And, the question is at any point will the state respond or give their instruction? She calling the jury on Monday. So, this needs to be done, Ms. Love. And again, Ms. Love is not doing her job as per usual, right? Lisa says, I still have some understanding for that particular person in that she thought she was there to just inform the court something Woody's lawyer said, not to be involved in a secret ex parte. Yeah, I totally understand. I have some understanding with that as well. My thing is, as a professional, you are supposed to recognize when you are in something that you need to get out of. You're a lawyer, man. I need your antennas up at all times. Period. That's all. The fact that it was ambushed on you like that was wrong. Wrong. And see, the state know it's wrong, man. The state know it's wrong. See, it says here, look, even She Lee says, if I was a juror, I would think Glanville was cheating and got kicked off. If you just swapping referees like this, man. If two boxers are boxing and all of a sudden in the middle of the match, you swap boxers to fight the other person, that means that first boxer was probably getting their behinds whooped. They were probably in a situation where they was in some danger. So now they got to switch fighters because we want to try to win. And that's essentially what's happening. is that, you have to switch referees in this instance, because the first one they didn't pass the smell test. They didn't pass the smell test. So I wanted to go into the RICO, and let's go into RICO real quick and get specific. Let's get specific, okay? Because we just throwing out the word RICO like everybody throwing out the word narcissistic. I'm so sick of people. Every time you talk to somebody that was in a relationship and they broke up with somebody, they always say that person was narcissistic. I'm so sick of people throwing out RICO like it's armed robbery. It ain't. It ain't the same thing. It is not the same thing. Okay? Stop it. Stop throwing the word RICO around like it's any old thing. It's a specific thing. The problem with the state is that they have named this RICO. That's it. That is the biggest issue. That is the biggest issue here. They have called this RICO, and it's like, yo, this is not RICO related. Is it some gang-ish? Yes. Some street-ish? Yes. Could you probably catch them on some street-ish? Yes. There may be some evidence of that, yes. Because you do have a couple guns or something like that were involved or found or whatever. But calling this RICO is reaching. Okay, it's reaching. So what is RICO? Okay, RICO, a Racketeer Influence and Corrupt Organization Act case, is a federal prosecution of organized crime activity or racketeering. The law was passed in 1970 to help victims of organized crime recover and strengthen law enforcement's ability to gather evidence. What? Strengthen the law enforcement's ability to gather evidence. RICO is literally an act so that way prosecutors can gain a more tactical advantage to gather evidence. So if you have a suspicion that there's an organized crime activity going on, you're the prosecution, RICO allows you to be able to get evidence in a more tactful or more strong-willed way. Before RICO, it was called OCC. It was like organized crime and corruption or something like that. That's all it was. Racketeering was not involved. Conspiracy was not involved back then. Before RICO, it was called OCC or something of that nature. And y'all can fact check me, but I believe it's OCC, organized crime and corruption. And RICO is what helped people or prosecutors get gangsters like Nicky Barnes, like the Chambers brothers, like, you know what I'm saying? Like that's what I'm Chambers brother. I'm showing my age. I'm going back to the 80s, back in Detroit. BMF, Black BMF, Black Mafia family, something like that. A lot of Frank Lucas, a lot of your heavy hitters back in the day that was, selling, cocaine and different other drugs by the droves. And so RICO came in 1970, and before that, all they had was OCC, organized crime. So to prove organized crime, but they couldn't. They only were limited to how they can get the evidence. They was limited on how they can get the evidence. So that's the reason why they're like, okay, we need to reform this particular thing. And that's when they passed RICO. All right. So RICO applies to 35 different criminal offenses, including those often associated with organized crime, such as illegal gambling, prostitution, unlawful debt collection, counterfeiting, money laundering, kidnapping, murder for hire. Let's just stop right here because it's a gang. It's a gang of stuff. But let's just stop right here. Has YSL done any of this? Have they proven any of this right now? Let me ask you all. Has the prosecution for Fulton County in Georgia, have they proven illegal gambling, prostitution, unlawful debt collection, counterfeiting, money laundering, kidnapping, murder for hire? Just those things. RICO also covers a range of federal crimes: slavery and human trafficking, drug and weapons trafficking, witness tampering and obstruction of justice, mail and wire fraud, copyright infringement, passport fraud, acts of terrorism. Have they proven anything? This is what burns me more than the fact that the judge is acting cuckoo for Cocoa Puffs. Okay. I don't care that the judge is acting ditzy. I don't care about none of that. What I'm upset about is the fact that I don't see tangible evidence of anything related to RICO from a federal or state level. Look, not one thing. None of the above. Nothing. I'm not getting anything. Money laundering. How is it money laundering? How can you prove that the YSL music organization, can you prove that the money is actually dirty and coming from organized crime or crime that's outside of the scope of anything legal or business related? Can you give me one thing? Can you give me a receipt? You gave me 2 receipts of this man renting a vehicle. Okay. But then the same receipts that you have about him renting a vehicle, when the witness is going to stand, the vehicle that actually does the shooting of the Donovan Thomas unaliving, the witness says it's a white Bonneville. As a matter of fact, even in that video, when you looked at that video of the drive-by, allegedly, when you look at the video, that gray vehicle that they keep pausing, you don't see one, you don't see a gun sticking out the window. You don't see nothing from that vehicle. You don't see nothing from that. Now, see, this is the problem that I'm having. I'm just sick of prosecutors or the prosecution just being able to say, oh, yeah, you did it. And that's all they got to do. They don't have to do no work to prove that I did something. Oh, well, we're going to go off the transcript. Yep. Oh, we're going to just do this. Oh, yep. And that's it. It's like, that's all. That's it. All you got to do is point and say, well, oh, you was a part of something. And that's all they got to do. That's what they're doing to Marquavius Huey in particular. We saw what the Silver Fox said when I made sure that I highlighted the opening statement of the Silver Fox on this channel right here. And Silver Fox told us in the opening statement that the firearm charge that's on my client was already dealt with before. Now they're trying to bump that charge to make it seem like it was a RICO charge for the unaliving of Mr. Donovan Thomas and for the shooting of other people's houses and all this kind of stuff that's related to the unaliving of Donovan Thomas. Not that he actually did something or he was actually there or there was an eyewitness. No, the fact that he knows Young Thug, The fact they're from the same neighborhood, that's all it takes. That's all that's all it takes. That's it. They did, you did it. You from there, you did it. You took a picture with him on Instagram, so y'all know each other. If I take a picture with Young Thug years ago, they would probably call me on the stand. No, I know that that may sound like a joke, but what we're looking at, that could seriously happen. That could seriously happen. Let's say, for instance, I went to a few Young Thug concerts, and every time I went to his concert, I took a picture with him. I've been to 10 concerts. I took a picture with him, and then he make a comment on my stuff, and I make a comment on his stuff, and I'm just fanning. And all of a sudden, how do you? So, are you close with Young Thug? Like, no, I'm just a fan of his. Oh, so were you there? I'm not even from Atlanta. I'm from Detroit. Oh, so they are going to find a way to accuse you of something. This is what we're looking at right now. You can just say they did something and that's it. No proof. We're talking specifically RICO. Now, all the other stuff like the gang shooting and the firearm stuff and all that. Okay, if you have forensics, if you have actual guns, you can actually prove that. But you don't have that. So you can't even prove the gang stuff. Even the young man, Zachary said, hey, all I know is that we dropped off our guns at OG Bentley crib. Now, how they get rid of guns, I don't know. But most likely they probably keep them. But I don't know how they get rid of guns. I just did what I was supposed to do. That was it. That's it. But RICO specifically, look at this. RICO charges can be brought against individuals who participate in the affairs of an enterprise through racketeering activity, or who invest racketeering income in an enterprise that affects interstate or foreign commerce. We're talking about RICO. We're talking about RICO. Activity and things and charges can be brought against you if you participate in affairs of an enterprise through racketeering activity or invest racketeering income in an enterprise. remember the TV show Snowfall? Franklin tried to clean his money up. He bought some apartments, some commercial real estate, some all kind of stuff. He tried to launder the money. Let me ask you a question. Have the state proven this? Have they proven that this whole situation that took place according to the RICO charge was to invest racketeering income in the affairs of enterprise, interstate and foreign commerce? Violations of RICO can result in a maximum prison sentence of 20 years. And RICO also allows victims to recover treble damages. Have the state even proven this? That the things that were going on in these charges were for the investing of racketeering income in an enterprise. Some famous RICO cases include the Lucchese crime family. That's Italian mob, members of the Latin Kings, and members of the Cowboy Mafia. Let's go ahead and bring it up, see what's got going on here. Oh, they got some footnotes here. I love this site, by the way. You get all your good information here. It's a legal information institute site. So dope. The racketeering, or the RICO Act of 1970, seeks to strengthen the legal tools in evidence gathering by establishing new penal prohibitions and providing enhanced sanctions and new remedies for dealing with the unlawful activities of those engaged in organized crime. What is it? Evidence gathering. Right? Evidence gathering, right? Let me ask you a question. Put a 1 in the chat if you think they have gathered evidence. Put a 0 in the chat if you think they have no evidence. Put a 1 in the chat if you think they have gathered evidence. Put a 0 in the chat if you think they have no evidence. The RICO Act is specifically used to gather evidence that these things up here have been done. These things up here have been done. Organized crime. We know this haven't been done at all in this case. They can't even prove this right here. They have not one speck of evidence. And again, we're not promoting gang stuff. We're not promoting violence. We're not promoting any of that kind of thing. But you cannot be unjust and try to put me in a situation like this with ambushing things during a trial when I'm tried unfairly. It makes absolutely no sense. Overcharged. That's right. You're overcharging. So you're going to get the not guilty verdict. Look at this here. They say they're coming back. They said they're coming back at 3:30, right? It was like 1 hour and 10 minutes. So we got a little time. Remember, I told you all about the first RICO Act that ever happened. The first RICO trial that was ever documented was the Frank Thierry, a La Cosa Nostra boss in New York City, November the 21st, 1980. 2 years before I was born. This is the first RICO incident that happened. Thierry was convicted of racketeering charges, including loan sharking, threats to a restaurant owner, and fraudulent activity at the Westchester Premier Theater. Thierry was also affiliated with the Genovese crime family. Okay? The Genovese crime family. One of the biggest families. I believe Michael Franchise was that in his family. Either Lucchese family or he was with the Genovese family. He wasn't with the Bonanos. He wasn't with the Gambinos. He took an 8 year. He took 8 years. He took an 8 year charge because he was selling oil. He was selling oil and not paying the honorary tax on the oil. Back in the day, when you had a gas station, you had oil, and all this kind of stuff, and you would selling oil and gasoline and all those things. Back then, in those early days, in like the late 80s and early early 80s and 90s, they had an honorary. They had a honest what they call it. Honesty system, or what's the name of it, chat? If you can help me out real quick. The honest system, where you just pay the tax when you're supposed to. Pay the tax when you're supposed to, and that's it. You know what I'm saying? But they didn't give you a date for it. They didn't give you like a specific time for it. So it's the honor system. That's what it was. The honor system. The honor system. And that's what they did back then. Michael Franchise wasn't paying the honor system tax through the honor system. He kept that money. All right. So it says here that this was the Frontier was the first one back in 1980. It says here RICO stands for, we already know what it stands for, to combat organized crime. The law was originally intended to dismantle mafia families. That's what it was originally intended for, was for to dismantle mafia families, but has since expanded to include any group that conducts illegal activity, such as corrupt politicians, and police officers and street gangs and businesses. RICO provides for extended criminal activity penalties and civil causes of action for acts performed as part of an ongoing criminal organization. To prove a pattern of law breaking, federal prosecutors must show that at least 2 crimes occurred from a list of about 3 dozen potential violations, and that those crimes were part of an ongoing criminal enterprise. So what are they trying to do? What are they trying to do exactly? They are trying to say, hey, this is why they're banking on the Donovan Thomas murder. They're banking on that. And they're also banking on the firearms, because that's like 2 for the price of 1 right there. Okay. So it makes absolutely no sense to me at this point of why you are withholding dumb things like pictures and and Instagram pictures and stuff like that. With like, why are you not handing that stuff over? Like, why are you not doing that? Why are you not handing over cellular location records and things that you've plotted? Why you're not doing these things? Because you don't have evidence. You don't have evidence. Now they talked about the overt acts. Let's get into that real quick before they come back. Let me take a look and see. Yep, they're still on. They are still on break. All right. Let's get into this real quick. Overt acts. I had to ask a question to Google. I said, Google, can overt acts be used as substantive evidence? Because that's what they're talking about, right? So it says here, yes, overt acts can be used as substantive evidence in conspiracy charges. An overt act is an action taken by one or more people to further an illegal agreement or plan to commit a crime. It can be any act that shows the individual's commitment to the conspiracy's goals, even if it's not the actual crime itself. For an example, in the trial of the first World Trade Center defendants, evidence of their renting a van, buying explosives, and visiting the World Trade Center was used to establish overt acts that prove their involvement in the bombing. So you didn't commit the crime itself, but you rented the van, you did this. So this is why Brian Steele is saying, okay, you're trying to say that Young Thug had an overt act because he rented the vehicles that allegedly shot and unalived Donovan Thomas. You're also, but the statute of limitations shows. That's why he went to the statute of limitations. Like, wait a minute, hold on now. This is back in 2015, 14, 15, right? So you're trying to use this stuff, man. Miss Love is trying to use it as substantive evidence. She's like, no. That's the reason why she's like, no, I want to get into this. What? Okay, exactly. Okay, what are the other overt acts that they can use against her? I don't know. They don't have any. They don't have any overt acts. The only thing she is trying to use, that's only one thing. He rented a vehicle. You still haven't proven that the vehicle that he rented was a part of the entire situation. And the reason why they haven't proven it is because on the witness stand, they have had several people say the same thing. It was a white Bonneville. I know what I saw. It was a white Bonneville. He did have another white vehicle. I know he had an Infinity. He had another vehicle. And so the fact that these vehicles were used to, I guess, pick up the shooters or transport them out of the area, what happened or whatever the case may be, they still have to prove that beyond a reasonable doubt, though. They have to prove it beyond reasonable doubt. Here are some other things to know about overt acts and conspiracy charges. Not all jurisdictions require overt acts to prove conspiracy. Uh-oh. Uh-oh. Brian's still about to go to work. Brian's still about to go to work. Even if a statute doesn't explicitly require overt acts, they can still be important for evidentiary and procedural reasons. Okay. Even if a statute doesn't explicitly require overt acts, they can still be important for evidentiary and procedural reasons. The only evidentiary things that we've been going over are statements. That is the only evidentiary stuff we've been going over this whole week is what somebody said. It's what somebody said. What up, Doe Q? What up, Doe Q? Appreciate you stopping by. So that's the evidentiary stuff we have so far. Okay, Ms. Love. Right now, you're not really, you don't look like you got the overt act thing. Only one overt act needs to be proven, and it doesn't have to be committed by the defendant personally. What? Only one overt act needs to be proven. It has to be proven, okay? And it doesn't have to be committed by the defendant personally, but it has to be proven. This is the thing, though. The state is trying to utilize and prove things based on testimonies. They have 170 witnesses. Didn't they say that? Didn't they say they had about, I think in the very beginning of this try of this case, had about two, they had the list was about 200 or something. And then Judge Whitaker said, hey, can you make this a more realistic list? In other words, do you need to talk to all of them? Are they all gonna say the same thing? So if they're overt acts, then how are you going to prove, Ms. Love? The overt act doesn't have to be illegal. It just needs to show that the agreement is being acted upon. You haven't even proven that, Ms. Love. Oh, it was 700 witnesses on the list. That's insane. So you haven't even none of this right here is going to be able to be used, Ms. Love. Conviction under 18 USC 371 to commit a substantive federal offense requires proof that one of the conspirators committed an overt act in furtherance of the conspiracy. You have to prove it. What did Denzel say in Training Day? It's not about what you know, it's what you can prove. Okay, Hoyt. Okay, all right. Okay, Hoyt. Okay, listen to me very clearly. Okay, huh? Okay, no. It's what you can prove, Hoyt. All right. Okay, all right. More than a few federal statutes, however, have a conspiracy component that does not include an explicit overt act requirement. So what are you doing, Ms. Love? What are you doing, Ms. Love? Oh no, you talk as much as you want, Q. Hey, you ain't got to be done. Talk as much as you want. You good? We all have a right to speak. All right, that's what the chat is about. Speak your piece. So what have you what are you going to be able to prove, Ms. Love? Not much. Not much of anything. And that's the problem. You're not going to be able to prove anything. You're not going to be. The overt acts happen when I read it earlier about the fact that the overt acts happens. Like some acts don't have statute of limitations at all, which is murder. We know that there is no statute of limitation with that. But when it comes to armed robbery, when it comes to this particular felony or this particular misdemeanor, whatever the case may be, when it comes to all those things, there's a 4-year limitation here. There's a 7-year limitation here. This stuff happened in 2015. It'll be almost a decade since these things happened. How are you under the law that you all pass, that you all vote on, that you all sanction? How are you under the law going to be able to prove that these overt acts are allowed or should be allowed in your case? You see what I'm saying? You're building a case that you should not have done. You should not have named it RICO. You shouldn't have named it RICO because as you can see, there is no RICO charges that has any proof to it. No evidence, no forensic evidence, no ballistic evidence, no anything. No anything. What was it? Some Xanax and some other stuff. I think that was it Gunna? He was the one that got pulled over with something or whatever, and some money, whatever, all that kind of stuff. That's about the most you got. And that had nothing to do with RICO. It had nothing to do with RICO. So, I think it infuriates me that the prosecutors, they have the right to mischarge you and they don't get in trouble for that. How many times does a person get prosecuted and the charge is not categorized properly? And the prosecutors do it over and over again, and they never get in trouble. They never get disbarred. They never get fined. They don't go to jail for 30 days or 40 days or whatever. Nothing happens to them. Nothing. You know why? Because the 14th Amendment, I believe the 14th or the 11th Amendment, it's the 11th Amendment, I believe, that gives prosecutors absolute immunity. Absolute immunity. That's a good question, Q. This is a great question. What's the consequence to a judge if a trial decision is reversed? Let's say, for instance, a judge puts a person in prison, and he's an innocent person. Then he proves he's an innocent person, or she proves that she's an innocent person. Through the appeals, they get appeal, and then the appeal say, you know what? The judge was wrong. The prosecution was wrong. This person is innocent. What happens to them? Nothing. And that's the problem. Justice, it's only justice if it's just us. We are back. We are back. I'm going to step away for a minute. Got to make a phone call, but I'm going to go ahead and let this play. We are right back. Here we go.
so I have just received about 2 minutes ago, the state's, well, no, the state's proposed instructions, 105 instruction, and then an instruction in the event that Mr. Copeland decides. Oh, sorry. I know, I have to tell myself to talk into the microphone. Sorry about that. Okay, so a few minutes ago, I received, and I assume y'all all did as well, yes, the state's proposed instruction on 105, and then a proposed instruction in the event that Mr. Copeland does not grace us with his testimony beginning Monday. So I'm just looking at those right now, and those look pretty good to me. I don't know if y'all have had a chance to look at them or not. I don't know if y'all come up with your own instructions for us to ponder, but this is the only new one I've gotten so far. I think y'all were all hard at work until you just came in on something as well. So if y'all want to forward what you have, that would be great.
Your Honor,
Yes.
regarding the jury instructions, I think Ms. Westmoreland is working on typing one up,
Okay.
but I'm just going to say it is very lengthy and
Okay.
also addresses a lot of, it's going to be very lengthy. I'll just put it like that. Because we feel that it needs to address every alleged overact and who it would not apply to.
Okay, well,
So we could possibly come up with, go ahead. We could possibly come up with a general charge, but then it
Okay.
would have to be repeated for every overact for every individual who is not charged substantively with that overact.
okay.
Is that fair?
Why don't you give me the really detailed one and then also a more general one? And it may be that even if we don't use the really detailed one now, we use it, you know, at the end of the trial when we're giving them all the instructions. But I'll take a look at both of them. And I know we are going to need to sort of give each other a chance to look at what's been cross-proposed and then make edit, come up with something else and then actually figure it out, which, you know, maybe can happen in the next hour and a half or 2 hours, maybe can't. But this is finally a good start. So, do you need a little bit more time before you send whatever you're going to propose? Okay.
To do it right.
Like 30 minutes, like how long?
Just to do it in general. I think that we definitely can do this. And I think that that it deserves, attention. And as you mentioned earlier, that we need to be specific so that the jury understands what we're trying to, what you're going to convey to them. With that being said, I think that it's going to take longer than an hour.
Okay, so I guess I'd rather have it late and good than not at all, but I am having a really hard time understanding from not necessarily everybody, but not simply one person or one side either, why when I say kind of A, over and over again, and B, with a week or more's notice, I would like for y'all to be working on this and provide it to me. Why lots of this is still not provided in a timely manner. And y'all don't have to give me an answer, but I would like for y'all to stop doing that. Okay? Because we are in the middle of this trial, as y'all all well know. And, one of the complaints made by the defense is, man, the jury's been out so long, they're not even going to have any idea what we said before. And the longer we take on everything, the longer the jury stays out. And I'm having the jury back on Monday at this point. And it should not have been a surprise that we were going to talk about this today. And y'all should have already had whatever you wanted to propose ready and in final form. So let's please try to be more timely with the tasks at hand. Okay.
You're only talking to Ms. Love.
All right. So
I'm not even break it down on the defense.
I think maybe we'll all be here really early on Monday I'm going to give y'all all orders so you can get in early, and we're going to be here starting at I may need to find out from the deputies how early we can have our defendants here and ready to go. I mean, I was thinking 8 a.m. and I know that means an early day for everybody, but since we can't spend 3:30 to 5 talking about this, what can we do? What's the earliest we can do? Can we do 8 a.m.? All right. We're going to be here 8 a.m. on Monday. And we're going to, finish, and y'all work together over the weekend, over Friday and the weekend, to the extent you can, to narrow down any disagreements or discrepancies and bring to me only what still needs to be hashed out Monday morning. Okay. Yes, ma'am.
Judge, I just want to make sure, so as our position is that some of the instructions would be better given at a different time than Monday. Is it a certainty that the court is definitely going to give it at that time, or is the court open to hearing any, law or any?
It's not a certainty, but it's a probability. And yeah, if you got law, I'll consider it, but you don't have to wait till Monday morning to send it to me either, but it is a probability.
Okay, I'm a little bit. I may have to rewind so I can see what happened. I had to step away for a minute, guys. I'm sorry.
Your Honor, do you want objections to the state's proposal or just a re-proposal so you can then evaluate it? A separate proposal. In writing.
Right now, I don't think necessarily want objections. What I'd like is for y'all to try to work together on something.
Okay.
I mean, if you think there's some entirely incorrect legal concept, but I'd really rather y'all try to get together on it first.
I do object to it, but I think that makes sense because I could do all of the objections.
Okay. All right. Thank you. Okay, so given that we are not able to sort out jury instructions right now, and I think we have
Oh, okay.
dealt with all of the evidence that we think might be, objectionable, that we need to hash out beforehand with regard to Sledge now. Is that right?
I believe so.
Okay.
I saw some inquiries over the time that you wrote regarding a couple of exhibits maybe that were.
Yeah, and I don't know if those were objections as much as they were just, we need to sort this out, so.
So certainly we would not be entering the same piece of evidence under two different numbers.
Yeah.
We just wanted to make sure that we got.
Yeah, no, I mean, so yeah, just take a look at that and. Yeah. Okay, so yeah, I don't think that was an objection. That was just kind of an observation. All right, so then who's our next witness that we can get through evidence on?
Well, we
Do
back to
our
this.
Motions in
Evidentiary
limiting
statement.
on.
She keeps saying things like, this right here, I think be timely isn't much of an instruction. Absolutely. Give an actual deadline to when you want something. Give an actual
Oh, and
deadline.
Miss
when you
Miss
want
Love,
something.
I know that you have now given to defense
This is going on long enough.
counsel the detailed list, right? But have you given that to the court? Didn't you give them something?
I shared with them the bucket of physical exhibits for Sledge and a list from yesterday. And I'm about to send over another bucket for another witness. So as opposed.
Good.
To be able to give all of the exhibits themselves.
Mm-hmm.
That's what.
So are you then not just, so I understand, are you providing the actual exhibits?
That's what I had.
Okay.
Why?
I mean, that's fine. Fine with me. What I want to have happen though is, have you now only done that for Sledge and you're about to do it for one other?
The actual exhibits?
Yeah.
Yeah, because Sledge was the next.
Right. Okay. So what happened to the tranche of the first 30 witnesses?
So that I was working on that.
Okay, they were due yesterday.
So that's what I'm. That's what I've been working on.
Oh, wow.
She
Turn
really
your
hasn't
mic
said
on.
much.
I haven't said much. Yes, I.
She was speechless for a minute.
No, yes, I was.
And now she says that's what I've been working on.
No.
Okay, so, and maybe you're confused about what it is that I want produced. If you have got,
Dang, dog.
if all you're using, for example, with Thomas Burnett is demonstrative pictures of the infinity, and they have all the demonstrative pictures of the infinity, and demonstrative pictures of the infinity serve, XYZ date as, item number 73B, that's fine. I don't expect you, unless it's easier for you, to reproduce those things. I do want you to identify it specifically enough that they can go, oh, here are the 10 pictures she's going to use. And I hope you don't have 10 pictures because that would be excessive with this one infinity representative. So does that help a little bit? But I do want it to actually have happened for 30 witnesses at this point in time, because we can't
So
The way to operate this trial is not witness by witness at this stage of the game. Okay, so do you need clarification beyond that?
no,
Dang.
no, Your Honor.
Okay.
I have all of the exhibits in folders.
Okay.
So what I was doing was trying to extract the specific ones. So for the 30 witnesses, we have the exhibits in 30 folders.
Okay,
And what I had done was label them and
Yeah.
extract
okay,
relevant ones and send them over.
okay.
And so I won't do that. I'll just go through the folders and put it in a table, because I was actually gonna do that for the ones that are listed. I was actually sending the list yesterday. Mr. Atkins sent it for me just to say, hey, here's what we're sending you. But
Okay, whatever is easiest, and I mean, if it's easier to have them each give you a thumb drive, that's fine too. I mean, logistically speaking, you know, I just want them to know with some degree of specificity, here is the actual evidence they are going to be using with this witness, not social media. But
I understand.
what social media? Okay. But they should have been served at this point in time with everything you intend to use with every witness.
they have,
Okay.
and understanding the court's instruction about making sure about anything that the court told me to
Yeah.
give to them. By note. So both of those.
Okay.
I understand. And yes.
Okay. And so when can they expect the next 27 or 28 witnesses info about which exhibits?
So
Now, you
we're
just talked
gonna
about something in a timely
upload-
manner.
Okay.
Because it'll be probably quicker to upload them to a Dropbox link than it would be
Okay.
to sit and, or maybe we can have some team members.
Yeah, I
typing and
mean-
some uploading, so.
Okay. And can you share it with the court as well, just so I can have it as well? Okay. So by the end of the day?
As in an hour and.
I
change?
mean, I figure you're gonna work past 5.
I have.
So what I kind of mean is by midnight. Okay. All right. And then is everybody, okay. So are we ready to work on another witness's chunk of evidence that we think
This
might
is sad,
be
dog.
subject to motions and limiting?
This is sad, bro.
Your Honor, if the
Yes.
court will give me a minute just to get my list.
Okay.
Your Honor,
Yes.
may I bring up another potential issue?
Yes.
So it's my understanding and belief that that there may be some outstanding Brady material regarding Antonio Sledge.
Okay.
Brady to include impeachment.
Okay.
My understanding and belief is that the state may have met with Mr. Sledge and he may have said some things that would fall under Brady in
Okay.
a prior meeting with the state. I'm not asserting that as fact,
Okay.
but I am inquiring about that. If
All right.
there was
Can
a
you-
prior meeting with Mr. Sledge
Okay.
at a
What?
coffee shop.
All right. Was
At a coffee shop.
He is, Mr. Shard is correct. I was at the meeting and an investigator, Lancico was at the meeting. There was nothing that I took to, I'm going over in my head everything he said.
Okay.
Didn't say anything.
I'm gone.
I don't know what part of
Okay,
that meeting.
so,
Mr.
do you two want to huddle together and maybe Mr. Shark can share with you what he thinks got said and then you can confirm or?
Yes, would the court give us a moment just to step outside now, or do you?
Sure, or
How about you do it right now, right now?
I don't know
Nuh-uh,
what
don't
was
step outside.
said.
Okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
My understanding is that there may be Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
Okay.
then I wouldn't have an issue.
Well, since there, Mr. Sledge's attorney was present at the meeting. So if Mr. Shart has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege. So Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe would Mr. Shart, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine, but.
I prefer not to.
Okay. All right. She seems a little in the dark on what might be. I mean, I don't know.
Not the source, just if he would, just the content. I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material, and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything, or said before, that would be
That would be
considered
impeachment and
would-
therefore Brady. Yes. So you have
Oh.
reason to believe that he may have said something at the coffee shop inconsistent with something he already said.
I'm
Can
asking.
you be more detailed with regard to which thing it might be inconsistent
I
to,
don't,
or you just don't know?
I don't know,
Okay.
and that's why I'm asking.
Okay.
There were four people. There were
Even
four people.
even Bruce
in the
Harvey in it.
meeting.
Mm-hmm.
Oh my
If
God.
anyone's recollection of those set of events are different than mine, I'd like to know what they are, because mine is not that he said something inconsistent. And as I said, the people who were there are me, Mr. Sledge, Lieutenant Lancico, and Mr. Sledge's attorney throughout the entire time there. So.
All right. Well, it's.
Oh, she didn't think.
relevant
Oh, she didn't think the
issue
coffee
is
shop was
not
gonna
who
come
was
up.
There, the relevant issue is, did Mr. Sledge say something inconsistent at the coffee shop with whatever
Look at
he
her
has
face.
told the state or
I
law
don't know,
enforcement
Judge.
previously? I
Oh.
guess any of those four people
What you mean?
could sort that out. The best two would be, well, the best one would be you
What
if
you
you were the
mean?
prosecutor there, because I mean, I don't know what else to say. Maybe there's nothing, but maybe if you've got notes, or you and your investigator get back together and think it through and try to figure out whether he said anything that's
Me too.
inconsistent. And
Me
I mean,
too.
that's, I don't know what else to do.
So they met at a coffee shop, and he said some stuff that was inconsistent, but he took a plea.
So,
Oh, that's
Cool.
dirty.
Search our collective memory.
Okay.
And if you, I am really interested in speaking with Mr. Sharp about what he is talking about, so that I can understand where.
All right,
So
I'm not
I
sure he
think
knows.
Different. Somebody has said the word Brady or something, and I don't. Well, I will talk. We will.
Okay.
search our collective
Something inconsistent.
Did anybody take notes? I mean, we had four people there. Nobody took notes. Nobody recorded
I don't know
it.
that we know that. I don't know.
No, I'm asking. We're entitled to it if that's what happened.
Well,
So the
if it,
answer is,
hang on. Mr. Harvey, talk to me.
I-
Don't talk across to opposing
I am
counsel.
not. I am just somewhat astounded that we had four people meet at a coffee shop And nobody took note number one. Nobody,
Mr. Harvey, no one
nobody
has made that
recorded it.
assertion.
Nobody recorded it. I'm asking if there was a report, if there were notes taken, if there was a recording, we would
Okay.
have something to review to determine whether or not there was something that should be provided to us.
Okay.
Okay?
I don't know whether that happened or not.
I would, if I had I did not record our interview.
Oh my
our
God.
Conversation, because
This
I
is
would- I would
crazy.
Turn that over. I did not record our conversation.
Okay.
It was literally a conversation.
Right.
And that's it.
Okay.
What?
Sorry, I missed it. I understand then that not a single person took any notes of that meeting.
So I don't know if Ms. Love can speak to what Mr. Sledge or Mr. Sledge's attorney may or may not have done.
I'm asking from the state. It's the state's obligation to provide it to us. We don't have to go out and talk to
I
anybody.
understand.
All right. So I'm just inquiring as to whether there are any notes, and I'm just surprised. Well, I would like an answer as to whether or not any notes
Were taken.
Thank you.
Two things. I did not take notes. I talked. Lieutenant Lancico, as she sat there, she looked around and listened and looked around our surroundings. We were not within Fulton County.
Okay. So no notes?
No.
All right. No notes.
I would not, well, there are no notes. I did not take notes. She did not.
Okay.
My notes are not something, my investigator's notes would be something to which either of the defendants would be entitled. My notes would not.
Because they're attorney work product.
Yes.
However, if there's something Brady in your notes, then as you know, you need to provide it. And if there's something Brady that you hear, then you need to reduce it to writing and provide it. We talked about
This is
this before,
nasty,
you know
dog.
that. And so you are maintaining that no, you didn't take any notes. No, your team didn't take any notes. As far as you can think right now, nothing Brady impeaching was said. You will give it some further thought along with your
His attorney.
Sure.
Make sure that I
Okay.
check. His memory was
All
mine.
right, that's all we can do at this point. Thank you for raising it so that they can think about it some more. Yes, sir.
Your Honor, you asked the state, pursuant to my request, whether there was any Brady whatsoever from any fashion, not only impeachment evidence, but exculpatory evidence. And the state said, let me think about it. This, I believe it was yesterday.
Right.
And I'm presuming by the silence, there's nothing.
All right, so I think I gave y'all, remember I told you to huddle with your team, not just on Brady, but on anything that is discovery that you intend or think you intend to use that they might not yet have. And I think I gave y'all until Friday to finish that huddle and get that answer back. So, yes, so I think they're still huddling on that. And by 5 p.m. on Friday, if there is anything, please detail it in at least an email.
We're going to
in
read it.
writing
We're going to
some
read it in a
way
minute.
that you send to the defense and to the court.
Thank you, Your Honor.
All right. All right. Any other
Oh my goodness.
issues before we get
Oh
to
my
the
goodness.
next witness
There was a-
that we might have evidentiary things to sort out on?
There was a conversation at a coffee shop with a man who took a
All right.
with Mook too.
Okay. Okay. Who's the next witness now that we should turn to?
What the heck, bruh? So was that ex parte?
To sort through their evidence.
Oh man.
So we've done Sledge and Zachary. Then also on that list, coming up after them is Detective Thorpe with the Kendrick interviews. Have y'all already hashed that out?
So so Your Honor, I'm glad, thank you for reminding me. So with respect to the Kendrick interviews, we needed to bring to the court's attention. I don't expect to be playing them or getting into them by next Friday, but we had.
Okay. Okay, that's fine. But remember, we're not doing this week by week anymore. We're doing as much as we can possibly get through beforehand. All right, but anyway, okay, go ahead.
We had previously, Mr. Weinstein, Mr. Kendrick had filed a motion to suppress his statement. And the Honorable Judge Glanville heard
Honorable
from Mr. Weinstein.
But didn't decide it?
He decided it as to the portion of it beyond a break in the interview.
Okay, and that part got suppressed?
So that part
All right.
got suppressed. But as to the portion before, I believe that there needs to be a Jackson. Didn't hear no less, there's no argument about it because he did not suppress the part before. My witness was here, but permitted to put him on a stand, so,
okay, so a part after some break was suppressed. Was an argument made that the entirety of it was should have been suppressed?
no, I think that, no. Mr. Weinstein argued that just.
Okay, well then it seems like there's not anything pending. Is that correct, Mr. Howell?
Sure, I am jumping into this.
I know, so am I.
I will need to check with Mr. Watson. I should have an answer.
Okay, all right. All right, so we think that whatever wasn't suppressed is legitimate to be presented, and so there shouldn't be other issues as to his statement or statements. Is that right? Is it more than one interviews?
There's more than one part of it, but no,
There's only one interview, and obviously you're only using the unsuppressed part. Okay, so, and that'll be Miss Detective Thorpe's testimony at that point in time.
So. There is, so we will need to have an argument because there's a.
Speak up, because I'm sure they're gonna say they can't hear you.
There is a second one.
Okay.
And so the argument may be, hey, we needn't reach that second one because in the first one, this break occurred and everything beyond that point should be suppressed. I would have a different argument, but we have not even looked, we got to one interview.
Okay. And you would like to use the second interview?
Yes.
Okay.
We would object.
Y'all, this is just, was there no deadline for filing challenges like motions to suppress? Okay, I'm gonna need that motion. If there's a motion to suppress the second interview, I'm gonna need that ASAP, and not just this interview should be suppressed. You tell me why. You tell me the legal basis. You tell me the facts that back it up. Give me a specific motion to suppress, a particularized motion to suppress.
Well, the opinion that original order covered everything past.
All right. Anybody be able to point me quickly to date of original order? Okay, thank you. All right. Yes.
Let's go with March 18th.
All right.
And I just emailed
Thank you.
and
All right, so I'll take a look and see what that seems to say.
This is crazy, y'all. What just happened, dog?
All right, the next thing would be, or the next witness would be Mr. Bean with text messages.
So we, Judge, I think since we talked about Mr. Zachary's interviews, I think that Mr. Bean won't be the next one. Mr. Zachary would be before Mr. Bean. And there are social media postings. I don't think that there is going to be any kind of an issue, but just I can name them or send them or share them.
Well, if you'll share them with the defense, then the defense can see whether they've got objection. Does the defense think at this point that they have objection to Mr. Bean's text messages or social media? I assume y'all know what she means by that.
Judge, I don't, so unless something in particular happens to allow us to introduce it, the state is not going to, I don't anticipate using those text messages of Mr. Bean.
Okay. All right. Can you send me that whenever you get it?
Your Honor?
Yeah.
May I add to that? Just to be fair, those text messages, my opinion, come from a phone that was seized on July 15, 2015 from Mr. Williams' home. It's been suppressed in all derivative evidence.
Okay.
So, and I'm assuming that's why the state said that, but if it is going to be used at all, I think we need just to alert the court that we'll need a hearing on it.
That's why you don't intend to use it.
Right, and that's why I said unless something specific happens, unless there's a door, anything, I don't know, but we don't intend to use that in our case in chief. I don't know. I don't foresee a circumstance, that occurs.
Yeah, I don't foresee a circumstance where that would be permissible either. All right.
If an attempt were made to make an argument that is directly refuted by something that was suppressed, I might ask the court, hey, Your Honor, this argument was made. This is not true. We have a reason to believe it's not true. Here's why we think that. Would the court consider X or Y or Z as a curative?
I mean, if you want to provide me some really specific case law that says I can do that, sure, but I wouldn't waste your time on that right now. Okay, so Bean will probably just be some social media postings. I mean, if I had the more detailed list, I could.
I don't, right now, it would be testimony.
Okay. All right. I'm just trying to figure out what we can make progress on while we're here. Kenya Morton interview.
So Kenya Morton would, it would be her interview to impeach her if necessary. She is listed as an alibi witness of Mr. Kendrick.
Okay.
And so
okay,
her interview is the
all right. And everybody's got the interview. Anybody anticipate, assuming they're going to impeach, that there are other issues with her interview that I need to think about evidentially right now?
and we have impeachment, but it will be impeachment and substantive. Since there was an issue raised, but That would be the only thing with Ms. Morton. And the other pieces of evidence that would be used with Ms. Morton have already been introduced.
Okay. Easy enough.
Introduced through another witness.
Okay.
This is wild, dude. This is wild. So Antonio Sledge is the
So
one.
I've just looked at the very first paragraph of the order on Mr. Kendrick's statements that's filed March 18th of this year. And I haven't looked at the end of it yet, but it certainly says the motion to suppress was as to an October 6th and an October 12th statement. So I would imagine that he covered both, yeah, continuing through the entirety of his October 12th interrogation or suppressed. So yes, that second one has already been ruled on and is not allowed. So it's the October 6th one prior to the 2:16 PM mark. Okay. All right. So that answers that. That one was an easy one.
Miss Love did not know that they knew about that coffee shop situation.
Bruton issues in that it's a law enforcement statement. I will look at it though and alert you.
All right. So we would definitely need to sort that out before presenting it to the jury too. Okay. So yes, thank you. And just share with the state whatever you think about that so that they can have a response prepared. And normally Bruton, not necessarily normally, but oftentimes Bruton issues can be cured by redactions. So if you've got proposed redactions that would cure it, that would be immensely helpful.
We'll send over anything.
Great, thank you. All right, and then next, at least on this list, is Mike Sprinkle, who, I mean, I don't know what all, is he going to be testifying to stuff that's already in evidence or new stuff too?
A combination of things because ADA Sprinkle was after the DA's office was given a case, ADA Sprinkle went and continued to research and work on it.
Yeah.
As a result of what he found, different persons were charged.
Right.
So he would be speaking to both jail calls that he found.
Okay. And then is he going to testify to the contents of those jail calls? And
he would play them, not.
okay. He'd be like, I found this jail call and it's between these people or, okay. And you'll give the defense, if you haven't already, details of what those jail calls are, when they occurred, et cetera. Okay.
Yes, and also, for instance, Martinez Arnold is a witness further down.
Mm-hmm.
I don't think he's on this list, but he is a witness that we are intending to call. So we would not endeavor to put, before Martinez Arnold testified, we would not be endeavoring to put his jail calls in.
Okay.
But for instance, Mr. Stillwell's, we would. Mr. Sledge, he would have already testified. So anything that we needed to impeach him on or anything that he didn't, Mr. Sledge denied knowledge of or refused.
All right.
So,
all right.
So, Your Honor, my client has about maybe a dozen jail calls listed under Mr. Sprinkle in the spreadsheet that was shared yesterday by Mr. Adkins. They had previously identified, I think, 4 calls And so there's additional calls. I still need to review those calls.
Okay.
Because that's the first time they've been specifically
Okay.
identified beyond those
All right.
four.
And I mean, sometimes people continue to make calls and Mr. Sprinkle probably continues to listen to them.
Well,
I don't
these are
know.
from
when they
2015,
occur.
but
Oh, okay. Well, there are a lot of jail calls to get through with some people. So, okay. So sure, we're going to have that whole week in another week that starts on August 19th. So maybe we'll be doing that then.
yes, Your Honor.
Okay. Thank you. All right. And then it looks like there's a series of custodians of cell records. Do y'all anticipate objecting to those people? How about for Mr. Kendrick? Mr. Nichols? Mr. Huey? Okay.
Caveat, presuming of course that we've got all of the business record certifications. I think we probably.
I would certainly hope that, but yeah, y'all have certifications for this. All right, so those will be easy witnesses. And
Adam's
then
dog.
Bernie, this was the guy we talked
Adam.
about yesterday, but you were saying the report he's going to be providing at this stage of the trial is not that new-ish one. It's something else, right?
We would not be endeavoring to have him talk about the two new ones that he plotted. We would
Okay.
only be presenting the plots of the cell phone numbers that we had previously provided to the defense.
Okay. All right. And then we got a firearms analyst, which of course there'll be lots of cross, I would imagine, maybe not, I don't know, on the stand, but do we have any like motion and limine type issues that y'all know of with regard to the firearms analyst? Things I could be thinking about beforehand?
Unless there's recent United States Supreme Court opinion, I have to refresh my memory whether there's a surrogate witness, but otherwise, no. It's nothing from us.
Okay. All right.
I'm sorry, I couldn't hear all of what Mr. Steele said. If you could
Do you mind repeating that?
Not at all. Unless like a crime lab person left the office and this is another person coming in to say we reviewed notes, but he or she didn't do the testing. There's a new United States Supreme Court case, I can't remember, but came out within the month.
Yeah.
That talks about that's a Confrontation Clause violation.
This is the same person that actually did the analysis to begin with?
So both Mr. Weitzel and Mr. Voss physically analyzed them.
Okay.
Neither are still with the GBI.
Okay, but they're going to be the ones that come and testify.
Yes, I don't at this point, unless something has happened to them. I haven't.
All right. Well, maybe get somebody on your team to check and make sure they're still lined up. Okay. Super.
Your Honor.
Yep.
As we go. No, not that. There was one set of instances, and this is something that will be included tomorrow, but just as I'm thinking about it and looking down at the next few witnesses. So we have provided crime lab photographs, APD photo lab photographs for the intrinsic acts, the shootings that occurred after the murder of Donovan Thomas.
Okay.
One of them, I think April the 28th, we provided a crime scene technician's report of a set of photographs.
Okay.
the actual photographs, the lab said it could have either been affected by the hack or what. The description of each of the photographs was listed in the crime scene report.
She is so.
I've asked the lab, do you all have a physical copy of whatever you uploaded to your server that may have been affected by the hack? I have not received anything from them.
Okay.
And that's something that while I looked at it as we were sitting here, that I wanted to.
Okay, and this would be photos from which crime scene?
It is the one Adele Avenue, 1428 Adele Avenue. The crime scene that is 1180462, 151180462.
All right, and
The
they
hack,
no
really?
longer have the originals, or what's the
Really?
deal?
They,
Because a description of the photo, I don't.
I don't know. They've been looking for me. So
Well, do y'all have copies of them?
No. So that's just it. We didn't have the photographs themselves. If we had a copy of them, that would be great.
Right.
But we were never given the photographs themselves or a disc of the photographs themselves. We just got an email or a response saying, we couldn't locate this one.
And this is APD?
Yes.
Took these photos?
Yes, and crime scene Turner.
Yeah, okay.
Actually, that's the tech. We have all the information about the photos. They just don't have the photos. Or at least they said they couldn't find the photos. And I have someone on the inside who's trying to get the photos, looking for the photos. They have not been located.
All right.
That's it.
So, I mean, I would think that, I don't know how well a report of what the photos show is gonna do for anybody, but.
She is so full of it. That is
What
bull.
witness is this gonna be?
That is, so Denise Bell.
All right.
The witness who was the.
She's so full of it.
Okay,
dog.
so
That's the person who's one of the people who were inside the house.
Oh, right, okay. Well, we may just have to have a description from the witness's memory as to what things look like if y'all can't find the photos. Because I mean, and you can provide the report, like, I mean, what were you even thinking you might do instead if the photos can't be found?
They have the report. We turned over the report.
Right.
I mean, if the photo, if they just don't,
I mean, there are all kind of creative things that might be able to be done if this place still exists and looks the same as it did. I have no idea whether it does. If the report is descriptive enough that somebody who has artistic talent can draw out a really good diagram, that might be a solution as well. But I mean, I don't know. I doubt if just I don't know. So, okay.
that was just something I wanted to.
All right, well.
Something that I'll go in detail about if I have to tomorrow.
No. Y'all are on notice of that, and to the extent you think you might use some substitute for those photos, if those photos cannot be found,
I don't have any.
talk to, or what do you think? I mean, do you think you'd probably just have a witness describe it, an eyewitness describe it?
Yes,
Okay,
I can.
well, that's fine. All right. Okay.
This is
So-
unacceptable.
Miss Latners is a witness that we've called and have had to call at different times regarding the 911 calls. I don't know that there are any objections to them. There have in the past been some objections to 911 calls, but
To the contents of them or to them coming in at all without?
To the contents of some of
Okay.
them.
We had a long discussion. Judge Glanville excluded part of a 911, one specific 911 call because it was not for an ongoing emergency, and it identified a person, in that case, Mr. Williams, but the speaker, the caller, 911 caller, was not available, so we could not confront. So it was a confrontation clause issue, is what the state's talking about. If I have the 911 call, I will look at it and make sure that there's no issues. And that's under Pitts, Pitts versus State of Georgia. I believe it's a 2006 case. It was written, I believe, by the Honorable Justice Sears. It's cited, I know it's under old law, but it's cited in 2023 or 24. It's a great opinion, actually, by the Supreme Court of Georgia. But I think that's what Miss Love is referring to.
No, we were talking about the ones that are coming up. We're not revisiting the ones that.
Right, right. Yeah, yeah.
What I'm
But
saying.
okay, so as to whatever other 911 calls, y'all know what other 911 calls they intend to introduce?
Those are the ones that are listed on the list that the court has in front of it.
Which I just have this exhibit list that doesn't have any detail. It just says 911 call.
Yeah, that's what I have.
So,
I don't have the
okay.
new list you
So,
shared.
The 911 call and the CAD report from 151.
Oh, okay. I do. Yep. Club Crucial, 1428 Adele and 1903 Drew. Okay. So y'all, the defense know what all of those 911 calls are going to be.
I could link it up, yes.
All right. And you're going to be getting that more detailed exhibit list over anyway. So I mean, whether you have an exhibit number for them or not, you could be like, if 1223, 1248, 1255
Yeah,
or
we like
whatever
to submit this in little
on whatever
folder.
date. And then they'll be able to search their discovery and find it and figure out for me whether there is any objection to the 911 calls, content or otherwise.
Yes.
Okay, so that might be something we have to deal with. All right. Yeah.
CAD reports. I have a case for the court. I have to just put my finger on it, but certain information on CAD report is also a confrontation clause. I'll get you the case.
All right, and then point out for me, as to whichever CAD reports are going to be used, what is objectionable. All right, thank you.
This is pathetic. Absolutely pathetic. Did she say the hack? Did she say the hack is what caused the? Did she realize what kind of hack that
All
was?
right, it looks like the next few are
Jeez, oh, Pete.
not necessarily any objections other than the normal ones in a trial. How about, is this number 26, at least on my list, Tyrone Dennis, is he just has a lot of different types of evidence listed next to him. What's his, is he law enforcement?
He is,
Okay.
he was one of the lead detectives
Okay.
that investigated that assisted in the investigation regarding Mr. Thomas. and
right,
later
yeah.
on.
We've heard about him in our videos we've been listening to. That Dennis. Okay.
Yes.
So, is he going to be, do y'all know generally what evidence he's going to be testifying to? And do you think you're going to have objection to it that we can take up beforehand?
So he is also, in addition to being a fact witness, he's also one of our gang experts. I think.
Okay.
I don't know if that was brought out before, but as it relates to the social media, some of the social media posts between Mr. Garlington and Defendant Williams, the we ain't going back and forth social media posts, I think some of them we may have already put in, but
Okay.
the social media posts between Demikion Garlington and Mr. Williams, I'm Screaming 30, Fuck a Blue Jean Bandit. Other social media posts that we've specifically identified and I'll send over. Between Mr. Garlington, Mr. Stillwell, Mr. Arnold, and Mr. Kendrick. Photos of the gun recovered by law enforcement from Mr. Kenneth Copeland that belonged to Quindarius Zachary. A photo of the gun Mr. Zachary was arrested with on May 7, 2015. The video of Mr. Arnold getting into a fight with Kelvin Watts at Magic City on September 30th, 2015, which led to the subsequent arrest of Mr. Kendrick, who was in the car with Mr. Arnold. Following that fight, and at which time Mr. Kendrick was found to be in possession of a gun, and it led to the revelation that they were going to retaliate against members of a rival gang at this apartment complex.
Okay. All right, and then you also have music next to that. Is he gonna just testify about certain songs, or what's that gonna be?
You would
Certain songs.
intended to play portions,
Okay.
not whole songs.
Okay, and he'll give his gang expertise about what
Yes,
all
that
that
is-
stuff means. Has he already testified once? Has he been qualified already? Okay,
Yes.
all right.
So
Yes, sir.
a couple things about the state's proposed evidence about through Mr. Dennis or
Mhm.
Investigator Dennis. With the music, I'm
It needs to be
interested.
strike that
Are
off, please.
Is the state planning on playing videos, audio? How is that? Are they proposing, of course, over our objections? And
Right, and a lot of that's already been ruled on. Let's find out. Did you intend to play video or audio when or whatever, I don't know what his rank is, Dennis is going to be testifying?
So it's audio, and some of these are the overt acts that we have listed. For instance, Act 78, 60, 74, 95, 97, 103, 125, and 129. So we would be playing the audio portions of the audio.
so strictly audio, no video, no pictures.
No, I didn't say that. I also said that we would be putting in the described social media posts.
Oh, yeah, no, he's not asking about social media. He's asking
Music
about if you're
videos.
going to be playing clips of songs. Is that going to be just audio, or is it going to be video also? Is that the question?
Yes, and if there's video, I mean, we've discussed, from my recollection, and I wasn't the one litigating a lot of the
Right,
free speech, First
Right.
Amendment issues here.
right.
But if there's video, there's certain things in a video that could be problematic to be introduced in front of a jury as well. That's why I'm inquiring. Are we confining it strictly to the words that are spoken?
No. So when we have, so what I didn't make the distinction on my list of which ones we will be entering the videos of. So I will speak with Mr. Sharp and whomever else wants to
Okay.
be involved in that conversation and identify the videos that we will put in as, or
Okay, so this witness is within the first 30, and so by
midnight. You said?
the end of Friday, you need to have details for what specifically, not just music, but, a video of whatever the name of this song is, or, a 2-minute clip from this song.
I can't believe
Here's
music
the
is even
minutes
part
that
of
are
this
included, and
evidence. That's
audio
crazy.
from whatever other song. Detail it for them so that then they can make detailed objections.
And Your Honor, also just to give the court a heads up,
Uh-huh.
87 Lima is operations planner's PowerPoint. I don't have it in front of me, but I'm very familiar with that PowerPoint. That PowerPoint includes all sorts of conclusory language, all sorts of additional information that is not relevant to this case, all sorts of commentary from it written down on the, I believe it was intended to be a PowerPoint to other law enforcement. That's my understanding. I could
Is
be
that
wrong.
PowerPoint that Dennis is?
I believe so. And I understand that the state's intending to call him as an expert, but hearsay and an expert can't be used as a mere conduit to get into hearsay and other inadmissible evidence. And there's a lot of, I'm saying I know I have numerous objections. And
All right, is 87 Lima already in evidence or no?
No, I don't think we've introduced it.
Okay.
Evidence, but they.
Your Honor, when we were served with this, I'll get you the date. I filed a motion challenging the admission, and my memory is Judge Glanville said he's not letting that in and asked the state, and they said they were not using it. Now, if that's wrong, I apologize, but I'm pretty sure that's
Okay.
accurate.
All right. So
I'll check back into our notes because I don't have memory.
don't
of that
remember.
particular-
Okay. All right.
but
Just check
I'll
on that one.
back.
Thank you. See, this exercise may be boring, but it's helping everybody.
This judge is in over her head for real, man. She think this is a joke.
All right. And then there's Arnold, Munson, Kilgore, and Underwood would take us through 30. And it doesn't look like there's, other than maybe Arnold.
Facts. She leave. That's facts.
He
She's trying
doesn't
to
seem to
sneak
have an
stuff back
interview.
in.
He just has jail calls. Is that right?
Jail calls and the plea agreement.
Right. Okay. And the plea agreement would be kind of the same issues as the other plea agreement we were talking about
Yes.
previously. Okay. All right.
And then some social media.
Okay. All right. All right. So y'all get together on what I've told you to get together on. As far as I know, outstanding, waiting on an order from me are Mr. Stillwell's renewed motion for a fair trial, which I'm finished but have not filed yet. And then Mr. Kendrick's supplemented motion for mistrial, and then Mr. Williams, I don't know if it's two different ones, Mr. Steele, or just one and two amendments to the motion to disqualify the prosecutors. Is that two different things, or am I just supposed to?
You ruled on one because I said I would.
The earlier one, but then you sent two more.
Okay, I remember one,
Okay.
but I'm sure you're right. But I remember one about ethical concerns.
All right. And as far as I am recalling, those are the only outstanding motions that need ruling from the court. Does anybody have a recollection of anything additional? No. Okay. All right. Any other matters that you need to bring to the court's attention or that we can deal with right now before we adjourn for the day?
Your Honor.
Yeah.
Mr. Adams, you're correct. There are two, but there's an amended additional motion that was filed on August 6th at 3:53.
Yep.
And then there's an additional motion to disqualify lawyers Love and Hilton, which was filed approximately 56 minutes before that. But all I added was, all we added was a footnote. That's the only difference.
Okay, so basically one just supersedes the other then. So I can look at whatever the latest filed one is and that'll deal with it.
That's
All
correct.
right, thank you for that clarification. Okay, y'all have got lots to do. Thank you for your hard work thus far. I will see everybody bright and early on Monday morning at 8 a.m. All of the attorneys should already have orders for early entry into the courtroom. Does anybody need one? Mr. Howell, will you be with us Monday or will Mr. Weinstein be back with us? Okay, and he should have one. And our defendants are already with us, so. Speak into your microphone, please.
We've got an old order from Judge Glanville. I'm
Okay.
assuming, I mean,
He's still our chief judge, and it probably, does it just say through this trial?
I don't know.
All right.
I'll have to look.
I'd
It does
imagine
say
those
through
are
the
still
trial. Okay,
in effect.
all right.
Okay. All right. So I will see everybody on Monday, and please do the homework that I gave you. All right, thank y'all.
Oh boy. Yo. What? Listen, I'm sick of her, to be honest. I feel you. I ain't gonna lie. She's a little bit on the annoying side, for real. Okay, that's actually it for real. All right. So Sheila, I have no idea, honestly. I have no idea when she's going to rule on the motions. She gives the appearance that she's going to rule on the motions soon. Soon as in like this weekend, probably. I doubt that she is going to I doubt that she's going to grant those motions, though, to be real with you. But what is up with the fact that there is some extra potential Brady material that we just don't, we just always finding more stuff and more reasons to just get rid of this case, to just get rid of the case, period, right? No, well, the responses that was filed before were from the other motions prior to the ones that got supplemented and amended and all that kind of stuff. Adrian Love ain't filed nothing. Okay, she haven't filed not one response to anything. So yeah, I think, okay, yeah, they're due tomorrow. And you know, this is it. This is it. We'll see what happens. We'll see what they do, what happens tomorrow with those responses. They got to be in by what, noon or something like that. You know, they got to be due. She better not use AI lawyer. I'll tell you that much, because she done got found out. She done got found out. That's for sure. Look. Oh yeah. By the way, we did have a convo in the conference shop, but I just talked. I didn't take no notes. You're right. Who doesn't take note? This is your Antonio Sledge, man. This is your. Jeez, Pete, man. Look. Let me see if I can play this real quick, because they're saying it seems like Mad Max got some inside information that he was not willing to share with the court. And I think I have an idea of why he did it that way, is because he don't want to say something out loud. He want to see if she's going to tell the truth first. And I have no idea. I don't know. Did you take any notes? Did you record anything? And my man, Bruce Ponytail Harvey went nuts. He's like, Your Honor, how many times this is going to happen? You know, you mean to tell me you had no recordings, you had no notes? Okay. You sit in the coffee shop with Antonio Sledge, Moot Toon, and you don't have any notes. Wow. Why is that? Why am I not surprised? Again, why am I not surprised? Let's go into something real quick because we do have. It says here that he took the plea deal. Let's see how Woody feel when he, yeah. Let's see how Woody feel when he wake up on Monday. He got to be there 8 o'clock in the morning. Man, look. Yes. Remember, Woody said the person that did it is not even in custody. So this is all bad. This is nasty work, man. Once again. So I guess I could play the video. I found this video of the day where Antonio Sledge was in the courtroom with Miss Love and everything like that when he took the plea. Let's take a look at this real quick. Hopefully I found this. So hopefully let's see. Hopefully this will give us some type of something here. Hold on, let's see.
Which means that the state will recommend to the court the following sentence.
Yes, ma'am.
As to count 1, 15 years to serve on probation subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true.
So basically, she's reading the plea deal. Yeah, it's the video. It's not nothing I can do about it. The video. Let me see if I can find a different video though. As a matter of fact, let's see if we could do it this way because I think I found the article for it. Yeah, I got the article. Let's go ahead and do it this way. Hold on. Hold up. Wait. Let's see here. I got the article.
Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers.
Put a 1 in the chat if you can hear that. Let me know if you can hear it real quick. This is her. I guess this is her because he's pleading guilty to pretty much the first count. Oh, I got it all the way up here. Okay, I got some more stuff to look at. Oh, okay, hold on. Let's do it this way. So yeah, it says 7th man entered a plea and with wide-ranging indictment against an alleged criminal gang linked to rapper Young Thug called Young Slime, blah blah blah. Okay, this is This is when Mutuk was getting sentenced. Well, plea deal was being read in front of the court. Another plea deal in Young Thug case, co-defendant Antonio Sledge, aka Mutuk, pleads guilty to 1 count of conspiracy to violate racketeering act and 1 count of felony in possession of firearm. So basically the whole coffee shop situation. This is crazy to me. So basically, if I'm understanding correctly, and you and Chad, help me out now, what's basically happening is that they had a conversation with Antonio Sledge at a coffee shop. Her, Lieutenant, whoever she said, I forgot the name, Mr. Sledge, and his attorney. It was no notes, no recording, no anything. Okay. The only reliable source I would say in that whole entire meeting would be Antonio Sledge's lawyer. If I had a reliable source, I would say that would probably be him. To rely on the information. And apparently whatever Antonio Sledge said in that meeting has to some degree a level of Brady violation or Brady material that can exculpate the defendants or the defense or Mr. Stilwell. I'm not sure, but because when Max Sharp stood up and said, he wanted to know what was said in this particular situation. Even Adrian Love said, I don't have no notes, I don't whatever. And the judge said in that particular instance, if you do have notes that have exculpatory evidence, then you're supposed to turn that into the defense. Even though she's like, my notes, she tried to make a process. See, my notes is my notes. I ain't gonna give up my notes. The investigator can give up. If he took notes, he could give up his notes, and they can go to the defense can go to him for that. But my notes, I'm not gonna give up. The judge is like, well, if your notes it has exculpatory information in it, you need to hand that over to the defense. Period. So the problem is, in this particular case, we don't know. We don't actually know. You know what I'm saying? So I'm like, and that's the reason why that's why Sharp wanted her to say what was said, because it seems like Lawyer Love is the type where she'll take what you're saying and try to like piggyback off of it or something of that nature to try to twist it to make it seem like that wasn't the case, when in actuality it is. She like to twist things around and make it seem like something that it's not. Weird to me. Weird, just super weird. But he talked about the fact that he took a plea and he has information about something that can exculpate defendants, but he said something different. What he said something different. But at this coffee shop situation, obviously he's telling the actual truth. And so now it's like, oh, but because he has impeached himself, that is Brady material by definition, right? So we like another bombshell. And I said, and that's exactly why I titled this live. Any more bombshells? Now we get another bombshell at the end of this entire situation, right? So let's take a look at the whole thing real quick. And yes, this case is so messed up. Lisa, I feel you. It is so messed up. Like look, I'm curious as to how this judge is going to rule the motions. I'm very, very curious. They don't have court tomorrow, so we're good for tomorrow. but this is definitely crazy. So Mr. Sledge was at a coffee shop with his attorney and Love and investigator or lieutenant. And then apparently in this particular place where he was at is where he said something that was exculpatory, allegedly or potentially. And now Max Sharp's brought it to the court's attention that there is another issue of potential Brady evidence. And it seems like the defense is not going out looking for it. It seems like it's just coming to them, which it should. I mean, because hey, this is crazy. So let's play this real quick and see what type of plea deal did he get. I don't even know what type of plea deal he got. I know it had something to do with like 15 years or something of that nature. I don't know. Let's take a look. Let's listen real quick.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to today?
Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 1611-133, is 15 years in prison?
Yes, ma'am.
You know what? I'm sorry, but Miss Love sounds like she just love locking brothers up. I don't know if she takes great joy and pride in this, but she's got this. It's like she got this vendetta type spirit in her voice. I can't. Am I the only one that's? Is it me? Am I just? I just don't understand. It just seems like she finds joy and pleasure in locking up brothers. I mean, is it okay? Thank you, because it just sounds like she enjoyed saying that to him. Oh, yeah. That's the whole. That's the thing. Kamala was locking brothers up for show. Okay. Her record, her whole prosecutorial career is all kind of nasty. All kind of nasty. And if y'all don't know about it, y'all go look up Kamala Harris when she was a DA. Look it up when she was Attorney General, Senator. She was locking up brothers in jail that was innocent. She has had more innocent men in jail than any senator, I believe, in the history of California, in recent history or something of that nature. I'm telling you. See, I just said it. I live in California. She sent innocent black men all the time. Okay. This lawyer here has this nasty, mean-spirited tone in her voice. And with her just saying this to him, he like, yes, ma'am. And with her, it just seemed like she find joy in that. She is mean-spirited, man. I mean, I can feel it just off her voice. I don't know. I'm sorry. I'm a little bit, I don't know what I can hear it. I feel it here. It's crazy.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
Which means that the state will recommend to the court the following sentence.
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on
I appreciate that time. Thank you so much for
although
that.
you are
I
pleading
received that.
guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of Section 3 Special Conditions of Sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30.
Dude. I just think she found joy in that, man. Okay, plea details. Here we go. Sledge must testify truthfully at Young Third trial and gives up the right to take the fifth. Okay, I knew this was what this was. Okay, God, good. I'm glad we're actually talking about this. Man, if I could drop myself down and so we can all see it together. Here we go. So that's why he's on the witness list, of course. Sledge must testify truthfully at Young Thug trial and gives up the right to take the fifth. If he abides by all provisions, the state is recommending 15 years probation on the racketeering charge and will nulla pro, which basically drop the charge, possession of firearm. Okay, so that's what that was. All right, so that's what that was. So he took the plea deal to testify. He can't utilize his Fifth Amendment right. Golly. He's going to, and if he violates, if he abides by everything, he will get 15 years probation on racketeering charge, man, and will drop the firearm charge. So exactly, Lisa. This is what I'm saying. Has to testify truthfully, but Love doesn't know what he's going to testify to enough to provide Brady material. Sounds pretty sus to me too. No, he's not in custody. I don't think he's in custody. Everything is incumbent upon his of his testimony. so I don't think he has I don't think he's in jail at all. I don't think he's I think that's how he got out, is because he took the plea. And so because he says it, Sledge, this is the plea deal. This is the details right here. He must testify truthfully at the trial and give up the right for the fifth. Take the fifth. He got to give it up. If he abides by all these things, the state is recommending 15 years probation. That's it. And they're going to drop the charge of possession of firearm. Okay, so right now he's out. Right now, I mean, because again, he is another key witness in this whole thing as well. This is interesting that we finding out more about him, because obviously he is another key witness, but he has to give up his Fifth Amendment, and he has to testify truthfully. He'll get 15 years probation. That's crazy. 15 years probation. Let's see what this one say. Let's see what this one says.
The special conditions of the sentence, as outlined in Section 3, are that defendants shall abide in full by each and all of the terms of this negotiated agreement. Defendants' failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment.
Oh, okay. So, that's what Max Shard is talking about. Max Shard is talking about the fact that at this coffee shop, whatever his statements were that he gave to the state at this coffee shop was something totally different. what he said at the coffee shop was the actual exculpatory Brady material. But what he gave to the state was what he was supposed to do. They wanted him to give him, so that way they can put Lock Thug up. Whoa. Whoa, man. Whoa. That's what I'm saying. So that's the impeachment part. So if the defense finds out that Antonio Sledge impeached himself then that means that this is Brady. This is so nasty, yo. I'm actually glad we talk about this right now. I know we going over, I mean, we got 8 hours in, and I appreciate everybody rocking with me for the last 8 hours, man. I appreciate time with the positivity about our health is our true wealth, and that's facts. And we're always gonna stay balanced, and life is focused. It's fact. I enjoy this message. I receive this, dude, or ma'am, or sir, wherever you are. I appreciate it. Thank you so much for letting us know this. Yo, this is nasty work, dog. This is nasty work, man. Dog. So this is what Max Shard is talking about. There is potentially at the coffee shop meeting, which has not been recorded, no notes, no nothing. This coffee shop meeting has Brady. That means that whatever he gave the state, like they always say, the state, like, if you tell us that he did it, we'll do this for you. Look, if you say that Thug did this, and the third, then we'll give you this, and this. We'll do this for you. But you got to say the truth, and you got to say this. So you got to put this in a statement, and you got to say this. And when you say whatever the statement is, thank you, another coerced plea deal. Didn't I just talk about prosecutorial misconduct, man? Oh my God. I'm so glad I made that video. Because this is coercion. Allegedly. I'm gonna be fair. I'm gonna be objective. Allegedly. Allegedly, okay? This is absolutely insane. So if you know that this young man was not telling you the truth when he made statements to you, and I'm talking about the state now. The state, he told you some things, and y'all said that he got to say whatever it is that he made them statements with, but the real deal is the fact that he got some other information and you did not give it to the defense. This is the automatic case dismissal. It has to be. This is a coercive plea deal. Do you think the lawyer told Sharp? Oh, snap. Yo, I'm like, oh, snap. I'm curious now, dog. I'm curious now, player. Oh, snap, man. You think the lawyer told Sharp on the low, like, hey, man, hey, cuckoo. You know what I'm saying? Oh, my goodness.
Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the
Oh, he got to go. Okay. That's what he got to go to drug rehabilitation though. And within 30 days, if he tests positive for the random drug screening. But if he lie, you go give him 50, you go give him 20 years. You want that? Yo, you want that? You want this testimony? You want this perjury lie testimony so bad in your case because you don't have a case. You don't have a case at all. You want it so bad. If he violate the drug part of the deal, he got to go to rehabilitation. I've been on probation before. Okay, I've been on probation before. Really? But he actually had a firearm. He did all this conspiracy. But if he dropped dirty, he got to go to rehabilitation. But I don't want him in jail because he can't testify in jail. I need him out here. Oh my God. Time says, Tay Biz, I just locked in, sir. Hit the like button. It's definitely free of charge and share the live. I did. I appreciate it, man. Thank you. Appreciate it. Yo. This is absolutely crazy, man. Oh, we talking about Antonio. For those of you that's coming in or lurking or whatever you're doing, we're talking about Antonio Sledge's plea deal and how it relates to what we just saw in court today when Max Shard said there was a coffee shop conversation that has potential Brady evidence. Yo, man, this is crazy.
Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
Man, every time he say yes, ma'am, I don't want to scream, man. They made this man sign this. I'm getting hot. I promise you, I'm getting hot right now. I'm trying to relax. Right now. Let me just go ahead and play this because I need to relax for a minute. I'm getting very hot right now. This is crazy.
Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above.
What the caption say here? It says here, co-defendant Antonio Sledge will testify to and has signed statements about Young Thug and others' knowledge and or participation in murders, drive-by shootings, gang activity, drug sales, and more. The way they did this is so nasty, man. More details of the Young Thug co-defendant Antonio Sledge's plea deal. After the murder of Donovan Thomas Jr., YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave them case money to lay low. No, okay. So now we're talking about the Miami situation. We're talking about the fact that everybody went to Miami and all this kind of stuff, or they had some money to get away. And Woody did say something about on the stand. He did mention about going to Miami. I remember that. Them guys really did not understand what they were signing, just to try to have time out of jail. Exactly. They didn't want to go to jail, but now you can't invoke your Fifth Amendment right. You can't invoke your Fifth Amendment right. So okay. So I'm seeing something. I'm thinking here that Woody's testimony is trash. All right, let's just keep it a bean. And we don't know if Woody is going to testify on Monday. He said it depends on how I wake up. That's what he said. All right, it depends on how I wake up Monday morning, and I'll let you know. So there, literally, this whole thing rests upon if he's going to testify or not. Will Woody testify? I'm gonna be honest with you. I don't know. They remember he was in court. What was that? Was that Tuesday when they got in court? That's when Caleb Bumper took the stand and Woody took. I think that's the same day Woody took the stand, or Woody took the stand the day after that, I believe. And the judge said, "Okay, you have until Monday," which was yesterday, I believe. That's what he said. You have until Monday to let us know if you're gonna testify. He said, "I'll let you know when I wake up." I don't know if he's going to testify. I can't say for sure if he will or not. However, he did say certain things, and there was a thing that he said something, but he gave us some information about something. But one of the things he did mention was about going to Miami and all that kind of stuff. So this is very interesting that now with Woody being so compromised to the point where they have to utilize his interrogation videos because they can't rely on his prior inconsistent statements. And again, Bruce Harvey is trying to get the judge to understand that if you're going to have the jury come in on Monday, you're going to have to instruct them that the prior inconsistent statements of this particular witness is because they're not credible. They're not a credible witness. So whatever they said, it can't be used as evidence against my client because he's not credible, which makes sense. So you're going to have to piece out that testimony. Some of that you're gonna eat the fish, spit out the bones. You got some of that is going to be, some of that is good information, some of it is not. Like the information about Miami was important. As you can see, it's been alleged that Young Thug told them to lay low. He gave them some money. Okay, we can use something like that. You're going to have to extract some of the things you can use, some things you can't use. But man, it's so muddy that it makes no sense. And then on top of that, not only is the fact that the muddiness is within the defense a little bit when it comes to the activities of what's going on and who got involved, but the real muddiness is on the prosecution and how they are coercing people with plea deals and taking away their time. They're taking away their right in replacement, their right to speak and replace or not speak in replacement of their time. So I'm not going to lock you up, but you can't be silent either. So you're going to have to pick and choose. Because if you decide to go this route and lie on the stand or don't provide the necessary testimony that I want you to testify about, that I want you to give, then we're going to lock you up. And we're going to lock you up for a long time. We might just give you the maximum of 20 years for RICO. You know, when you hear things, man, when you hear certain things, it's like, yo, this is where it gets real dirty. And I think that Fonnie Willis, I believe her attitude is like, we're going to get this gang crime at all costs. So sometimes you got to fight dirty, you got to get dirty and fight dirty when you got other people that's dirty. And that's her approach. Her approach is, okay, since you dirty, I'm gonna get dirty with you and I'm gonna out dirty you. Fonnie, that's her game. I'm gonna out dirty you. And what's happening is it got caught. Look, when she gave Nathan Wade 700,000 a year, right? And she paid cash on these trips and she doing some dirty stuff. She's gonna out dirty you. And that's her. It seems like that's her thing. And it seems like that's the atmosphere in the DA's office in general. Is that they all get dirty. And she found her a culprit. She found her a culprit that don't mind getting dirty. And that's Miss Love. There is nothing that Miss Love has done truthful in this case. She has done everything she can to show that she has absolute immunity. You can't do nothing to me, and I wish you would. That lady right there. She is dirty, evil, very evil lady, man. I'm gonna play this last clip of her, and let's see what's up with the rest of this plea deal.
Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number 12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge.
Hold on 1
you had
second.
an opportunity to
Hold on 1 second. Let's go back a little bit.
or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession. Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL.
To increase the notoriety and reputation of YSL. That's what Miss Hilton last week was trying to say that Woody was doing, and the judge said no, he's just trying to promote himself. So they're also utilizing the fact that notarizing YSL by publication and doing all that kind of stuff and throwing up the signs or whatever is a part of the reason why it has a lot to do with the conspiracy aspect of RICO. I'm exhausted. I can't believe this, man. Oh my goodness. This is great. I'm glad we actually looked at this because I can't remember who said it in the chat, but Antonio Sledge's plea deal has some very intricate details, which is what she was listing. the statements that pretty much was being made that he made. And then all of a sudden, Max Sharp gets up and said, hold on, Judge, we do have some more information that has potential Brady material where Antonio Sledge is now at a coffee shop alone with his lawyer and a lieutenant and Miss Adrian Love. And Miss Adrian Love did not take any notes, or if she did take some notes, she don't think she need to give them up. But if they have Brady evidence on them, she does. The investigator or lieutenant took notes, I guess, allegedly, maybe not. So the lawyer of Antonio Sledge is the only one that has credibility in that whole situation right there. So Max Sharp was like, she was asking, well, do you know? He's like, I don't know. He was being technical. He's like, I don't know. Hinting at the fact that, but I have something, you know, like, I don't know exactly, but I have something, but I'm not going to share what I got. I'm gonna see what she got. I'm gonna let her play her hand first. And of course she acted dumbfounded and lost and all, like she don't know what to do and all this kind of stuff, like she always does. So I am super wow, I can't wait till Monday. This is about to be crazy. Monday is about, everybody put Monday in the chat. This is about to be crazy Monday. Monday is about to be absolutely crazy. Then let me go ahead and see what's up here, man, with the chat. Y'all been doing some excellent chatting. I appreciate it, man. I appreciate the chat so much. Lisa said that video just gives me chills hearing how much she's enjoying getting to exercise that power over someone. Exactly. Like it's just absolutely crazy that this is even a thing, man. Oh my God. Tay Biz, Fonnie Willis was a defense attorney, and guess who she defended? No other than the leader of YSL Mondo. All facts, and Fonnie Willis is close to Nuts family. Okay, so I heard that Fonnie Willis has some type of attachment to the Nuts family. So wait. So Tom, let me ask you a question real quick, Tom. Do you think this is like some type of like revenge thing with Fonnie Willis and YSL? Or what? I don't know, man. That's that look, stranger things have happened. If that's true, that could be. That's it. Nothing is impossible at this point. Nothing's impossible at this point. Okay. Robin Johnson, thank you so much for coming into the Biz Nation chat. I appreciate you. She just admitted the real RICO. RICO is occurring at the DA's office in Fulton County's. I don't know what that's supposed to be. Freedom of mendacity, I think. Is that what you're trying to say? I'm not sure. But yes, she just admitted the real RICO is in the DA's office for sure. Absolutely. Robin Johnson, thank you so much for stopping into the Biz Nation chat and saying what's up to us. We appreciate you. So this is crazy, man. So this is crazy. I think that Monday is going to be absolutely insane. We've been rocking out you guys for 8 hours and almost 40 some odd minutes. So I definitely want to say I appreciate you all so much. And those of you that may be watching later on or whatever, go ahead, hit the comments. Let us know what you think about this whole thing. If you're a stream watcher and you like to see all streams, then that's what's up. I had somebody comment the other day on one of our streams that we did, one of our 8-hour streams. They was watching it and they time stamped like 3 hours and 45 minutes. I was like, you was watching me for 3 hours and 45 minutes? I'm like, okay, I appreciate you. You know what I'm saying? I appreciate you. Thank you. So I appreciate that. So in the meantime, in between time, we're going to go ahead and chill and relax and enjoy the rest of your day. This is Friday Eve. So everybody be safe. Everybody be kind. Love your family. Love yourself. Love God. Love each other. Also, like, share, subscribe to the channel. I'm definitely about to go ahead and take a break. I've been at this since 8 something in the morning. And so, this is definitely very interesting. So I appreciate you. I appreciate everyone. No problem at all. No problem at all. It's my pleasure. It's my pleasure doing these 8 hours in. I'm telling you, we about to get it pop. Something's great about to happen. Something's gonna break. Some justice is gonna have to come out somehow, at some point. You know what I'm saying? Because the truth is that prosecutors can't keep doing this, man, and they can't keep coercing people with these plea deals, and that's what they do. I'm telling you, that is what they do. Now I know, like I said, with me, the first thing they did was, hey, plea deal. I'm like, let me negotiate a little bit. You know what I'm saying? So too much power on the prosecutorial side. So, but until then, I am going to go ahead and call it a night. You all have a great evening. Get you something to eat, get you something to relax to. You know what I'm saying? Hey, it's your boy Tay Biz. I'm out. Thank you all so much. I love you, chat. Thank you so much. Peace.
Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we hate. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. Cause my young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With the boy, I'm so ashamed. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that Henny fluid. Young middle Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that Lily before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty thick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there. Around through that